Good morning, everyone, and welcome to Uncivil Law. I hope you're having a great day. We are tuning in for Verdict Watch. It's exciting and fun for the whole family. The jury has been deliberating now just under 2 hours between yesterday and today. Very exciting. And we are going to see how this all turns out. It's going to be interesting, I'm sure. We'll discuss issues relating to the case. As you have questions, we can discuss issues relating to the lesser included. We can discuss issues relating to appeal. We can talk about some of those things intelligently. We can talk about, we're going to watch the interview that Turtle Boy did with another juror here, probably to start. And then we're going to watch some Supreme Court stuff, or read some Supreme Court cases, because that sounds like fun. And we'll kind of go from there. So all those good things. You have all the questions? Well, hopefully I have all the answers. Although probably not, but we'll do what we can. We do what we can. Let's see what we're going to be doing here. Try to get everything. Yeah, thank you. I enjoyed being on Melanie's channel on Friday. That was fun. We might pop on her channel for a little bit today too. So that could be fun. Black hole theory. The black hole theory explains many things, man. The black hole theory is underappreciated. Yeah. I'm glad you like it. It entertains me too. We laugh so we don't cry. That's what we do. We laugh so we don't cry. Yeah, man. Good morning, Team Brittany. How you doing? Good to have you here as always. Now, Turtle Boy, I think, did an interview with another juror, and so I was trying to figure out where that interview was. Is it on his website or on his YouTube? I don't see it, but he did another juror interview, did he not? It wasn't one. Maybe it's a live. Maybe that's why I can't find it. Yep. Juror number 3 from the first trial. That's what I'm looking for. Great. We're going to start with that. Excellent.
Juror number 3.
All right, cool. Excellent. Very good. All right, so let's go ahead and start with watching this interview. We'll see what's going on. Why don't we do a poll on how long the jury will deliberate? My mod could set that up. I'd appreciate it. We can do a little poll on how long the jury will deliberate. That'd be fun. All right, let's see. Too many things on too many windows. Let's see. All right. All right. We're going to watch this little interview that Turtle Boy did with juror number 3 from the first trial, who did not, and we're going to listen to what this person had to say, and we'll go from there. All right.
That's what we're going to call
I need to change the audio source so I can hear it and you can too. Okay.
All right. Hello, is this juror number 3?
Hi.
How are you?
I thought I was your favorite juror. Why did you say that this group is better? I don't get it.
Well, your jury didn't acquit Karen Reed, so, you know.
Well, that's, yeah.
I know it's not your fault, but yeah, so you, I commented a lot when I watched you. We looked at each other for like 10 weeks there.
Yeah.
2024. We stared at each other, and I made a lot of comments about you on my Twitter account about your behavior because it was really, I don't know what the right word is, obvious. It was really like, I knew what you were thinking, which is ultimately why I think you were ultimately removed.
Someone needs to tell Law and Crime that unless something has changed that I'm unaware of, there's only 60 minutes in an hour. Law and Crime. Hold on. All right, I have now chastised Law and Crime to fix their clock. What kind of a day are we having, man? It's too early for this.
Is because I knew what you were thinking. And so what were your tell me your thoughts on the first trial as a juror. What was that like?
There's so many that it's so hard to actually put them into like a coherent sentence. I mean, sitting there for how many weeks? 10, was it?
Yeah, it was 31 days, just like this trial was 31 days.
Well, it felt like it was like 3 months though, with all the breaks and the days off.
Yes, there was
the pool days that we had to have.
Yes, 100%.
I mean, it was just kind of wild to sit there and listen day after day and just have to come back the next day because I'm like, why am I here? Like, why are any of us here?
Is it true that you wrote in your notebook something like they're all liars? Did you write anything like that in your notebook?
So yes, I don't remember what my exact words were, but as I was going through and like writing notes about people, I would write whether I believed them or not. So like telling the truth, liar. Yeah.
And so who looked at the notebooks every night? Do you have any idea who actually looked at those notebooks? Do you think anyone in the DA's office looked at those notebooks? Anything like that?
I don't know. I mean, there's a lot of speculation. Do I know for sure anything? No. Did I ever pay attention to the placement of my notebook? No.
Mm-hmm.
Did I think at that time it was a problem that anyone would read my note? No. So
you made visible faces, particularly during Michael Proctor's testimony.
So I've heard.
You couldn't, you just looked disgusted.
I wish someone had videotaped me. I would have loved to see it back.
Well, maybe John DePietro did. I don't know. He seems to be doing some shady shit there. But, you were making faces that you just couldn't hold it in. You were 2 seats away from where he was sitting, and
Right.
You just looked 3 seats. Right. And you just looked disgusted by him. Like, I remember you like looking, like opening your mouth, like, oh my God, like putting your head back, like, oh my God. And so did Victoria George, who is sitting directly behind you.
Yeah.
And you guys, it seemed like you guys became like friends during the trial. Like you guys were talking, and I assume not about the trial, right?
At that time, no.
Yeah. But
No.
you could tell you were on the same page, right?
We didn't know until after the fact.
Mm-hmm.
I mean, you think that you know, but clearly I was wrong about a lot of other people. So
yeah.
you never really know until until it all kind of shakes out.
Yeah.
But we know. I mean, yeah.
Let's talk about that.
But we know after now.
So the jury, when you were deliberating, or you not deliberating, so you didn't deliberate with them, but when you were going there every day, I mean, it looked like a smart jury. I said a million times, I thought that they were going to acquit her very quickly. I didn't think Ryan Piotrowski was a problem. I thought that like those two guys in the front row, the Asian guy and the engineer, John there, who was also an older guy, both of them had PhDs. They looked smart. And I'm like, those guys are not guilty all the way. As it turns out, all three of those men were guilty voters. Does that surprise you that the people that you surrounded yourself with for over 2 months could be this stupid?
So, I mean, I think I said this from day one of like the mistrial, that people were either going to believe in the conspiracy and believe that all of this shit was just crazy, or you were not going to believe it. And if you didn't, technically the evidence was there, right? I mean, the taillight was on the ground.
Or just another option, which is on the table. You can simply believe the state didn't prove it. See, this is the thing, right? It's like, this is the problem with jurors don't understand the assignment. We spend all this time telling them the assignment and they don't understand, right? It's like either you believe a conspiracy or you believe the evidence was there the whole time. It's like, well, or you just believe that the state failed to prove each and every element of the crime. Like, you don't necessarily have to believe the conspiracy. You just believe that they didn't prove every element of the crime. It's like, so I mean, but this is the problem. We can't get people to understand the assignment, man. I swear.
Right. The taillight is broken.
Mm-hmm.
So, I mean, if you didn't believe in all of the other crap that they brought in that was so unbelievably crazy that I don't know, like, how you could take anybody seriously as they were talking. But if you truly tuned that out, I don't want to use the word distractors because I don't want to get yelled at. But if you truly tuned all that out, then...
Please don't use the word distractors. Yeah, they're just distractors. They're just distractors. Yes, if you tuned all that out, in other words, yes. But this is the thing, right? And this is the problem. This is one of the things when I keep like trying to assess like the odds of conviction. And I'm like, yeah, 20% sounds about right. It's like, yeah, it's like the jury gets to decide how much to believe something, and they also get to decide how much weight to give it. So basically, they can weigh it out of existence, essentially, right? Because they get that power. So, yeah, it's like if you don't really buy any of those things, if you tune it all out, then that gets you a long way towards a conviction. Yep. On that first trial, though, it's like you have to tune a lot out, though. You don't have to do as many mental gymnastics this time, right? The biggest problem is the causality of the injury. Like, because even if the collision happened that led to the injuries that caused death is the biggest problem logically from a purely analytical frame. So if you're doing this in an analytical way, that's the hardest problem to solve. But it's at least it's not as much as the problems you had first time. So that first jury, how they managed to hand wave all those things away, man. I don't know, man. Makes you re-wonder about our entire system of justice. Makes you question about what the reasonable man is. Like, who is the reasonable man? The man of average, ordinary prudence. Who is the average man? Right? This ordinary person. Who is they? And it's like, oh, maybe the ordinary man is an idiot. Maybe the ordinary man's a moron. It gives you pause into our entire system of justice, and also just who is the average person. Like, do we really want to have a democracy? Democracy is ruled by people. Have you met people? I don't know, ma'am. That democracy thing isn't looking so good right about now. Maybe we need to figure out something else. Yeah.
Yeah, technically, I guess it was there. And that was, how people were so stupid because they don't like see reality of the world, I guess. I don't know. I mean, I don't know if that.
I just don't understand how anyone could listen. Your reactions to Trooper Paul were the other ones but that's the one I don't understand. Okay, Proctor, whatever, but like to vote guilty for manslaughter, these people had to believe the word of Trooper Paul over the ARCA experts.
A little bit.
How could any smart person reach that conclusion?
See, that's the problem, Turtle Boy. That's the problem. Facts, not in evidence, relies on an unestablished premise. How could any smart person, you say? Yeah.
Trooper Paul is more qualified than them.
I don't know. I mean, I guess I'm not a smart person because I thought he was a clown, and he was the entertainment of the day. Yeah. So, I mean, I don't know.
What did you think of Alan Jackson and Adam Lally?
I don't care about the weather. I don't care about table setups. I don't care about drink counting. I was done with it by like day 3, and it went on for 32 more days or however many. He just, it just was difficult to stay focused and to listen because it was just like dun 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 dun. And I mean, I think every time AJ got up, he just dominates a room, right? I mean, he's got a personality. He just dominates the room, right? So, I mean, it's just very easy to listen to him, and it's very it's very easy to be interested in what he's saying because he's charismatic.
He is.
We hit 150,000?
You listen to.
Oh, we hit 150,000 subs when I wasn't watching? Oh, let me just double check the back end. Hold on. Not that I don't believe Tony, but I want to look for myself for my own validation. Sorry. Please talk amongst yourselves for a second. And we did hit 150,000. We hit 150,003. Excellent. We hit 150,000 by the end of trial. Very, very good. That means we need to do a giveaway of some kind. So we'll ponder what that is. My 2 ideas here is we can do a merch giveaway of $150. That's option number 1 I've considered. Option number 2 is we could do like 8 items of $20 each. And for the purposes of this exercise, 8 times 20 is 150. And if you correct me, then no one gets any candy. So that's option number 2. And I'm open to other options, but let us figure out what we want to do here, and we'll do one of those things. So let me know if you have other ideas of what we could do. Those are my 2 ideas. A merch giveaway of $150 or 8 of 20, or I'm open to other suggestions. Let me know.
You're like, oh, all right, what are you going to say next?
Now, have you reached out to the defense at all? Can you comment on that?
I have spoken to them, yes.
What did you guys talk about?
That I'm not going to say, but I have spoken to them, and I've given them my opinions on a few things.
On jury selection or on strategy, on things that worked well and things that didn't work well?
A little bit of all of it.
Okay. So let's talk about that. So you messaged me.
$150 knife giveaway? Well, I wouldn't know how to do a knife giveaway. I don't believe knives are sold through the store. And so short of me giving you an Amazon gift card, which I guess I could do, I could buy you an Amazon gift card of $150, but that doesn't feel like fun. That doesn't feel fun. Yeah. No, I don't like this idea. I want to be something that's, channel appropriate, or yeah, I could give you a $150 Amazon gift card, but is that fun? That doesn't feel fun. It's like giving someone cash for Christmas. It's like you've run out of other ideas. I don't know, man. Yeah. I don't know about the knife giveaway thing. But thank you for the congratulations. A watch. I could buy you a watch for $150. Your choice of watch up to $150. That could be an interesting idea.
Like this kind of doom and gloom message maybe 2 weeks ago. Can I read it?
If I ever finish I will finish the watch that I was building and send you the watch I was building. The watch that I built, I could send you that one. I still have to fix the stem, but that should be relatively easy. So I could send you that for the merch giveaway. That'd be interesting. So you win the watch that I've been building this entire time. The one that you've seen before. We could show it again on camera, assuming it works. Otherwise, we might have to do something else. Maybe we could do that.
Which one is it?
About your thoughts, the one where you were like worried.
Oh yeah.
About how things.
Oh, the one when I ruined your day and your week. Yeah.
Did I say that? Did
no,
I say?
but
Yeah. Well, it was a real downer. It was like, okay. Let's see.
Oh, it was right after.
This is May 29th.
Welcher.
You sent me this. You said, unpopular opinion, but I watched as me, the juror, who knows nothing about what I see in court. Welcher came across as credible, knowledgeable, and that he was trying to answer Alessi's questions as best he could. He seemed that he really wanted to give complete answers, but the questions were narrow and he couldn't give an expert opinion based on the question's lack of substance. Alessi came off as argumentative, and I would have been very frustrated sitting there for 1.5 days listening to him and trying to follow his questions. The clips were bad, especially the last one. This is why a jury should scare the fuck out of everyone. And I said, you think so? And you said, I wouldn't be as solid at this point like I was last time. I think I'd probably be leaning Commonwealth, which is bullshit. So, yeah, I mean, let's talk about that. So this is
well, I sort of agree with the juror. This is a juror reflecting on the watching the new trial, trying to put themselves like in a lens where they don't know anything from the first trial, right? So they're trying to put themselves in the shoes of the new jury, right? So they're trying to forget what they know and only keep in mind what the new jury knows, which is perfectly right. That's what they should do, right? And this juror comments that they found Welcher to be credible, which I think is something that a person could believe. And also, like other things in this state's case, were much better presented, right? We've discussed this before, right? So there are a lot more ways to get an intellectually satisfying guilty verdict than there were in the first trial. In the first trial, trying to get to an intellectually honest guilty verdict in the first trial is a much, much harder assignment because you have to like discount a lot to get there, right? I mean, the jury is entitled to like sort of any reasonable combination of the evidence, right? They're entitled to that middle 95% of like all the possible options, right? All possible ways to weigh the evidence, all possible ways to trust the evidence. The jury is entitled to sort of that middle 95%. They're entitled to a lot of latitude. So they're entitled to a lot of combinations. But in that first trial, man, I don't know that you can do it. And that's incidentally why, like, as a judge, I would have like thought really, really hard about a directed verdict in that first trial. Right? I'm not saying I would have done it because it's basically the same question, right? A directed verdict for not guilty is basically the same thing. No reasonable jury can convict. So like, is there any way for them to do it? And in that first trial, I'm like, I don't know, ma'am. I don't know. In the second trial, there's a lot more intellectually interesting ways to get there. So I sort of agree with juror number 3. It's like, yeah, it's like, and of course, the government goes first. And if, a juror was convinced by it, and made up their mind and, because of primacy, they sort of bought into a story and, thought of everything else as distractors, there's definitely, 20% to convict seems like a very reasonable probability. When we remember what juries are and how they work and stuff, and it might be even an underestimate. But yeah, those are all issues.
A completely different trial, right?
Yeah.
Now a lot's changed since May 29th. Okay.
Yeah.
So like she has put on a defense since then, and it has been an outstanding defense. But this was like right after Welcher's testimony, and there was no Proctor, no Higgins, none of the usual stuff, right?
Yeah.
Because I think you said in a later message to me, you said I wouldn't.
Didn't I set these on auto delete? No. All right, I gotta.
No, we
update
used
that.
to have it. Yeah, but basically you said to me at one point that that what sold it for you were the McAlbert. Like how we're saying they're not doing the McAlberts and Proctor this time, and you were like, but that's what sold me. Do you?
Oh, yes.
That's what sold you last time, the McAlberts and Proctor.
Yep, 100%.
How come?
I mean, because how many times can you butt dial somebody in a night? How many times can you throw your phone away at an army base, SIM card in one dumpster, phone in another? I mean, just the whole thing. How do you not get out of bed when there's 43 fire trucks and people screaming on your lawn? How does your dog not bark? I mean, none of it made any sense. And it was just to the point, it was so ridiculous. Like, why do you drop donuts off in a blizzard? Right? None of that makes any sense. It was all so ridiculous.
Right.
That by the time we got to all of the other stuff, I was just kind of like, I can't even take any of this seriously at this point. There was two people that could have changed my mind. It would have been medical examiner and Trooper Paul. And Scorty Bello said, it's not consistent with being hit by a car, the injuries, and Trooper Paul did pirouettes. So, there we go. It's a very different trial this time, though. There is none of that nonsense that you're just sitting there like, this is a friggin' circus.
Well, it's a very calculated risk, and it sucks that they have to make this choice. They have to make the choice between, do we go the McAlbert route and which is the conspiracy route and tell this sexy story that has ultimately gotten the attention that got us here in the first place, right? Because that's the really interesting part about this. That's the Hollywood part about it, is that these people framed someone for murder and they're all lying and they're all pieces of shit and it's like a fucking movie, right?
Yeah.
But the problem with movies aren't real. And
exactly.
So like people have a tough time believing that. And now you believed something was up with these people, but like for others, that was a tougher sell. So this time the defense has gone with a different strategy, and that is focusing. There was no collision. That's all this defense is in, just a few words. There was no collision, and everything else after that, they're not even getting into. What? Now, you sent this message 2 weeks ago.
Yep.
Do you still feel that way?
No, not even close. The defense, the witnesses they put on, they basically just brought person after person after person that unequivocally said there was no collision. So what I'm not a lawyer. I don't know what trial strategy is. And what's going to hit for everybody. Right. But not having all of that other stuff, I think is probably the smarter way to go now. Right. Because that stuff was not really taken into consideration, it sounds like, last time around. So I think it's more solid this time of the reasonable doubt. And it's just up the middle, right? It's like there was no collision, full stop. We're not going to bring in anything else, but that's what we're going to prove to you. And they've done that, witness after witness after witness.
So when you said that to me, you were saying that out of like concern and worry, right?
Yes.
Like a worried parent, like that.
Yes.
Because you even said, you're like, can I'm thinking about calling Karen and telling her this.
I was very much
like,
considering calling her.
And I'm like, yeah, don't do that. Yeah. Because, and I think you spoke for a lot of people when you said that, when I read that, because part of me was feeling that. Like, I didn't, think, I'm like, oh no, because there's no do-overs if this doesn't go the right way. If this ends in conviction, which I don't even hate saying that, but like, if it did, you don't get to do it over. So you have to get it right the first time. You have to. And you're like, oh, it is such a gamble. It is such a gamble not calling these people.
Yeah. And I've been trying to like watch this, and admittedly, I've not watched every testimony beginning to end, because it turns out when the Commonwealth is not paying me $50 a day to be there, I don't have as much time as I did the first time. But I was trying to watch it from like a juror eyes. I was trying to put myself back in that chair and being like, I don't know other than what they're telling me. Right. And that's where I started getting concerned, because the things that, and I can see, what's going on Twitter and all the things that we all are focusing on about, man Shannon lied on his resume or whatever, right? But those aren't the things that like will likely stick with the jury at the end. Those will be the things that it's like, yeah, okay, the guy's a loser, but maybe he just didn't want to admit that he didn't have his degree. So, but he has 15 years of experience. I'm making this up. I don't remember how much, but like, so he could still be credible, right? So that's how I was trying to look at it as a juror.
He could be. That's fair.
Having all of the
you don't need a degree.
That makes sense.
It's true.
And that's where I started getting worried and nervous, honestly, because I mean, it's a very different case. I think the defense has a stronger case this time, but I think the Commonwealth showed less of the shenanigans, I guess. I don't know what else to call it, and more of the clips, the this, the that. Like I don't know if people are picking up on the FBI. I'm telling you, I would not.
Yeah, let's talk about that. So you had no idea about the FBI, despite the couple. But it's right, Ryan Nagel actually saying FBI and. You had no idea what this other. What did you think all these other hearings were that they kept talking about and other long? No clue. I had
absolutely no clue. I thought it was like I don't know, like a meeting last week. I had no idea.
Yeah, because
it never occurred to me that. I mean, I guess I just figured it was like a grand jury from like a week before. I had no clue, like none.
I'm with you.
But I don't know anything about. I don't know anything about the legal system, so I have no idea.
That's what I'm saying. Like, and even I said this before, and I'm like, even if this jury does know the FBI was involved, I don't think they understand the gravity of what that means. I think they'll like a lot of some people get charged in federal court and in state court. For all they know, the FBI was investigating Karen Reed. Like if you mention, oh, the FBI is involved, it's like the FBI hired me to investigate Karen Reed. Like to, you know what I mean? Like, so like, or to who the fuck, nobody would ever guess that like they're investigating the investigation itself. Like that's fucking crazy world.
I would have never picked that up. Never.
Yeah.
Never.
But Hank played it off.
I missed the slip of the FBI. And honestly, I think if I had heard it, I don't know that I would have put two and two together and connected it. I really don't think I would have.
Sure. No, I didn't think the trial was actually going to fucking happen. The first trial, I'm like, after the 2E report came out and all this FBI stuff came out, I still can't believe that after getting that 3,000-page report, which was what was in that report, all the text messages, right, the butt dials, the destruction of the cell phones, right, the Proctor texts, the and of course the ARCA report was all in there, and any ethical prosecutor looks at that and they're like, whoa, let's hold on here. Let's reevaluate. Let's take a deep breath. Do we really want to go forward with this? Is this ethical to go forward with this? But like, like Betterow always says, it's just like, well, time to make the donuts, like back to work tomorrow. It's like nothing happened at all. They just went right forward and they're like, you know what? We got the judge, we got the judge. We're good. Like we don't have to worry about like this trial is going to be in favor of. Let's talk about that actually. What did you think of Auntie Bev as a juror?
So again, at the time, I knew nothing but what I saw. She seemed like she was kind to us, right? I mean, like in the sense that she would like give us breaks if we had to pee. I mean, literally, these are like bottom bare minimum things looking back, right? But at the time, I was no smarter to know anything else, right? I mean, I would notice when she'd be like, I'll let them have it. That would drive me crazy when someone would object. And I never knew what the objections were about. I had no clue. I was like, was that mean? Or I don't know.
Do you wish you knew? Do you wish you knew? Would that have helped?
I don't know, because even if I did know, I don't know that I would have known what it meant.
Okay.
I mean,
why didn't you like the I'll allow it? What bothered you about that?
Because when the defense would object, so if it was this way, so hold on, let me just think for a second. So it was when the defense was crossing and when Lally would object and she'd say, I'll let them have this one. Drove me crazy. Like, why are you letting them have it? Like either it's fair and proper or it's not. So I didn't love that.
It kind of sounds like she's doing them a favor. Like,
Yeah.
We'll
Yeah.
allow it. It's like, no, you're not allowing it. You have to. Like, it's the rule. Like, that's what's just is, they're right. That's another way of saying they're right. So I will allow it. Like, you're not allowing it. The law is allowing it, isn't it?
Yeah. So the way she would say it is like, I'll let them have this one. Seemed like she was doing them a favor. That's exactly how I would say it. And I did not say it that way.
Like, it was almost like begrudgingly. Yeah, allow it.
Like, I'll throw them a bone on this one.
Yeah, right.
I'll I won't let them have the next three. But
did she seem biased towards the prosecution as a juror?
she seemed biased towards the defense.
Towards the defense, like, you mean against the defense?
Yeah, no. Sorry. Yes, I'm mixing them up. Sorry.
Yeah.
It's been a long day. Seemed like she was it seemed like she was with the Commonwealth and against the defense.
Right. Okay. So you picked up on that as a juror. That seemed like she was giving them hometown calls and hometown cooking.
I mean, in some places, yes. In some places, no. Because some places it was just so obvious.
Mm-hmm.
With the, I'll let them have it and stuff like that.
Now, do you think
I'm trying to think back at the same time too. So, I mean, I might not be saying all of this the totally right way.
What was that like to be, I mean, every day? So you would go, she warns them every day not to go watch their social media use. I'm sorry. If you have social media, then you're consuming Karen Read content. It's impossible not to. Did you go on social media as a juror, and how could you possibly avoid Karen Read content when you would go on social media?
I went on TikTok, and all it was Taylor Swift because.
Oh, not anymore. TikTok. Karen Read owns TikTok now.
Well, at the time, it was during the Eras tour, so it was just all Taylor. So, and I'm, it's when she added the tortured poets to the set and everything. So that was my TikTok.
But you would like, you're on Twitter now.
Now I am.
Karen Read was impossible to miss on Twitter. So you weren't on Twitter at the time?
No, I've never used Twitter. I think I had an account from like 10 years ago that I had to reset the password 6 times.
Now, what about Facebook? Did you go on Facebook, and was it like there's a lot of Karen Read?
I don't even like Facebook now, so no, not really.
All right. So you didn't have a problem avoiding Karen Read content when you would go home every day?
No.
Okay.
No.
So where would you guys like the bus every day? Like what? So what time? It had to be fucking early. Where you guys met somewhere and got on a school bus every day and parked your cars there and it would just drive you in?
Well, it was like a fancy school bus, but yeah, I mean, that was the gist of it.
Okay. And did you guys become friendly with each other? I mean, there's 17 you at first. Did you like them? Dislike them?
I mean, you don't love everybody that you have to talk to every day. It's like going to work. They're not all your friends, but you tolerate them, right? So
yeah. Speaking of, juror number 5 was eliminated on. She was actually accidentally picked up on camera. That was the day that Jessica Hyde testified, and she had to be on Zoom for that. And she was eliminated. I believe you had something to do with that, didn't you? I mean, did you report her, or were you one of the people that was called up about that?
Yes.
So did she say something to you inappropriate?
There was a comment that was made. Yes.
Are you able to say what that comment was now, or no?
I mean, I'd rather not, because, why drudge up? It wasn't just me, and it wasn't just me who had to go in and talk. So.
Okay. So a couple other jurors also heard this comment?
I don't remember if they heard it, but I know that I was not the only one that talked to the judge. So I guess let's just leave it at that, because I don't want to speak for anybody else or say anything that had anything to do with anybody else.
Okay. Because I think it did have, it was in the motion to dismiss, wasn't it? This whole thing, or am I dreaming?
I'm going to be very honest. I never read that because I was far more hot and bothered that, it was out in open court.
So
talking about me. So
well, she was respectful enough not to say your name at least, so that was good. But
yeah, for like 5 minutes, but
yeah. So let's talk about that. Have you received any sort of threatening emails from anyone, any YouTube content creators?
In general or recently?
In general.
Yes.
Really? Okay. Care to say who they are?
My lawyer has advised me not to.
Okay, not to talk about the threatening emails you received. Okay, so because that's interesting because Ryan Piotrowski, immediately as soon as the trial ended, he cried victim, and he said that, oh, Turtle Boy is going to dox me. Or I don't even know what he said. It ended up, ironically, it ended up being Kevin Lenahan from Plevin from Yellow Cottage Fails, who ended up doxing Ryan Piotrowski first before anyone. And he lied in his, and this is interesting because it involves you, because he said that during deliberations, they could hear Karen Reed supporters outside every day cheering loudly. And that was used to extend the buffer zone like 400 feet or some shit like that. And then you provided an affidavit for Mark Rendaz's lawsuit that ultimately got the buffer zone fixed, didn't you?
I did, yes.
And what was inaccurate about what Ryan said in his affidavit?
Oh, I'd have to pull mine up and look at compare the two. I don't remember specifically.
Well, for one, is it true?
I'm guessing you know though. So
is it true? Is it true that jurors could hear Karen Reed supporters during the breaks and whatnot?
I think that we could hear things from time to time, but it was no more than like normal noise, right? I mean, it was nothing that it was like crazy. No.
So you didn't hear Free Karen Reed or anything like that coming, people chanting that?
No, I never heard chants. I never saw signs. Nobody ever like came near the bus or the back door when we were going in and out. Everybody was very respectful, which is what I put in the affidavit.
Let's talk about how jurors were chosen. So you were picked on the second day, I believe, right?
Oh God, is this a quiz? I don't know.
How do I know more about you than you?
Because I don't know. I guess maybe I blocked some of it out.
So I thought that's what you told me.
Was it the second day?
I thought you told me it was the second day you were picked. And so
I don't remember now.
All right. Well, do you remember what you were asked when you were brought up in during jury deliberations? You filled out your form and then they brought you up and they asked all the jurors, the Lally is standing there with the defense attorneys and the judge. And what did you guys talk about?
I'm trying to remember. They asked me.
I have to say, I find it fairly interesting. I'm not sure what it says about anything, but I find it amusing. There's like 1,500 people watching this stream. This is like one of our most popular streams that we've done for Karen Reed. It's like, this is just funny to me. Like, this is like twice our normal audience, and there's not a lot going on. I don't understand how YouTube works. I don't get it. I don't understand it. Oh, man.
About the news and watching the news. And I said, I watch the news to get the weather. And then Bev said, well, can you get the news from somewhere else? And I said, I suppose I could ask somebody. She said, or you could just look out the window. And I said, I suppose I could do that too.
They asked you if you watched the news?
Yeah.
And they don't want you watching the news. Okay.
I don't know.
Okay. What else they ask? Did they ask if you had family in law enforcement or anything like that? Or
that was on the questionnaire, yes.
And do you?
No.
Okay. And did they ask you like if you blindly if you trust police or anything like that? How'd you respond to that?
Yeah. So actually, I looked at this.
Also, I'm going to make the noise for a little while with the clock. Doot, 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 doot. I was doing my best 24 impression there. I don't know if that was working for anybody, but sometimes you have to amuse yourself, man. Back to the interview.
questionnaire not that long ago. I think I said, no, I don't blindly trust the police. I mean, and the question that I got at sidebar that the day I got picked, I mean, I know the question and I know the reason. I know they sent me away 3 times and then brought me back and kept asking me questions. They did ask me about TikTok. So I did tell Lally about my Taylor Swift TikTok.
Okay.
I don't think he cared, but no, the question they asked me was, are you more likely to believe a police officer just because, or a law enforcement just because of their job, right? And my answer was, a person's profession does not define their character. So no.
Okay.
So I think that's kind of what ended me up in there.
But yeah, so why do you think Karen Reed picked you? I mean, there was hundreds of people they went through. What do you think she liked about your answers?
Wait, she picked me?
Yeah, I mean, Karen's extremely involved in her defense, like for a defendant. I mean, ultimately her attorneys did, but they don't do anything without her, approval.
Yeah, I guess I didn't know who actually picked me or if I was just because they didn't want to waste an exclusion, to be honest.
They didn't want, okay. So you get picked and you go through this whole whatever day, however you were there for months. And then you become an alternate. How pissed were you?
Well, I mean, it wasn't an alternate. I got dismissed.
Okay. So you dismissed. You didn't get to deliberate.
Correct.
On a scale of 1 to 10, how pissed were you?
30.
30. Yep.
Okay. Sounds pretty right.
Why? Tell me your thoughts. Well, how are you feeling after you got dismissed? Like, what was it like driving home that day after you just wasted 3 months of your life dedicated to this bullshit, and now you are going home on the final fucking day? What does that feel like?
Well, I was mad. I mean, I was mad.
Anything else?
I mean, no. That day I was just mad.
Okay.
I was just mad that day.
You're just mad. Who were you mad at?
I mean,
were you mad at Auntie Bev? Because she kind of, like, your transcript with her has been entered into your whole conversation, and you sounded like a deer in the headlights when I read that whole back and forth between the two of you, and she was like asking you if you were drinking at a bar 6 weeks ago or something like that, and you're like, I don't know. Like, you're allowed to drink at a bar. Last time I heard, you're allowed to do stuff like that. And she's like asking you to remember shit that you did 6 weeks ago. Meanwhile, the witnesses that you just sat through, none of them remember anything that fucking happened 2 days ago. And you're supposed to remember, 6 weeks ago, allegedly, like you're out of the bar and you're like, what was I saying? Like, you never said anything bad. You never talked about the case openly, did you?
no.
Yeah. And so you felt like there was no reason to remove you as a juror at all?
No.
Okay. And everybody always asks this, and I know the answer already, but did you have any interactions with John Fanning?
No.
Okay. Because a lot of people are like, think that John Fanning was like on the bus or some shit. John Fanning is just a guy that fucking somehow is in charge of security and involved himself in this somehow. I don't even know how the fuck he got involved, but he just did. But next question I want to ask you.
I was going to say, I can't say anything more than what I just did. Again.
Okay.
I've been advised not to, so.
Can you say who your lawyer is?
No.
Okay.
Yes, you can.
I think I know who it is, but
you can absolutely say who your lawyer is.
Just leave it at that.
Okay.
I'm not purposely evading your questions. I'm just trying. I have a line I can't cross, and I have.
Well, you don't have to worry about that either way. Of course, you're under no obligation to answer his questions as the judge informed you anyway. So whether your lawyer advised you or not, but like you can, but you don't have to, of course. So it's like, I just don't want to answer your question is a perfectly valid answer. For whatever reason. It's like, you don't need a legal reason. You already have a legal reason. Freedom of speech, baby. You have the right not to speak. It's great.
I'm trying to toe that line as closely as I can, but there's things I can't say.
Why? Can you answer this one? Why so secretive? I mean, are you scared?
Why so secret?
Because you're scared, or are you worried?
It's because my lawyer told me not to talk about it publicly. That's why.
Okay. All right. So
Defamation
are
issues.
you worried about being doxxed? Are you worried about like coming on a program like this? Are you worried that, there's a lot of people that don't like Karen Reed and that don't like, and they're very vicious. Some of these people, they're very mean, right? They say mean things about me. They make memes. They,
499's from Haley's Hobbies. I always catch your replays, but I'm watching live because you're one person not going over verdict slips. Thanks for your commentary. Yeah, we went over the verdict slips already. We already did the verdict slip discussion a couple times. So I mean, we can do it again, but there's really no reason for us to because we discussed it. I did a whole like 60-minute discussion talking about lesser includeds and what they are and describing them in some detail. So you can watch that if you're interested in it. People seem to think it was pretty good. I thought it was pretty good. And yeah, I was right, by the way. That Pennsylvania has a 5-year misdemeanor. So when I was like, oh yeah, I remember reading one time that there was a state with a 5-year misdemeanor. I think it's actually the pinned comment now in the YouTube comment. Like someone said, I've been a clerk court in 3 different states. I've never seen a misdemeanor more than 1 year. What the hell are you talking about? Like, so then of course I looked it up. I'm like, oh yeah, it's Pennsylvania code. Here's the citation. Here's a link to it. Yeah, a first degree misdemeanor in Pennsylvania is a sentence of up to 5 years. It's a 5-year misdemeanor. Yep, that's what they're doing. States do some weird shit, man. But I know everything. Yeah, I know everything. It was like, yeah, I remember reading that one time. It's like, oh yeah, that exists. Yep. I'm not hallucinating cases.
they're ugly, vicious people. Does that worry you at all?
Yes, very much so. I mean, and I think that's why I've never wanted to say anything because I just, nobody wants to be called, terrible names on the internet and, have their stuff smashed.
Also, let me take a time to acknowledge the other super chats that have come in so far today since I haven't done so. And I apologize. I've been a slightly bad YouTuber and I apologize to you, my friends. And also incidentally, like, where is my donation alert? And is it coming up on screen? It probably is not even on the gaming thing. Donation alerts. I don't even know if the donation alerts are displaying or not. They might not be. In any case, let's move that up just in case. All right. Anyways, Elizabeth Joe Clanton became an uncivilian. Carlos 24/7 sent 5 gift memberships. Barbara Thomas has been a member for 26 months. Says uncivilians are here. Hold on, Karen. Blackbird 72 has been a member for 53 months. Adam Trapp sent 10 gift memberships. Pin King 554 said $150 knife giveaway. We're still working on exactly what we want to do here in terms of a giveaway. I'm thinking about doing a merch giveaway for $20 and then like figuring it out. I don't know, but yeah, I'm working on it. Violet Ellie said for $279, congrats for reaching 150K. I feel validated. Okay, the alerts are working now at least. That's nice. Excellent. I don't know if they were working before, but they're working now. David Eddy became an uncivilian. Miss Mandy, how are you doing, Miss Mandy? Holla. Hope you're feeling better. Member for 12 months. Diabolic Tutor, been a member for 5 months. J.E. Walsh, Watcher Fund for $4.99. Lucy Bowers for $5 says, judge should have let it be known it was FBI or made clear organization was hired by anyone connected to Karen Reed. Well, I mean, the lawyers made that clear repeatedly. So, but there's reasons not to let it be known that it's FBI. Right, because it's kind of prejudicial that it's FBI. I think it's the right decision not to let be mention this the FBI, because if the rule has to be the same either way, right? That's the thing. Like the rule has to be the same either way. So if you imagine that ARCA was hired by the FBI and came to the conclusion that Karen Reed was guilty for whatever reason, right? The fact that they were hired by the FBI might provide some additional gravitas that is perhaps unwarranted, or people might be prejudiced against the FBI in a way that might not be warranted. So I think excluding the fact that the FBI is correct. It sounds correct to me. So I'm not really bothered by that, but thanks. Haley Hobbies for $4.99 said to always catch your replays, But I'm watching you live because you're not the one person not going over verdict slips. Thanks for your commentary. And Fallen Hero sent a gift memberships. Thank you very much. You are all my friends today. Yeah. Also, by the way, I have to there was a comment, and I've seen this comment actually today too. And it's a bit of a pet peeve of mine. But I saw the comment in a different context on the chat today. And there was also a comment relating to when I did my my discussion relating to the DUI. And I said, so I gave a hypothetical to prove, to show how a DUI could be proven without a blood draw or without a breathalyzer. How could you prove a DUI without these things? So I created a hypothetical. And basically, let's suppose you're the only eyewitness to this person. You see this person unambiguously drinking a large enough amount of alcohol, and you know exactly how much, and you know for sure it's alcohol because for sure it's alcohol. It's not ambiguous. You see them drinking it all. You see them doing it. It's there's nothing ambiguous about this, right? You see them, wait around a sufficient period of time for the alcohol to be absorbed, and then you see them get in a car and drive away. It's can you charge DUI? Can a jury convict on DUI based on that and nothing more? And the answer is yes, they can. They can do it if they believe this eyewitness's story, right? And then someone in chat or someone in the thing said, well, or I think actually maybe it was the live chat of the last stream rather than a comment. Maybe it was a live stream. But someone said, oh, that's just he said, she said. There's no evidence of DUI. And I'm like, all right, there is evidence. There's an eyewitness. An eyewitness testimony is evidence. He said is evidence if he's saying it in court under oath. He said is in fact evidence. It's testimony. Testimony is evidence, right? Now, it might be he said, she said. Maybe this other person gets on the stand and testifies too. Maybe they do. But then it's just a matter of whether the jury believes the eyewitness or believes the defendant at that point. And if the defendant is, if the eyewitness is, deemed more credible and deemed more believable, then the jury could convict. I'm not saying they would convict. I'm saying they could convict. I'm saying it's legally sufficient. I'm not saying the police would charge. I'm not saying the DA would charge. I'm not saying any of those things. I'm saying they could. A jury could convict. It's legally sufficient to convict. There is evidence, namely the eyewitness who observed all these things. That is evidence. But some people, it's a pet peeve of mine because people will say things like it's not evidence when they mean it's not proof. And incidentally, yes, it is, because it would prove the case unto itself. It does prove the case if you believe it. You may not believe it, but if you believe it, it proves the case. It proves every element. The other thing I thought that was interesting about the whole DUI discussion is why can they charge DUI if they didn't charge her that night? Right? And I'm well, for the same reason they can charge any crime, except when they don't have to charge any crime the day it happened. Right? What kind of rule is this? Right? There's no crime that you have to be charged the exact same day it happened. That's insane. Right? So obviously they can charge any crime within the statute of limitations of the crime, depending on the jurisdiction. Right? So the fact that they didn't, they didn't do a breath, that's not a thing. So I don't know. I guess people are confused a little bit because they're well, here's how a DUI, a DUI, 99.9% of the time, right? I'm sure. I'm that's probably not even an overestimate. 99.9% of the time, a DUI is because the police pulled you over, and they did the breathalyzer and it popped to 0.08, and Bob's your uncle. 99.9% of the time. But the fact that that's true, 99.9% of the time, doesn't mean it has to be true, right? There are other ways to get to the end conclusion of guilt, right? There are other ways to do it. And so I don't know, man. It's just, I find the whole thing interesting, but I'm amused easily. How could they know 100% what the drink was? You mean in my hypothetical? How do they know? Because I'm God of the hypothetical, and I'm telling you, they know for an absolute certainty. See, that's the magic of the hypothetical. I can just take issues away because I'm God of the hypothetical, right? How do they in the hypothetical know? Because I'm God of the hypothetical, and I'm telling you, they know for an absolute certainty, and they are not mistaken. They are not mistaken about this. They know for sure. How? I don't know. You can figure out ways that they know for sure. But I'm just, because I'm God of the hypothetical, and I can just tell you. It's magic. Right? That's the magic of hypotheticals. I just tell you things and they become true. It's great. Lord. You need to be under the influence or 0.08. Yes. But that's why I said you saw them drink a sufficient amount of alcohol that it would be true, right? Whatever amount of alcohol that was, you saw them down the entire bottle of liquor. You saw them take a bottle of liquor that was still sealed. You literally saw them unseal the bottle, take off the plastic wrap or whatever. It's Maker's Mark. You saw them take off the wax and open up the thing and start chugging the shit out of it. And you saw them chug the entire fifth. See, this is like, I'm God of the hypothetical. It's like, yes, this person has a blood alcohol of 0.08 or greater. Also, the person weighs, I don't know, they weigh 150 pounds. Who's doing all this? So like, I can make this work. I can do whatever it needs to happen to make this example work. Please stop picking apart the hypothetical. I will just add in new facts until I win, because I'm God of the hypothetical. Yeah. More to the point, it is evidence. More to the point for what I was trying to tell you. An eyewitness testimony is evidence. Now, you might, at trial ask them like how they know these things, but they have a satisfactory answer. They have an answer that will satisfy you. Because, I'm God of the hypothetical. It's like, yeah. I regulate liquor in the state. I'm part of the liquor regulation board of the state of it. I have 20 years of industry experience. Also, I worked for that specific brand before. Also, I'm a distiller. I literally made the alcohol myself. It's aged alcohol, don't you know? So I literally made the alcohol they drank because it's aged, right? So back when I was working, for Makers, I literally made the alcohol itself, literally this bottle. And I personally did it. And the way I know that I did it is because, I have a special way of doing the wax that only I do. So I can tell that it was one of my bottles because I have a little what you call that? A little Easter egg, right? A little Easter egg that, most people wouldn't see, but, a little Easter egg that tells you it was dipped by me. So I personally made that bottle of alcohol myself. Also, I know what it is because, also I work for the liquor regulation industry. Also this, also that, whatever you need to make this hypothetical work, right? It's like, I can make it as whatever it needs to be. It's great. Oh, Lord.
All over the place. So, but at the same time, I'm kind of like at the point where, I'm fed up, right? I think Karen's getting hosed and I'm just fed up with the way that this whole thing is going. Honestly, just watching this and watching what's been happening, it's just crazy. This woman is getting railroaded and it's just insanity.
So you didn't deliberate, and you have somewhat of a strong personality, and so does Victoria George. And the other woman who was also eliminated was also have you talked to the third woman, the other woman that was eliminated, the other alternate?
Yeah. Yep.
And she's pretty, she believes Karen's innocent and would have voted that way?
Yes. Yep.
Okay. So that's 3 women who all would have voted not guilty, all of whom were eliminated on the final day. Do you feel if you were in that room?
Long Crime's clock is broken again. God damn it, Long Crime. Fix your fucking clock.
With these people deliberating, would you have tried to would you have been like a Henry Fonda in 12 Angry Men? Do you think you could have persuaded some of the others to see the light?
I mean, I would like to think so, but then some
Clock
of the
is
stuff I hear
fixed.
coming out of there, and it's just mind-boggling to me. But I mean, I think I would have been able to at least have people see common sense, right? Because to me, this whole thing was about common sense, right? I don't, there was, I think to some extent, right? How are such smart people so dumb? It's like they're too smart for their own good, right? That they can't actually see common sense. And so to some extent, like, I feel like that's where they missed it, is they were too like focused on being super smart and like, well, this and that, right? And so, I mean, I feel like I would have, I know it doesn't sound like it right now, but I do have a strong personality. I do think I could have convinced some of them. I do think that, it probably would have, I don't know that it would have gone in full acquittal, right? I mean, I can't say that I would have been able to do that, but, I mean, I do think that I would have been able to bring a few more people onto the, this is nonsense side.
Yeah, I mean, like Ronnie seems to have been banged around like a ping pong ball in that deliberation room. And last week you told me that you think Ronnie's kind of full of shit.
To some extent, yes.
Because how so?
I feel that.
There are some of us that have kept in touch, and you hear things differently, and the rememberings of things are not all the same, and the commonality seems to be some of his memories.
And I believe you said that you believe his memories are that that he was actually a guilty voter, that he's kind of lying about being a not guilty voter.
I think he's convinced himself that maybe he wasn't, but that's, Again, I'm going off hearsay, right? I wasn't in there, so I can't say for sure. But
objection, hearsay.
I've heard.
So that means you're still friendly with at least one person who was a deliberating juror.
I mean, it has to mean that.
I mean, you could say, you might as well say it. I mean, who gives a fuck? Seriously, who cares? Who cares? What the fuck's gonna happen? Like, oh no, Plevin's gonna fucking. Who cares? Might as well just say it. Who gives a fuck? Stop it.
It kind of does imply that.
I'm trying to be
Come on.
What are we doing here?
Wait, so
I'm friendly. I've stayed friendly with multiple jurors, some that were deliberating, some that were not. Yes. I mean, I'm not going to give names. I'm not going to say yes, no, or who or what, but I mean, and I'm not trying to, like I said, I'm not trying to be purposely evasive. I'm
interested, incidentally, like why her lawyer has given this advice. The only thing I can think of is defamation issues, but I don't know why you necessarily have to be this cagey about it. But other than that, I'm not really sure why you have to be this cagey. I'm not sure what your exposure is here. Okay. If it's something other than defamation, I'd be interested. Like, what is the concern of legal liability here? I don't know.
trying to be.
She's suing? She's suing who? For what? She's suing the state for what? Being kicked off the jury? Good luck. Yeah, that doesn't really work. For kicking her off the jury, she can't win that cause of action. People have tried before. People have tried suing for being kicked off the jury. There's no cause of action for that because there's no right to be on the jury, right? There's no fundamental right to be on the jury. The jury is a collective right, not an individual right. And so you don't have an individual. Yeah, she doesn't have standing. Yeah, she's going to lose that cause of action. Yeah, she's going to lose that cause of action. I'm surprised that she found a lawyer to take it, to be honest. Unless Massachusetts has some sort of strange wrinkle in its state law, which I guess is possible. Maybe they have some sort of strange wrinkle that, because we do have a lot of different states, and maybe there's some sort of special wrinkle there, but I doubt it. Right? Yeah. So yeah, that doesn't sound like a cause of action. Yeah, I don't think she has standing. Yeah, I don't think she has standing to bring the complaints. She doesn't have injury. That's the problem. She doesn't have injury because, yeah, jury service is normally seen as a collective right, not individual. And so people have tried to sue for being kicked off juries before, and like, yeah, courts are like, no, it's collective, not individual. So you literally don't have standing to bring the complaint. You don't have an injury. So end of analysis. Yeah.
Respectful to the other people that haven't necessarily wanted to speak, and so I don't necessarily, I don't want to speak for somebody else. That's all I'm saying.
How come none of the other, so there's 3 jurors who voted not guilty and stayed that way the whole time and would not budge. And I call those people heroes because they held the line in the face of pressure, and they were not going to let this woman get railroaded. They were not going to do it ever. They were never going to give in. And I love those people.
Me too.
But none of them, I would love to talk to one of them. I know who 2 of them are. I don't know who the third one is. I know one was a man who was sitting 2 seats, who was sitting in the first seat. Juror number 1, I called him. He was a not guilty voter. He's the one who has spoken to Christina Rex a couple times. Another one was the young lady who I believe is sitting directly next to you, right? The nurse.
Yes.
And she was a very solid not guilty voter. And I'll tell you one thing, she was the one during the deliberations when I was talking to Karen Reed's team, we're like, who's holding this jury up? What is going on? And we were trying to figure it out. And they were like, they couldn't figure it out. And they're like, I don't know about the young girl. I don't know about her. And I'm like, I don't know. I think she's solid. And it turns out she was like the most solid of all of them. And like, it was the PhDs that were the problem. And like Ryan Piotrowski, did you see the form? Everybody wants to know about the foreman. Did you see that coming, that he was going to be like leader of the Karen Reed is guilty of manslaughter movement?
Not even in the slightest bit. No. I mean, that was like, I don't know, multiple personality disorder, but no, there is absolutely no way that I would have seen that coming. It actually was quite the opposite.
Did you ever talk to him at all? Do you guys, I mean, you spent a lot of time together, right?
Yeah. I mean, we were in 2 different jury rooms. So, I mean, we didn't like, he was in the other jury room. So it wasn't like we were sitting down eating lunch together every day, but I mean, he was right in my little corner. So yeah, I mean.
What'd you guys talk about?
Everything but the trial. I mean,
I don't even know what that means. Like all I talk about is the trial. So I don't even know. I guess you talk about sports. What do you guys even talk about?
I mean, every time there was a sidebar, we would just talk about the annoyances of that and laugh about it. I mean, I'm trying to think.
That's just crazy not to be able to talk about the one thing that you all have in common, which is this thing that you're all sitting through this fucking trial. And like, how tempting is it not to get back to the jury room and be like, bro, if he says it's snowing one more fucking time, I swear to God, I'm going to fucking lose it.
Yeah. So, I mean, I think we all had the facial expressions of that. The eye rolls and stuff like that. So, I mean, there were things like that we probably said without saying them. But I mean, no, honestly, we got to the end of conversations. Like, we were talking about houses, we were talking about shoes, we were talking about,
So, yeah, I'm going to go down the list.
We did puzzles. I mean, we talked about people's kids. Literally anything to talk about. It's like making small talk with 18 people for 32 days. It's, you connect to some people, and those are the people you actually try and get to know. We spent time talking about Victoria being pregnant a lot, right? And she didn't feel great. So trying to, help her. But then
I've started a little goal, start a super chat goal. So we'll see if that can get me anywhere, because I keep looking for things to do with super chat goals, but can't quite figure out what to do with them. But I've started a super chat goal whereby if we get 10 $5 donations, then I'll do a $20 merch giveaway. So basically I get $50 and I give someone $20 back. So that seems like a pretty decent deal. Actually, in the $50, I'm only getting 80% of that. So I'm getting like $40. So I'm actually like giving half back. So that's actually pretty reasonable deal, I think. So yeah, if we get 10 $5 super chats, I'll do a merch giveaway for that. That sounds like fun. Yeah.
Other people, you just make small talk.
She seemed pissed when they pulled her number out. She seemed pissed. Like, what the? It was noticeably like, bro, Like you could tell she wanted to deliberate badly. And then
Yes.
she came in the second day of deliberations in a bright pink dress.
I've
And
never been more proud of her.
Yeah, and it was
Well,
reported in the media.
maybe the other day was when she filed her name on the Karen Reed team, but those were my two proudest of Victoria days.
Oh, right. Did you know she was going to do that? Did you know that she was joining the team?
No, nope.
That was pretty cool. I mean, I hope it helps. I hope she. Do you still talk to Victoria?
Yes.
Okay, cool. And she hasn't been around. A lot of the trolls have started to spread the rumor that Victoria George quit on Karen Reed. That she found out information and now she's flipping. And is that true? Is any of that true? Is she still cool with Karen Reed?
No, that's not true. Victoria has 4 children, as we all know. So.
But we don't all know that. You know that.
Well, I mean, I've seen it on the internet, so I assume that the internet knows. And she was pregnant during the trial, the first one. So she's got, younger kids, right? I mean, no, right. She hasn't, there's none of that going on.
Right. So
she's just as a believer as she was on, whatever day she decided she was the believer.
So I want to go down. I'm going to go down. I'm going to give you a list of names here one by one. And I want you to tell me your first initial, either in one word or in just one small sentence. What comes to mind when I say the names of these witnesses? Are you ready?
I'm ready.
All right. Colin Albert.
Who falls on their knuckles when they slip on ice? Like, that's the stupidest thing I've ever heard.
That's a pretty good point. Yep.
Good answer. What about Brian Higgins?
Creepy.
Oh, God.
Out of touch.
He does not know how to flirt.
Is that's what you took from him, was the messages? That was your
first. I mean, you're asking me the first thought in my head. That's the first thought, right?
All right.
So.
What about
fair play, juror number 3? That is what he asked. It's like, that's what you took away. You asked for my first thought. Yeah. It's like that was a good comment by juror 3. That's like, shut the fuck up, turtle boy. It's like, you asked for my first thought. That's the first thing. Fuck you. Yeah, I like that answer. Good job.
Yuri Buchanan.
Oh my God. The inverted video is not the same. It's not the same. It's backwards. It's not just a mirror vision. It's bullshit.
Did he almost hit you with his cufflinks? Because you were very close. And his elbow hangs up high, real close to the jury.
I don't remember, actually. I don't remember now. Maybe. I think I was too shocked by the inverted video.
Okay. What about Jennifer McCabe?
I don't know why she always looked at me and smiled.
Oh, did she? She was looking at you.
It seemed like it. I know maybe it was just my...
I was not allowed in the courtroom for the Jennifer McCabe testimony. As you know, I was removed. But so I didn't see the jury's reactions to her, but it's impossible not to notice that she kept looking at the jury for like, you guys believe me, right? I'm a good person. I'm just like a normal mom. Like, you guys, she kept looking at you guys.
What is this in my news feed that's happening? Hold on a second. Trump announced a mobile plan. What? Hold on a second. Hold on. What the fuck is this? The Trump Organization unveiled a mobile phone plan and a $4.99 smartphone. What? The Trump Organization on Monday unveiled a mobile phone plan and a $4.99 smartphone that is set to launch in September. The new service, Trump Mobile, will offer a $47.45 per month plan. Wow. $47.45. It's a little on the nose, isn't it? But okay. That includes unlimited talk, text, and data, as well as roadside assistance and a telehealth and pharmacy benefit. The company owned by Donald Trump also announced it will sell a T1 smartphone, which appears to be gold-colored metal case etched with an American flag. Holy shit. Okay. All right. Trump Mobile, its products and services are not designed, developed, manufactured, distributed, or sold by Trump Organization or any of their respective affiliates. The bottom of the website reads. Okay. The Trump Mobile website says the T1 phone runs Android 15 and features a 6.8-inch AMOLED screen with 16 megapixel selfie camera. Its other specs included 12 gigabytes of RAM and 256 gigabytes of internal storage, as well as a 50 megapixel main camera. Okie dokie. That is a story apparently that is happening in my news today. I did not see that one coming. All right. Carrying on. Glad you live in the UK. I'm sure that your living in the UK does not necessarily deprive you of your opportunity to buy this phone. I assume international customers like yourself will also be able to buy the Trump phone. I'm sure you look forward to it. All right. Pressing on.
And she was looking for like approval. Like she wanted to see what you guys looked like. Yeah, you guys believe me, right? And so did you believe her?
No, not at all. Definitely not.
Do you believe she Googled how long to die in cold at 2:27?
100%. Yes, I do.
Oh.
And I think that I do. Yep.
All right, let's do some more names. Ian Whiffen. What did you think of him?
I think he wanted me to buy his homegrown software app more than he wanted to convince me that Jennifer McCabe did not Google how long to die in cold.
What about Brian Albert?
I don't know how he didn't come out of the house.
Yeah, really,
What
right?
was it like sitting next to him when he looked at you guys and he thanked the jury?
Yes.
And then on the day that you were removed, he was standing right behind you. He was sitting right behind you, staring at you.
Yep.
And what was that like? Were you? I mean, he's a big boy.
Meaning like when he was on the stand or the day I walked in?
Let's do both. What was it like being on the stand with him with the Mr. Rogers look? And then what was it like on the day that he came in and he sat with the O'Keefes?
I didn't notice that he was there until I left. And by that point, I was like, tunnel vision, get me out of here. And I was contemplating, should I yell free Karen Reed in the courtroom? But then I was like, maybe I'll go to jail. So I shouldn't do that. So I just left.
Okay.
When he was on the stand, I mean, I watched him even when he wasn't talking. When the defense was talking, when people were asking him questions, I was still watching him because I wanted to see more of his reactions, not to questions, but in between the questions and things, because people tend to think you're not looking at them at that time. So I continued to look. I don't know. I'm trying to think of the right word, and I just don't know that.
What did you think of his whole Mr. Rogers look that he had on there? You didn't believe his whole thing about answering the phone while he was having sex. I mean, when you heard that?
I mean, I think I laughed because, I laughed at a lot of those things. What else do you do?
Yeah. Okay. What did you think when Julie Albert said bukkake twice in the courtroom? What went through your head when you heard that?
I didn't know what that meant until last week. So I had no idea. I had to Google it last week because somebody said it to me.
You don't sound very exciting then. Okay. But yeah, either way, I'm just kidding. No,
I had no idea. So I thought it was just like his nickname that they called him. And I was kind of like, that's weird that she's calling him his nickname. But I didn't know anything more than that until literally last week. So
did you know who I was when I was in court? Like, did you had you heard of me before? Because they've accused you of being like a Turtle Boy plant. Did you know who I was? Did you, when you saw me in court and we were looking at each other for 10 weeks, did you have any idea who I was then? What are your thoughts on me?
I mean, I recognized you, yes. But we didn't know each other. I mean, you did a story about a Christmas tree, and that's how I knew. But other than that, no. I mean, I didn't know you at all. I've never spoken to you until when? August? Yeah.
You reached out to me in an anonymous email, August. I thought I was getting trolled.
I remember that.
And then I did. You're like, no.
Now I see why, for what it's worth. Now I see why.
And we FaceTime. And I'm like, oh, shit, it's her. Oh, wow. Okay, cool. So let's keep doing the names thing, though. I like this. Let me think of
okay.
First thing that you think of, Michael Proctor. What comes to mind?
I just, he should have been fired far longer before then. I mean,
What about Paul? What about Paul O'Keefe?
He's like he's just an angry person, I think. I mean, he is just a very angry person, and he's not angry at the right people. And I think he's completely delusional in terms of like what actually happened.
You were looking at him for 10 weeks in a row. Did he? And this jury, apparently, somebody felt uncomfortable with Paul because he was forced to move his seat after the second or third week, and he now sits in the back row. Did Paul make you feel uncomfortable at all the way he was staring at Karen Reed and jurors?
Yeah, I mean, I didn't love the way that he would stare at Karen, but Yannetti did such a great job like blocking her when it started becoming so obvious that that was what was happening. I mean, honestly, I don't know how she sits there every single day and doesn't scream because it's just, I mean, it's just crazy to me that she has so much self-control that she can sit there and not scream. And the internet finds one face that she makes and, makes it out like she's this terrible person. I mean, you try and sit there all day and listen to this and not say a word.
Yeah. What'd you think of the faces Karen Reed made? Some people find it a turnoff. Others don't care. What did you think of the faces that she made during the trial?
So, I mean, honestly, there is a lot of things that happen in that courtroom that you do not see on television. So
Like what?
Well, I mean, what you see is one face that she may make on a particular day when the camera pans on her, but you don't see her when she sits there the entire time when people are, being asked questions about her. And I watched her quite a bit, and I watched like her demeanor, right? And people say she doesn't have any emotion or thing. If you watch her, yeah, she really does, but she's trying hard to not have the emotion, likely because she's told not to. So there's a lot of things that happen in that courtroom that you don't see on TV. And Karen's demeanor is one of them.
All right. So back to the
I wish everybody could see what we saw of her, because it would really change people's.
Well, we kind of do this time around. There's a Karen cam this time around that's showing her the whole time. The Zoom picture picks up on her. And I do feel like this time her facial expressions aren't, she's definitely making less of them this time around. She's just an expressive person, her face in general. And let's be honest, like if you take any video and you just pause it at the right time, you can get anyone making a funny face, like did you see the New York Post today?
No.
Oh my God. Their headline, you got to see it. I got to show you this headline. This is fucking outrageous. Give me 1 second to pull it up. Like I've never seen anything this offensive than the headline. Okay, here it is. I'm going to pull it up now. Wait till you see this goddamn headline. This is outrageous.
Okay.
I'm sure some people in the chat have seen this, but this is the New York Post today. Okay. It says,
oh, seriously?
Yeah. Karen Reed. Yeah. This is what it says. Karen Reed, sinister smirk as gory photos of her dead cop boyfriend were shown in court. And it's like, and then I go to read it. I mean, this is trash journalism, just absolute trash journalism. And it's by some reporter who we're going to shame right now because we have 17,000 people watching. Smash that subscribe button if you're new here. All
There's
right.
17,000 people watching this.
It's the biggest. Congratulations. This is the biggest show I've ever had. 17,000 live viewers. So you're welcome.
I don't think I'm that entertaining, but okay.
Yeah. Well, I mean, you could be entertaining. You could be a little more entertaining, but.
All right, I'm gonna try. I didn't realize. Okay.
All right.
Right.
So it says Karen Reed flashed sinister smirk as gory photos of her dead cop boyfriend are shown. This is by Anna Young. Who's this? Does she have a bio here? I click on it. So there's Anna Young. Okay. She sucks. She's a joke. She's trash. And, you know, I go and let's read the article. It says Karen Reed had a sinister smirk during yesterday's murder retrial. The same day jurors were shown gruesome photos of her boyfriend's battered, lifeless body. She grinned manically as graphic images of John O'Keefe's bruised and bloodied body were revealed to the jury as an expert witness testified that the blunt force trauma that killed the Boston cop wasn't consistent with being struck by an SUV. Perhaps she was smiling because she was vindicated by this testimony. Has that ever occurred to this woman that she spent the last 3 years being framed for a murder she didn't commit, and now a highly acclaimed doctor and medical examiner is showing these injuries and saying those didn't come from someone who died from hypothermia and was hit by a car? Who wouldn't be happy? They call that sinister. This is outrageous. Am I alone in this world thinking this is outrageous?
No, this is crazy.
The body did not have any hypothermia, she testified. Who wouldn't smile about that? And then, like, she displayed the Joker line grin. As an expert witness testified, there was no evidence. A Joker line grin. Are you fucking kidding me?
So, I mean, I'm just going to say this, and I hope that she doesn't get upset with me, but I watched Karen the first time around with the autopsies.
Yep.
She sat there the entire time, taking deep breaths. You could tell she was upset. I don't know if it was photos, this, that. I don't know what it was exactly, but I could see her taking deep breaths and trying to calm herself down. So this is the biggest bunch of fucking bullshit, because this is one photo that somebody took and, you know, went through a video to find the absolute worst freeze frame that they could find to put it on the internet. Yet they don't watch her every single day in the moments when, you know, nobody is paying attention to her.
Right. Right.
I guess it's so infuriating because these things are not how she's reacting. Not at least when I was there. And I watched her for 10 weeks. I watched her a lot for 10 weeks.
Right. And you weren't at all offended, obviously, by the faces Karen Reed made or anything like that. I mean, I'm just so disgusted that they actually put this out there. I don't even know where to start, but it's just absolutely disgusting that this is the state of the media, that they would put something out like that. But
no, and that's why, I mean, the one that was on the camera, I mean, that was the problem. It was, she did not like the faces that Karen was making. And that's what I said to a court officer.
If anybody can find Anna Young's Twitter account, please let me know so we can absolutely destroy her and shame her as she should be, because that is disgusting, and you need clapback if you're going to get something like that. You know, just outrageous, absolutely fucking outrageous that you'd put a headline like that. So it's just, I mean, what's the point of it? It's just not nice, right? Doesn't this poor woman have enough shit on her plate that she doesn't need to open the New York fucking Post and see pictures of herself like this? Like, put yourself in her shoes for just 1 second. It's just awful. Well, you know, the media isn't required to be nice, but the media should be honest. And a headline like that, my problem with it is it's dishonest, because it's not sinister. First of all, the catcher smiling is not sinister. Right. Maybe just she's actively involved in her defense team. They're having a discussion about something, and some good testimony came out that's helping her case, and she smiles. I feel like only a woman would come up with a headline like that, because only a woman could be that catty towards another woman to be like, oh, she's smiling. bitch.
Or like maybe she said, I really have to pee. I hope this goes fast. Or maybe she said, I'm so annoyed because my hair looked great when I left the hotel this morning, and now I feel like it's frizzing because it's so freaking humid in here because Auntie Bev won't put the ACs on. Like, who knows what she said? And who cares?
What was it like not being able to go to the bathroom whenever you wanted? I mean, I was in court today and I had to pee wicked bad by like 12:30, and I'm like, the fake victim was up, and I'm like, but I can't miss this. I got to write down I can't leave, period. It's my trial. Right. And I'm like, that must have sucked. Well,
I mean, we got to leave and pee when we had to, but nobody wanted to be the person that nobody ever wanted to be the person that was like, excuse me, I have to pee. But then as soon as one person did it, we would all run back, and everybody was very grateful because everybody had to pee. So
yeah.
But these are the dumbest things that we're thinking about.
So let me give you some more names. Lucky Loughran. What'd you think of him? Because
I loved him.
He's the best. He is the best.
Sweetest man. He is the sweetest man. And he just wanted to plow the roads. He felt bad about hitting the basketball net, and he just was such a nice man.
Well, that's nice to hear, because Ronnie said that they found him the least credible of all the witnesses. When I asked him, like,
shut the fuck up, Ronnie.
The least credible. They were like, they said Lucky, and I'm like, are you out of your fucking mind?
Yeah. Again, sometimes you can't fix common sense.
Yeah. So let me think of some more names. Tristan Morris. What comes to mind when I say that name? Anything?
Oh, how much trouble he got in when he got home for saying that what's-her-face was high maintenance, and that kid seriously had no idea what day, time, or month it was. Yeah. Everything was, I don't remember, right?
He doesn't remember. He doesn't remember anything. Let's see. What about Allie McCabe?
Oh, she got caught. She got caught slipping up when she said that Colin wasn't in the house when John was there.
Did you pick up on that when you were?
Yep.
You did?
I did. Yep.
You did? Oh, wow. A lot of people didn't pick up on that, but you picked up on that when she said that. That's interesting.
Yes.
She also cried, and it was about me. She was kind of the first one to cry about me.
Oh, that's right. Yeah, she did.
Were you buying her tears when she cried?
I mean, look, you never want somebody to cry because you never want someone to feel bad. But I mean, that wasn't why I was there, to feel bad for her. I was there to figure out if, Karen was guilty or innocent. So.
What did you think of the Canton police, like Seraph and Gallagher and Good? What did you think of them?
They were very unmemorable to me. I'm trying to think. I mean, we watched their dash cam videos. I remember writing everything down as they were talking, because for some reason I felt like the footage between the street and the flagpole was like gonna make a difference, and turns out it didn't. So I think, they were not memorable to me.
What did you think of the Sullivan sluts?
Oh, mean girls. Girls.
Okay, you thought they were mean girls?
Oh, mean girls. They pointless and mean.
Interesting. I think a lot of people share that opinion about them, just especially since Karen apparently paid for their room too. Like, whatever disagreement they had, one of them said that, like, yeah, but later on she came and apologized and then offered to pay for our cabana or whatever.
Yes, I remember that.
Yeah. So, and
I was like, why are you being so mean then? If she'd offered to pay for your stuff, can't we just get over it?
Yeah. They were just like, justice for Johnny, like, we need to come back. I don't know. Yeah. What did you think of the kids testifying? What were your thoughts on that when they? I was in there for that.
I mean, I don't see any reason why that was done, honestly. I mean, I guess it sounds like this time around, I forget who testified. The girl. So it sounds like she wanted to this time, right? I mean, it just seemed awful to put them up there. Honestly, I was annoyed very much with Lally that he brought them in there. I just did not see that it was any point at all.
Okay. So you weren't moved by their testimony. They didn't do much to, I mean, I think that's a comment, especially the boy. I mean, they added nothing.
No, I mean, it's not that I didn't, I feel for the kids. Of course, it's an awful situation. And two things can be true at the same time. It can be an awful situation and they shouldn't have had to sit in a courtroom and talk about it.
All right.
So
what did you
I mean,
now
that
this
was my
time
take
around?
on it.
So this time around, I know you said you haven't watched the trial as much this time around, but it's a very different trial,
Right.
and there's some very different witnesses. Have you seen? Like, have you been generally like? If I said the name Dr. Laposado, you know who that is? Have you seen any of her testimony?
Is she the one? She is the medical examiner yesterday that said she had the best line of the day. What was it? I didn't look because it doesn't matter because she didn't hit him with a car or something.
Yeah, she's the queen. She's the best ever at everything.
Yeah.
Lucky is the best ever. Lucky's the greatest.
You saw her.
Lucky is number one.
Trial. Like,
Yes.
you feel
She would have been. She was definitely more convincing, more concise than Dr. Sheridan.
Yes, because Dr. Sheridan, what'd you think of him?
I mean, he seemed like a nice man. He seemed like, an intelligent man, but he also seemed, very old. And
he had an accent too. He had a heavy accent, and he did seem very old. Yes.
I don't remember if he was difficult to understand now that you're saying that. I forgot he had an accent.
Mm-hmm. Oh, he did. It's a very strong accent too. So
Okay. I don't remember that, but
yeah. And he was older, he seemed experienced at all, but you're right. He did
experienced, but out of practice a little bit. I think that's, how I would have, I think that's how I looked at it. Experienced, but out of practice.
And just not as confident. Dr. Laposada, I've never seen somebody as confident as her, not like Judd Welcher was arrogant.
All right, guys, you did it. You hit the goal. You made the goal. I'm very pleased and very happy. So it's time for a merch giveaway. All right. So first of all, the rules, all the details that you need, how to redeem it, what exactly you can do, can be found with the command !rules. So how do I enter if I win? How do I get my prize? What do I need to do? All those things are contained in the rules so that you can read them for yourself. So what is happening right now? And is my thing broken? Hold on. Yeah. Okay. So whatever motion the defense made to amend the jury verdict slip was denied. Oh, because they want like more detailed instructions, which, they probably should get more detailed instruction, but not so much. But that was denied, which, you would expect it to be. I think my browser has crashed. Something has gone wrong. My entire browser, I think, has somehow crashed. Why has it crashed? Or what is going on? Okay, I will close the browser and reopen it and see if that fixes the problem. Talk amongst yourselves, chat. Great, we're back. All right, fantastic. All right, we're back. All right, cool. So let's do this thing. Hopefully this will work.
Sidebar giveaway. Sidebar giveaway.
Okay, cool. Let's go back to the discussion. Let's go back to the video and we'll watch that for a while.
For no reason, whereas Dr. Lapisato was so confident and I don't know if cocky or self-assured in her answers, just that she just had alpha male like presence to her. Like it was so fucking awesome.
She was a spitfire for sure. I mean, she was just like giving it back.
Yes. So what about trying to think who else in this trial, the new ones that you didn't see. So you never saw Kelly Dever.
No.
Did you watch her testimony this time around?
I didn't watch the whole thing. I watched pieces and parts of it. And I don't know how she got away with being that disrespectful.
So it's interesting because the defense talked to her 2 months, or actually right before the first trial began, and they elected not to bring her on as a witness because so they get the TUI report in February, and they're like, holy, she was in there. And like she says in the TUI report that she saw Higgins and Ken Berkowitz alone in the Sallyport garage for a wildly long period of time and so they immediately are like, let's call her as a witness, right? Let's call her up. And then they call her up and she's like, actually, that was a false memory. Now that I talked to Chief Cox, Commissioner Cox, I suddenly remembered that I don't remember that. But the defense this time, even though she had the same story she did a year ago, they're like, fuck it. It's worth the risk. We're calling her now. Do you wish you heard her as a witness, as a juror? And do you think it helped the defense to bring her on?
I think she looked like, she looked like someone who was trying to
start an OnlyFans?
She looked like someone who was trying to cover an ass because she shouldn't have said something to begin with. And now she was like going back and trying to correct it. Like somebody clearly said something to her. It seems like, seeing her, I think if they brought her in at the end at that point, I would have just been like, all right, whatever. You're just one more person that's just not going to tell me the truth today. So that's fine. Mm-hmm. And I'm just going to move on with my life.
Okay. So do you think it was helpful or not to bring her on?
I think it was helpful for the defense in the sense that she definitely came across as just rude and that she didn't want to be there. And that, obviously, because she said she didn't know why she was there. But she seemed like she was trying to backtrack and be like, I didn't say that, or I was misremembering. Like, how do you misremember that kind of stuff? So I think she helped. I think she showed. I think she would have been better for the third party conspiracy as opposed to the reasonable doubt with no collision. So for that, I don't know that she necessarily did anything, but I think she would have been more fuckery in the first trial.
All right.
If that makes sense.
She would have been more fuckery, like
meaning like one more person that was just saying ridiculous things.
Okay. Yeah. So it would have only reestablished. Yeah, you're right. Like I get what you're saying, that she would just been another person that's like makes you roll your eyes like, what the fuck is going on here? But that Ronnie would have called the distractor.
Probably, yeah.
Okay. All right. So Nicholas Barros, let's talk about him. I love him. So when he testified in the first trial, which you were a juror in, he said that the taillight was cracked but not completely broken. What did you think of that when he said that?
I believed him. He had no reason to say anything other than the truth. I completely believed him. I wish the defense had crossed him.
And you wish the defense had crossed him?
Yes.
Oh, really? Okay. And asked him like they did this time, did the taillight look like this?
Yep. That was one thing that I think they learned from trial one, is that him just saying that wasn't enough, and they needed to establish that much more.
The first thing. Go ahead.
And when he said, absolutely not with such certainty, that's what they needed.
That was powerful.
Yes, exactly.
Your jury did not hear that. This jury did.
No, we didn't hear it. Nope.
And that's one of 10 reasons I could think of. Let me tell you 10 reasons just off the top of my head why I think this second jury is going to acquit her more than your jury, right? Okay, so the testimony of Nicholas Barros was so much stronger because of absolutely not. That's one.
Correct.
Okay,
Yep, I
the
agree.
testimony of Lucky Loughran was better because of the way that he held up during cross examination with Hank, just refused to budge, refused to say that he was a victim of bullying or whatever, like any of that shit.
Yeah.
Okay. There was no Dr. La Posada in trial one. Okay. I think she is a huge addition. It makes them a million times stronger. I think that the ARCA experts were 10 times better this time than they were the first time, because they had all those videos, which they didn't have the first time, showing this. They more visuals, like they didn't have a single visual in the first trial. They just sat there and explained the science to you and all that stuff. What else makes this time a million times stronger? Who else? What am I thinking, Check? Give me some help
Dr.
here.
Russell, Marie Russell was way more confident, way more prepared this time. And she was sassy back to Hank too, which I don't think she was sassy enough back to Lally the first time around, when she was like, oh, no, that was the best thing I've ever seen. I love her. She was much more confident this time around too. I think everybody that they've put on has been far more confident this time.
And I think that Hank is ultimately a net negative for them. This is my number 6 reason why, is that Lally was more likable than Hank Brennan was. People felt bad for him, you know, or do you disagree?
Likable? I don't know. Feeling bad for? Maybe. Hank, I mean, he's nowhere near in the category of Hank. There's no doubt about that. I mean, Hank's just mean, and he just is a bully. Lally was.
Lally what?
Wasn't a
I lost
bully,
it. Oh,
but he was
there.
just kind of no personality.
Yeah. Just want to tell Barb here. I want to tell somebody to go fuck themselves. Hey, Barb. Go fuck yourself, Barb. Get the fuck out of here, you cunt. Anyway, I just had to tell Barb that because I saw that.
Oh.
And I hate it when people tell me to comment. Don't tell me how to talk, Barb. Get the fuck.
I appreciate that. I get frustrated too. Times when people tell me what to do, I get frustrated. Like, don't tell me how to feel. All right, don't tell me how to feel. Don't tell me what to do. Like, if you want to provide suggestions, but don't phrase it as a command. Right? It's like, yeah, don't phrase it as a command. Yeah.
Fuck out of here. Anyway, so that's.
Like, you would think people would know that by
I
now,
know
not
you
to
would
tell
think
what
it's
to
like
do.
you got the wrong channel. I don't know where you've been, right? I just had to say that. Number 7, Bob Alessi this time around, right? They didn't have him the first time around, and I think that he is very good and better than the other attorneys at the technical shit and breaking it down and going through his best cross-examination in this whole trial was with the medical examiner. Right. He was so good with her, and with Ian Whiffen, he was really good too. And just explaining why these people are bullshit. You didn't have Bob Alessi. What do you think of him? You didn't sit through him.
No, so I do think it's easier to follow when he breaks everything down, because he goes kind of step by step for those of us that are not science jurors, which definitely is me. I mean, I was picking out the key sentences because a lot of things, was over my head, right? I didn't, if I use the ME as an example, you can say that all the medical terms and all of this, and I don't understand that. But what I understand is the injuries are not consistent with being hit by a car. And that's all I needed to know. But then for somebody who's more
Yeah, like that's sort of again, this is sort of where I agree with this. Like, how do you solve this? What is the easiest way to solve the problem? Right? That is a very good way of doing this. How do we make our lives as simple as possible? Why make our lives more complicated than it needs to be? I mean, it's a murder trial, but why do we have to make it more complicated than it has to be? So what is the easiest way to resolve the problem? Right? Well, since the state has to prove each and every element beyond reasonable doubt, like, which element is the weakest? Right. And I think that, that the injuries are inconsistent with the motor vehicle accident is the easiest way to resolve it, because under the state's theory of the case, right, no matter what version of the theory of the case you accept, right? Because the state has posited multiple different versions of their theory of the case, which incidentally, by the way, they're allowed to do. They're allowed to change their theory of the case, so that's fine, right? They're not stuck to a particular theory. Now, the fact they change theories might hamper them in some other way, right? It might make them not credible, or it might make you not believe them, or it might make them think like they don't even know what's going on, right? But from a legal posture, they can change theories. What that means to you as a juror, is sort of up to you. But no matter which version of the state's theory you accept, right? No matter what sort of variables you put into this equation, right? There is one sort of thing that has to be true under every possible state scenario, right? There's two things that have to be true at the same time under any version of the state's theory, right? The things that have to be true is that one, that Karen Reed hit John O'Keefe with enough force to create some kind of disabling injury, whatever that is. Two, the injuries, the car also did not cause any bruising, broken bones, or torn ligaments, right? So it has to be simultaneously enough force to create a disabling injury, yet still not create broken bones, torn ligaments, or bruising, right? If the car hit John O'Keefe, which is their theory of the case, the car hit John O'Keefe and disabled him in some way that led to his death, whatever mechanism of death it was, it doesn't really matter what the mechanism of death for the purposes of this discussion is, right? Was it that the car killed him outright? Was it due to frostbite? Was it due to hypothermia? Did he have a heart attack? Did a dog kill him? Whatever, right? It doesn't really matter at that point, right? It created some kind of disabling injury, but not broken bones, torn ligaments, or bruising, right? And it's like, how are both of those things true beyond a reasonable doubt? That's the key, right? It's possible. I concede it's possible. But the state has to prove it beyond a reasonable doubt. They have to prove that is what happened beyond a reasonable doubt. They have to prove beyond a reasonable doubt this car created a disabling injury and also did not create any bruising, broken bones, and torn ligaments. They have to prove that beyond a reasonable doubt. And I don't know what combination of things you have to believe to get there beyond a reasonable doubt from an analytical framework. I suppose you can sort of hand wave it away, but you're not really doing your job, in my view, if you do that by hand waving it away. But how do you get there beyond a reasonable doubt? I'm not quite 100% sure how you do that analytically. So that's the easiest way to resolve it. And then, of course, if you can't prove that beyond a reasonable doubt, you don't have to ask any other questions, right? You don't have to ask anything else. Like, did she have the intent? Did she drive backwards? Was she, you don't have to ask any other questions, because the state having failed to prove one of the elements of the crime, you can just stop, right? It is a fail. It's like, all these things have to be true. One of the things is not true, therefore it's a fail. What about the other things? What about the other things? I no longer care, right? I no longer care. You failed on one thing. I no longer care about the other things, and I'm done. That's the easiest way to resolve this analytically. So I agree with the juror on that 100%. There are other reasons to doubt this, right? That is just for me, the thing that is the most literally, in the literal sense of incredible. It is not credible. There are other reasons to have doubts for sure, but that is the largest one. That is the biggest gulf in my view. And since it is the biggest one, there's really no point in addressing any of the other reasonable doubts, right? Again, there's really no point in discussing anything else, because if you can't solve, the biggest gap, then what's the point of discussing any lesser gaps? There's no point, right? Maybe we can bridge those lesser gaps, but what does it matter if we can't bridge the big gap? Again, we don't have to ask any other questions. We simplify our lives. It's great. Pressing on.
Science focused, right? They need that breakdown. So that's where Leslie is helping so much for those types of jurors, like the science, the engineer ones, right? They saw that last time around. So I think that's where it's helping.
Yeah, you're right. You do, because like one of the leaders.
And then, of course, I also don't have to answer questions like, what do you think killed John O'Keefe? How do you think he died? Who done it? Was there corruption? Was the evidence planted? Right? I don't have to answer any of those questions because it no longer matters anymore. Right? It no longer matters anymore for the purposes of Commonwealth versus Reed. It just doesn't matter anymore. I have found the easiest way to resolve the problem, and nothing else matters. Nothing really matters. Anyone can see. Nothing really matters. Nothing really matters to me.
Of the Lynch County movement in the jury last time was an engineer.
Correct.
And he believed he was smarter than the ARC experts, I believe. This time around, I don't know how he could think that after this time around, because they really walked them through everything that they were saying. And they explained more so in detail the science and the physics of how, like, what his arm would look like, how many shards of taillight wouldn't be able to even catch up to the arm. You know, it wouldn't even be like, it's not traveling. He's explaining velocity and all this shit. It's just fascinating how he explained it all. That didn't happen in the first trial. So what are some other reasons why I think that this time around was better? I think that honestly, just the lack of the conspiracy shit, it's like, you believed it, you thought it was effective. That's what sold you. But ultimately, that didn't sell enough people on the jury. And so I think that ultimately not going that route is going to be a positive, even though I agreed with it 2 weeks ago. Right. But you know what I mean? It was like, I was at that point too, though.
I was going to say, we agreed 2 weeks ago. And I think we agree now that, we should.
I was worried. I was very worried.
Yeah. We should trust the defense team, right? They have a strategy just because we don't know it. So we're sitting here all nervous. Like, what do you mean you're not calling Proctor? What do you mean you're not calling, Brian Higgins? But I mean, it was the smart way to go because now there's nobody to refute some of the things that were said, right? So
right, yeah.
That's why,
no decorated dude. You can't come on there and talk about how none of this stuff happened.
Exactly.
But Brian Albert doesn't have a chance to explain his bullshit away. He doesn't get to explain why he didn't come out of the house. The jurors are just left with that the dude didn't come out of the house. He never came out of the house. And
that's, I think, and that's the different strategy that they're taking this time, right? Whereas before it was the conspiracy. And this time it's, these are the things, right? But there's nobody coming in to explain all of these things away, all of the weirdness of why he didn't come out of the house. I mean, that's going to be a big focal point, I think, in closings as well as it was in opening, because it's just so unbelievable that a first responder doesn't come out of their house.
Yep. It's a little hard to believe.
Yeah.
Yeah.
I didn't understand it 2 weeks ago. I understand it better now.
Yeah. So, I'll tell you later about the message I just got. But I think, imagine just what do you think Karen Reed's going through right now? Like the thoughts that are in her head. Imagine being in her shoes right now, where you're about to have your fate left up to 12 strangers. Imagine that.
No, I can't even imagine it. I can't. She is a strong, very brave woman. And I think, if all of us could be half of as great as she is, then we'd all be better people. Honestly. I mean, I don't know how she does it. I really don't.
I don't either.
She's amazing.
As somebody who's been twice now in the last 3 or 4 months, I have stood in front of a judge after Robert Cosgrove has filed a motion to revoke my bail for 60 days, right? And I've stood in front of that judge. And let me tell you, it happened in Stoughton and then it happened again in Dedham. And I was shitting my pants. Like I was scared. And cause I'm like, oh my God, 60, I can't go to jail for 60 days. I can't 60 days, whereas if you're Karen Reed now, you're like, holy shit. Like if I was her, I wouldn't want to stop calling witnesses because I would just want to delay this as long as possible. Like I would just be too scared. I'd be so scared. of deliberations that I would just want to delay it as long as possible. Like, let's call another fucking witness. Let's call the Asian house lady. Let's call Kelleher. Let's call the, like, I would just keep fucking calling people because I'm like, well, you know, maybe Auntie Bev will be hit by lightning during this time. The longer I drag this out, the fucking better. You know what I mean? But I just can't imagine the finality of just accepting that it's time to put my fate in the hands of 12 people. I can't imagine what that's like.
I mean, I can't either, but I mean, you got to believe that to some extent, right? She's just like, enough is enough, right?
Mhm.
It's going to be what it's going to be. And I mean, it's, you know, I don't know. I don't know how she does it.
Well, I just want to remind Karen Reed that, and like Taz says here, my guy Taz, he's a regular down in the courthouse. You know, she's going to be acquitted. It's going to happen. It is going to be the best fucking feeling ever. And there's going to be a couple thousand people outside that courthouse, and you are going to hear screams of joy when that happens. Like, and it is going to be the best feeling in the world, and it is going to feel so good, and it's going to be over, and there's nothing they can do to hurt her anymore. And
I can't wait.
yeah,
wait.
it's going to happen. You got to remind yourself it's going, like, the hung jury was a fluke. Hung juries are rare. They're not very common. And that was a fluke. That was a fluke. This is a fluke jury. This is a defense team that has learned their lessons, that has come back much stronger in the second trial. And Hank Brennan in the last week is unraveling in front of our eyes.
I completely agree with that. I mean, because they're just knocking it down one by one. And that's everything that, you know, the jury is going to be left with.
Yes.
Is all of these witnesses, one after one after one, saying without any sliver of a doubt, he was not hit by a car.
Not hit by a car. Over.
And that's over and over and over.
La Posada, Wolf, and Rentschler is how they ended things. Wasn't hit by a car. Wasn't hit by a car. Wasn't hit by a car. Period. And he didn't die from hypothermia, so he wasn't out there that long. Okay, that's how they ended this show. I mean, who did they have? And then before that, who did they have? He wasn't on the lawn. Wasn't on the lawn. Wasn't on the lawn. Wasn't on the lawn. Taillight wasn't broken to smithereens. Wasn't broken to smithereens. Wasn't broken to smithereens. And oh yeah, where the fuck is Proctor? Where's Brian Albert? Where are all Brian Higgins? Where are all your? Why the fuck are you hiding them, Hanky? Why do you feel the need to present a sweatshirt and pretend that it was ripped on the round when you know goddamn well that Maureen Hartnett did that? Desperate people do that. This is a desperate person.
Where's Chloe? That's, I mean,
fuck Chloe.
Chloe's dead.
That's what I think of Chloe. He's in doggy hell if she's alive.
Oh,
Chloe can
Chloe.
get fucked. Chloe's a bad dog. Poor Chloe. Chloe's a bad dog. You know, so, I mean, some dogs are just bad. Some dogs are just bad.
I'm
dogs.
not a dog. I'm not a dog person. So, I mean, you know, I probably just pissed off the internet by saying that, but I'm not a dog person.
And I know it's not the dog, it's the owner. It's the dog.
I'm
Okay,
with you, though. It's a whole
dog.
different case. It's a whole different, I mean,
Yeah.
I feel better this time around with the way that they just put all of these witnesses one after one after one. You know, I don't see how any person could convict her of anything.
They can't.
I mean, it's completely crazy.
They can't do it. And there's no you on the trial making funny faces, so they don't even know who to eliminate this time around.
Well, thank God.
They can't.
Thank God somebody learned something from me.
Yeah,
right?
They can't rig it. You know, so
Keep your faces to yourself.
I'm telling you guys, it's like we're all fucked up from the last trial because she was, you know, the hung jury and the interview with Ronnie. Forget about that. That's over. That's done. It's a whole new jury this time around. They heard an entirely different case. They don't even know who Colin Albert is. They don't give a fuck about Colin Albert. They don't give a fuck about. They didn't call Rick Green. Let's talk about Rick Green. So what'd you think of him as a juror?
I'm trying to remember.
He's the 220. He's the Google search guy.
No, I know who he is. I'm just trying to remember. I think he came in, reminds me, he came in after Ian Whiffen and what's her face? Jessica Hyde.
He was the defense witness. The guy looked like Chris Farley. Like
Yeah. I don't think this is probably the popular answer, but I honestly don't think I listened to all that much that he had to say, because the other two convinced me of how ridiculous it was that they were proving that the search didn't happen, that I didn't need to hear Rick Green say that it did.
So you believed it before he even took the stand? You believed it happened?
Yes, because because Whiffen and Jessica Hyde were so ridiculous in their like analysis and reasonings and this, that, and the other thing, that I did not believe either one of them. So
okay,
Rick Green to me was just like, I would say he was just like the icing on the cake.
Well, they didn't even bother with Rick Green this time around. They used some of his findings. They used his findings against Jennifer McCabe. They just didn't call him up because this trial is not about Jennifer McCabe killing John O'Keefe, right? We all know what she did, right? But it's not about, they don't have to prove Jennifer McCabe did it. They just have to prove Karen Reed did it, and she didn't, period. And it's just more obvious than ever. And last trial, it was really just the ARCA guys, that got up there and explained the science of how she didn't do it. Whereas this time around, it was the ARCA guys on steroids and Dr. La Posada and what's her name? And Dr. Russell was a million times stronger and more resolute. Yeah. And so, it was just.
I do wish that we got Dog Daddy, though. I gotta say, I'm a little disappointed that there was no Dog Daddy.
Garrett Wing? Garrett Wing?
Yeah.
Yeah, that was a travesty. That is. I love Garrett.
I would have liked him to go, but I understand. I mean, at the end of the day, right? He didn't get hit by a car. So why bring in people that aren't necessarily needed, I guess, to prove that he wasn't hit by the car, right? I mean, you've established this with the last 5 people. So
yeah. So I think that, I want to remind people out there that like it's going to end. Don't worry about it, guys. I understand we all are scared and, you're worried for Karen and justice and blah, blah, blah. And the worst people, like, we've just invested so much in this emotionally, like all the Twitter beef and the evil people and the crusty panties and the fucking Julie Carpenters, like it's fucking deranged John DePietros. And you're like, they can't win. They don't get to win. Right? The bad guys don't fucking win. The bad guys fucking lose. And they're making us go through this and it's fucking horrible. And they're making her go through it and it's fucking horrible. And we all agree it. But that can't be how the fucking story ends. It's not going to end that way. It's going to end with Karen Reed being acquitted and it's going to be fucking awesome. Period. Done.
I agree.
Yeah.
I'm with you.
But
I'm, totally 180. I was worried 2 weeks ago and no, I'm not anymore. I mean,
I'm worried. Yeah. Yeah, they say, jurors make up their minds. They say sometimes in opening arguments, I tend to believe it. Jurors, prosecution goes first. That confession stuff, admission, it's pretty powerful. If they bought that stuff, if they bought that and ate that up, man, yeah, I'm worried about it. They've been deliberating 4 hours and 9 minutes, which is about 4 hours longer than is required, in my view. Well, maybe that's not quite fair because I don't think they had the jury verdict forms right away. So it's about 3.5 hours more than's required. But yeah.
I mean, I'm really not.
Awesome. That's awesome. So,
which I guess that's a good swing, right?
Why don't I take some questions from any Turtle Riders in the chat? If you guys want to throw your
Turtle
questions
Riders
up in the chat, I'll answer. I'll if I see good ones, I'll bring them up. If you guys have any questions for juror number 3 before we excuse her for the time she's given us tonight. And I understand some people in the chat are like, why even come on if she can't? She agreed to come on. She can't talk about everything that she'd like to talk about, but also you try putting yourself out there like that. You know what I mean? It's like not everybody wants to get fucking skewered by the internet. Give her a break for crying out loud. Okay. Let me see. People asking, what do you think of Kerry Roberts?
I mean, she's like the most useless guest that you bring to a dinner party.
Okay.
I mean, other than that she committed perjury and then tried to say that she didn't. I mean, that discredited her right there. So, I mean, other than that, the most useless guest that you bring to the dinner party. Maybe just to talk because you don't want to. I don't know.
Who was the first witness that convinced you Karen Reed was innocent? How long did it take you to believe that Karen Reed was innocent?
Oh, I think so. I mean, during all of it, right? I mean, it was all of the crazy McAlbert stuff that didn't make sense, right? So none of it was like adding up. So that was a little bit like, okay, that doesn't make sense with that, and this doesn't make sense with that. But I think the minute that I was like, I'm sure, was it was Higgins on the stand, and they were talking about the butt dials, and it was like a 22-second phone call or something. And he said, Higgins said, oh, well, even if I did talk to him or something, don't quote me, I don't remember what he said, but the gist was, you can't have a meaningful conversation in 22 seconds, right? And so AJ wanted Auntie Bev to stop and like observe 22 seconds long, just so that we could get the feel for how long 22 seconds was. And of course she didn't do that, right?
Fucking unbelievable. She wouldn't do that. Forgot about that.
But there were some of us who didn't need her to do that, right? So then as soon as she said no, I looked right at the clock that was sitting above like where she is, right? And AJ asked 3 very quick questions that had 3 very distinct answers that were very meaningful questions. And it was that second that I was like, you can have a meaningful conversation in 22 seconds because you two just did.
That's cool. That's good insight right there. I like that. That's really interesting. That's something we didn't know beforehand. See, that's award-winning journalism right there. Getting answers like that. That's something I hadn't thought of before. You actually, that's really cool. Thank you for sharing that.
Yeah.
Let me see here. Let's see. I'm trying to see some more questions here. So a lot of the people like you in the chat. They're like, I want to be friends with Juror number 3. She seems cool. Here's a good one.
Some people saying I'm boring, so I guess I'll take
okay. You can't win them all.
Nice.
Somebody asked the question. This is the one I want to see. Was the tour of 34 Fairview helpful when you guys went there?
Yes, because I climbed underneath the car.
You were the one that went under the car, right?
Yes.
Why the fuck did you do that?
Because I wanted to see if there were scratches underneath it, because there's no way that you can back up at 24 miles an hour and not hit something. It's fucking impossible. Not hitting the curb, not hitting anything, no scratches on your hubcaps. I mean, I'm not a great driver, so I know these things. It's not possible.
Do you think that the 34 Fairview trip would have been better towards the end of the trial after you had heard all these people talk about not hearing anything outside?
It didn't. I mean, I don't really know that it mattered to me, honestly. I mean, it would have been fine either way, I think. But
let me rephrase that. When Brian Albert said he didn't come out of the house because he didn't hear anything, and they all said they didn't hear or see anything, did you immediately think about, like, okay, I was there. Is that realistic? I was there. Could that have, you'd already been there at that point. Do you think if you had heard that and then went and looked at the house, do you think that would have been a better way to do it?
No, honestly, I think it was better to have seen it and to have that perspective before all of those things, because then as you're listening, you're like, how is that possible? Because when we were at that site visit, AJ pointed out those windows and said, look at those 2 windows right there.
Oh, he did?
Yes.
I didn't know they were allowed to do that.
Yeah, so they each pointed out certain things that they wanted us to look at. So, and again, it might have been Yannetti, I don't remember. It was one of them that was talking. But they said to look at the gate, look at the proximity of the flagpole to the mailbox, and to look at those 2 windows.
And what did what did Adam Lally want you to look at?
I think, I honestly don't even remember what he said. And that's how like unmeaningful it was. It was probably something like, look at the door. I truly don't remember what he said. And
Interesting.
I mean, I kind of walked around and did my own thing anyways. So,
Yeah, sounds
I
like
mean, I walked to the neighbors' houses and looked across from their doorbells. I was under the car. So I don't know. I was
interesting.
walking against the sidewalk from the mailbox to the flagpole, counting on my feet of how many feet it actually was.
Oh, really? You actually measured that?
Yes. And then I measured across and then like walked up, and because there was at some point a mention of a 3-point turn. And I was like trying to figure out if she could have done the 3-point turn and backing up without hitting the curb. And she couldn't have with the width of the street,
Mm-hmm.
at least not well in the snow.
Mhm.
So
I didn't know you were. I thought that was one of those things Auntie Bev lectured you on not doing. Your own.
yeah, she did, but we did it anyways. All of
Oh.
us. I think everybody did it.
Oh, okay.
Well, she told us we can't use those measurements as like, factual or whatever,
Right,
but I was
right.
not the only one that was walking and counting. No.
Interesting.
Yeah.
Very interesting. Okay, cool. All right. Well, if you don't mind, I'm going to let you go now, and I'm going to read
Totally
some
fine.
chats. But I appreciate your time, and thank you for coming on here. And free Karen Reed, right?
You got it. Free
Yeah.
Karen Reed. Maybe
We'll
I'll
talk-
see
Yes, maybe we'll see you outside the courthouse.
you. We'll see.
All right.
I was already in court once this week. I don't know.
yeah.
If I can...
Last question. What did
Yeah.
you were in court today in Dedham
I was.
District Court, right?
I was.
Yeah. What'd you think of my whole case? What'd you think?
So when Bradel said the taillights, I like almost burst out laughing. There was something about, so was there taillight fragments around? And I just almost burst out laughing. I was like, where am I right now?
Yeah. What'd you think of what'd you think of the fake victim? Did you watch her testify at all? Were you there?
No,
for that?
because again, it turns out I have to go to work when they don't pay me $50 a day to be there all day. So I was there for the cops and the map builder person.
Oh, right. What did you think of the cops?
I mean, they stood up there and said that you tried everything within your power to not do anything wrong. And then Cosgrove still says lynch him and put him in jail. So this is just crazy to me.
Yeah, it was Crump said it a few times today. He kept saying that, he was making a good faith effort to be 100 yards away. That's
it was said more.
Apparently, Law and Crime has failed with clock. They have a pinned comment now in their chat saying the verdict clock wasn't working. So they have removed the verdict clock from screen. Apparently they're having trouble with the clock. Okay, that's fine.
More than a couple of times. Yeah.
Yeah.
So I was just like, oh my Lord. It was just, I don't know,
Yeah. Yeah.
It's interesting to be back and listen to things that don't make sense.
Yeah. So, all right. Well, thank you for coming on.
All
I
right.
appreciate it.
Sounds good. I want to see whatever that text was too.
Oh, I'll show you. Oh, yeah. I'll show you. Yeah. All right. All right.
Because I like gossip too.
Of course. Of course. All right.
All right.
We'll talk later.
See you later.
Bye. All right. So, yeah, cool. Good. That's
All
the
right.
biggest I've
That interview was interesting. That interview was kind of interesting. Not as frustrating as Ronnie, to be sure. But, yeah, interesting. I think there are a lot of reasons for reasonable doubt. I think that there's more ways towards guilty than there were last time. I still am concerned. Apparently the clock is broken. That's exciting. All right, cool. All right, so I guess what we're going to do now is we're going to do Supreme Court decisions because that's fun. All right. Unless you guys have other ideas, but it's always good to learn about law. This is in fact a legal education channel. I know we don't just do true crime stuff, but this actually is a legal education channel. So we're going to inform you about the law. We're going to teach you some law. And we're going to teach myself about some law along the way because it's brand new law, right? That's the Supreme Court. That's one of the things they do with their time. They create new law. Sometimes the law is not, grand or massive in scope. Sometimes it is, but we're going to learn, we're going to discuss the law and we're going to learn new law along the way. And that's fun. I'm having fun. All right. So let me pull up some decisions And we will read decisions and we will learn some new exciting law. What is the new exciting law, Supreme Court? Yay. I did finish the giveaway. I absolutely finished it. 100%. We did. We had a drawing. There was a name drawn. It was announced. It happened. Yes. All right, let's see. So we're going back to the 12th. All right. Cool. Let's do a different split. Let's do it this way, because this will look a little nicer, I think. Okay, let's do it this way. Okay, this needs to go somewhere. Put that in this corner. Cool. Do this. All right, and I want this to be like longer. Neat. Uh-huh. Yeah, I think this makes sense to do it this way. Oh, I need to move these like logos to the other corner. That's what I need to do. And then it will look nice. Yeah, that looks better. All right, cool. Excellent. All right, so we're going to start with the case we started discussing last time. So if some of this sounds familiar, you've heard this before if you were here before, but we never finished it. So we're going to go ahead and just start over and we'll discuss it from the top so we can all make sure that we're going on. All right, so let's do all these things. All right. The case we're discussing today is coming from the Supreme Court of the United States via the 8th Circuit, is the case of AJT versus Owesa Area Schools Independent School District. The case is as follows. Multiple federal laws afford protections for children with disabilities in public schools. 3 statutory schemes are particularly relevant to this case. Section 504 of the Rehabilitation Act of 1973 provides that no qualified individual with a disability shall be excluded from participation in, denied benefits of, or subjected to discrimination under any federally funded program solely because of reason of disability. So, yeah, we can't exclude you because you are disabled. We can't do that. That's bad. All right. Similarly, Title II of the Americans with Disability Act prohibits qualified individuals with disabilities from being excluded from or denied benefits of public service entity programs or activities by reason of disability. While the anti-discrimination guarantees of Section 504 and Title II apply in various contexts, the Individuals with Disability Education Act offers federal funds to states in exchange for commitment to furnish the core guarantee of a free, appropriate public education to children in public schools with certain physical or intellectual disabilities. So as per normal, when the federal government wants something, one of the ways that they do this is with the money, right? The federal governments have no inherent authority over state schools. They can't make them do things. So how do we make them do things? Money. Money is the way we make them do things. Like, I want you to do X. And they're like, no, you can't make me. And the federal government's like, how about a big pile of money? And the states usually go, yay, money. And then we can make them do things because they took the money. So that's one of the common ways of doing these things. So, yeah, that's how that works. Carrying on. The centerpiece of the IDEA Act is a provision of an individual educational program which spells out a plan to meet all the educational needs of a child with a qualified disability. So you have to create an educational plan for this student, in particular, based on their needs. That plan may or may not be similar to any other student's plan. It may not necessarily be extremely different. It could be extremely similar depending on the nature of their disability, but you need to accommodate them in their disabilities. So to some degree, these may have to be individualized. And in an extreme case, it may truly be a one-person education plan, but that's what you have to do if you want the money. So that's easy enough to understand, no problem. Petitioner AJT is a teenage girl with a rare form of epilepsy that severely limits her physical and cognitive functioning. She suffers from seizures that are so frequent in the morning she cannot attend school before noon, though she's alert and able to learn from noon until 6. For the first few years of her schooling, school officials accommodated AJT's condition by permitting her to avoid morning activities and instead receive evening instruction. But when AJT's family moved to Minnesota in 2015, the new school district, namely Owessa Area Public Schools Independent District Number 279, denied the parents' repeated requests to include evening instruction in AJT's individual plans. So we're not going to accommodate you in that way, says this new school district. Between 2015 and 2018, AJT received only 4.25 hours of instruction daily compared to the typical 6.5 hours a day for non-disabled students in the district. After even further cuts to AJT's school day were proposed, her parents filed an IDEA Act complaint with the Minnesota Department of Education alleging the school's refusal to provide after-hours instruction denied AJT a free, appropriate public education. An administrative law judge determined the school district had violated the IDEA Act and ordered the school to provide compensatory education and evening instruction. Federal court subsequently affirmed AJT's IDEA Act victory. All right, cool. So like she thinks that she's protected by this thing called the IDEA Act. They're like, you didn't follow the thing. For people who are familiar with education law, this should not sound too unfamiliar. These lawsuits are, not uncommon. They're not uncommon, right? So people who are familiar with education should be familiar vaguely with the concepts of IEPs. They're not unheard of, and they should not be unfamiliar with being sued related to IEPs. So, all those things. So the school district was sued with respect to the IEP, and the courts took a look at it, and they're like, yeah, you're right. The school district didn't give you what you need, so they have to do these things. And please do those things, school district. Okie dokie. So far, so good. We're all on board. All right. AJT and her parents then sued under the ADA and Rehabilitation Act, requesting a permanent injunction, reimbursement for certain costs, and compensatory damages. So the IDEA Act basically unto itself, as I understand it, basically only allows you to get the new plan, right? It doesn't give you any award of money, right? So the remedy for an IDEA Act violation is, here's a new act, here's a new plan for you, right? So they got their new plan, but they didn't get any money for the lawsuit. And they'd like to, get some money for the lawsuit if you don't mind. The IDEA Act itself doesn't give any mechanism for that. The US rule is everyone pays their own way, right? Unless there's a law to the contrary, everyone pays their own way. So the IDEA Act does not give them a mechanism for compensation, but they think they might have compensation from a different law, and they'd like to try that in addition to it. So they're like, we won under the IDEA Act. We'd also like to sue under some other acts, so maybe we can get some money. Okay. So they sued under the Americans with Disability Act and the Rehabilitation Act, which are also acts of Congress, requesting a permanent injunction, reimbursement for costs, and compensation damages. The district court grants summary judgment for the school, and the Eighth Circuit affirms. So not so much, says the lower courts, with respect to the ADA and Rehabilitation Act. They said yes with respect to the IDEA Act, but they said no with respect to the ADA and Rehabilitation Act. In so holding, the Eighth Circuit stated that a school district's failure to provide a reasonable accommodation was not enough to state a prima facie case of discrimination under relevant law, which requires a plaintiff to prove conduct by school officials rising to a level of bad faith or gross misjudgment. So this gets relating to the pleading standard. What exactly do you have to plead in your lawsuit, right? What do you have to say happened to win? What are the elements of the offense in the pleading? And they said, well, you didn't make this standard showing that they, willfully discriminated against you or were consciously disregarded or bad faith. You didn't show any of those things. Okay. Are any of those things required? Are you actually required to show those things? The lower court said, yes, you're required to show those things. What does the Supreme Court have to say about the issue? Held, school children bringing an ADA and Rehabilitation Act claim related to education are not required to make the heightened showing of bad faith or gross misjudgment, but instead are subject to the same standards that apply in any other disability discrimination context. Right? So like the ADA is a generic law that applies, to sort of generic businesses. The IDEA Act by its nature applies to schools specifically. Right? And so the IDEA Act, you can't go to Chipotle and you weren't served properly and be like, I want to sue under the IDEA Act. That doesn't make any sense. Chipotle is not a school, right? Chipotle is not subject to the IDEA Act. Okay. They are subject to the ADA. So what do you have to show for an ADA complaint? Well, basically you have to show that you have a disability and they failed to reasonably accommodate it. That's basically what you have to show. And then the business, whatever the business is, can either say, well, we didn't discriminate against you at all, or we did accommodate you, but you didn't like our accommodations, but they were reasonable accommodations. We did provide you accommodations. They weren't what you wanted, but they're reasonable accommodations and they're sufficient. Or they could say, we are not able to reasonably accommodate you. What you're asking us to do is not reasonable. And then we get into whether or not it's reasonable or not. And it is not de minimis. That was a standard that they had a couple years ago. Like just anything more than de minimis, which, that's basically nothing. So it's not de minimis anymore, but it's not also like breaking. It doesn't have to be like, it doesn't have to be burdensome, but they have to do things as long as it's, not unduly burdensome. And then we can get into exactly what that is. But, those are the things they have to show. We didn't discriminate against you at all. Or we accommodated you, but not in the way you wanted. We're not required to accommodate the way you want. We're just required to reasonably accommodate you. The fact that you didn't want our accommodation is your problem, not ours. Or we can't accommodate you because it's not reasonable and we're only required to do reasonable accommodation. And so, sorry, but we can't do that. And those would be valid answers from Chipotle. And the school district is basically subject to the exact same standard because it's the exact same law. There's not some special education carve out in the Americans with Disability Act. There could be, of course, Congress can, slice it any way they want. There could be some section in the Americans with Disability Act that says, oh yeah, by the way, if this is a school, here are some other things that for that situation. Those could be stricter. They could be less strict. Congress can kind of do what it wants, but Congress didn't do that. They just passed an ADA that sort of generically applies. And the school district is the same as Chipotle in this situation. So you don't have to show this heightened standard. You don't have to show bad faith by Chipotle. You just have to show there's a disability. They were aware of it. They failed to reasonably accommodate you and so forth and so on. So the school is subject to the exact same standard. They're not special. They're not one of the specials. So you don't have to show some sort of new burden. That is not how that works. All right, great. So that's all the same. All right. Outside the educational services context, right? So how do we normally deal with this in normal world, right? How do we normally deal with these kinds of complaints in normal world? Okay. Courts of appeal permits plaintiffs to establish violations and obtain injunctive relief under the ADA and Rehabilitation Act without proving intent to discriminate, right? That is not an element. You don't have to prove the intent. You just have to prove that they are discriminating. You might have to prove they're aware of your disability. You might have to prove that. And, that they're aware of the disability. If they don't know, then how can they accommodate it? But, you don't have to show that they were trying to discriminate, just that they were discriminating. To obtain compensatory damages, courts generally require a showing of intentional discrimination, which most courts find satisfied by deliberate indifference, a standard requiring only a showing defendant disregard a strong likelihood that challenged actions would violate federally protected rights. Okay, so if you want to establish the violation and obtain injunctive relief, you don't have to prove any intent. If you'd like some money in addition to, fixing the problem, if you'd also like some money, then the courts do require showing intentional discrimination, but deliberate indifference will also be fine, which is typically true in intent, right? Deliberate indifference or willful blindness is kind of the same idea, right? If I'm consciously choosing not to know, right, then I know, right? If I'm choosing deliberately not to learn the information, then I know the information. Yeah, willful blindness, conscious disregard, that works a lot. Deliberate indifference, these are kind of all the same things. So, nothing surprising there. So that will be fine. Nothing in the text of the applicable substantive provisions or remedial provisions of the ADA or Section 504 of the Rehabilitation Act suggests claim based on educational services should be subject to a separate, distinct, more demanding analysis. So, again, Congress could have said, when it comes to education or anything else, some other standard, they could have done that, but they didn't. So we know how you deal with it normally. We know how you deal with it in normal cases. There's nothing in the statute that says this is special in any way. So just apply the normal law. Just apply the normal law, right? That's not complicated. Just do like what you would do with any other kind of business. Just do that. Just do the normal thing. That would be fine. It's not that hard. All right. Some courts, however, have come to apply a heightened intent standard to the ABA and Rehabilitation Act for claims in educational services context. Okay. This standard traces back to bad faith or gross misjudgment rule articulated by the Eighth Circuit in 1982 in a case called Monahan, in which the Eighth Circuit reasoned that to prove discrimination under the Rehabilitation Act in an educational context, a plaintiff must show something more than mere failure to provide, the education, which in this case is the service, right? So they failed to provide the service. In this case, education. In Chipotle case, how about a burrito? But they failed to provide the service. So, yeah, okay. The court explained a heightened showing of bad faith or gross misjudgment was necessary to harmonize the Rehabilitation Act and the IDEA Act and reflect the proper balance between disabled children's rights, state official responsibilities, and courts' competence in technical fields. So they're like, oh, there's a whole bunch of statutes Congress passed, and we need to make them all work together at the same time. And so this is how we're choosing to fix the problem. So they all work together at the same time. Okay. In Smith versus Robinson, this court similarly tried to harmonize the IDEA's specific guarantee of free, appropriate public education with protections of other anti-discrimination laws, ultimately concluding the IDEA Act's comprehensive statutory scheme was the exclusive avenue by which disabled children with their parents could challenge adequacy of education. So the Supreme Court of the United States, was faced with this problem before. They were faced with this problem before. They were faced with the IDEA Act and the ADA and the Rehabilitation Act. And the Supreme Court of the United States said, what we think is when Congress passed the IDEA Act, we think they meant for that to be the exclusive remedy, right? That is the only remedy for children, right? They have an Americans with Disability Act and they have a Rehabilitation Act, but Congress passed a special law for educational environments. And they're like, well, maybe the reason they did that is because they want this to be the only law for educational environments. Because again, Congress can do that, right? Congress could say that, the ADA doesn't apply to schools, but that's okay. We have some other solution for you, or, not, as the case may be. And we think that's what Congress meant to do. We think Congress meant for the IDEA Act to be the only thing for the kids. No ADA or Rehabilitation Act for you. Only the IDEA Act is what we think. All right, well, Congress has another idea. Congress doesn't like that idea. Within 2 years, however, Congress enacted a new provision of the IDEA Act overruling our precedent. Yeah, Congress didn't like that idea. Congress is like, you done fucked up, Supreme Court. I don't know what law you thought you were reading, But you apparently suck at your job, but that's okay. We are here to help. We are here to help. And we are going to overrule you. Supreme Court, can the Congress do that? When it comes to a statute, you bet your ass, right? Congress can just change the statute. That isn't what we meant, you stupid Supreme Court. We meant something else, but that's no problem. We're going to spell it out to you in small, easy to understand words that even you can understand. Supreme Court, your law sucks. Here's some new exciting law. Fuck you. And so the Congress did that, and they can do that. And yep, that's a thing now. So great. So that provision is now codified in some other section of law, provides that nothing in the IDEA Act, and we're just going to spell this out for you so that even you, the Supreme Court, can understand this. We're just going to spell this out for you. They said nothing in the IDEA Act shall be construed to restrict or limit rights, procedures, and remedies available under the ADA, Rehabilitation Act, or other federal laws. We fucked that up. We fucked that up. Oh, no, wait, no, it's not exclusive. It's not exclusive at all. They still get all those other laws. Congress is like, we passed a whole bunch of laws. All the laws still apply. Fuck you, Supreme Court. Oh, okay, well, we got chastised, so, all right, that's kind of clear. Congress cleared that shit right up. This provision makes clear the IDEA Act does not restrict or limit rights or remedies that other federal anti-discrimination statutes independently confer. We screwed up. Sorry. The bad faith or gross misjudgment rule derived from Monahan is irreconcilable with the unambiguous directive. So Congress is like, what about this? Do you not fucking understand? Let us spell it out for you. And apparently the lower court somehow didn't get the memo, because they're still like trying to reconcile it. And Congress says there's nothing to reconcile. What are you even trying to do? There is nothing to reconcile. They are just separate, completely separate, independent causes of action. They may have some overlap. So the fuck what? Says Congress. So what if they have overlap? That just means you can sue multiple different ways for the exact same thing. So what that you can sue for the exact same thing multiple different times? Who cares? You have multiple different causes of action. Go forth, my friends. Go forth. Oh, okay. All right. So, but apparently the lower courts didn't understand the assignment Congress gave them somehow. In imposing a higher bar for discrimination claims based on educational services as compared to other sorts of disability claims, the Eighth Circuit effectively read the IDEA Act to implicitly limit the ability of disabled school children to vindicate independent ADA and rehabilitation rights. No, not so much. Thereby making it more difficult to secure the statutory remedies provided by Congress. The school district no longer defends Monahan's asymmetric rule. Because that doesn't work, and contends that instead of bad faith or gross misjudgment is the correct standard for all ADA and Rehabilitation Act claims. Oh, okay. That's how the school district wants to fix this problem. Okay, yeah, this is how we're going to solve this, right? We're not going to try to defend that, there should be a special rule for the IDEA Act because Congress, just whacked us in the back of the head with the stupid bat. And, so we're just, we understand now. We're not going to try to do that. What we're going to try to do is say, oh no, actually you've just been misinterpreting the ADA and the Rehabilitation Act all this time. Oh, okay. That's it. You've just been misinterpreting the ADA and Rehabilitation Act. That wasn't a requirement for the IDEA Act. That's a requirement for all the discrimination law. ADA, Rehabilitation Act, IDEA Act. Yeah, you have to prove the intent to discriminate, the bad faith for all of them. All of them. You've just been misinterpreting the ADA all this time. Silly Supreme Court. Let's give that a shot. All right, great. This argument was not resolved below, was not raised in brief of opposition, is outside the question presented. The court declines the invitation to inject this case, a significant issue that's not been presented. Also, by the way, there is no hope of this issue. They're going to try. They're going to try. They're going to try at the lower courts to be like, oh yeah, no, we've been misinterpreting the ADA this entire time. Good luck with that plan, but we're not going to decide it right now. Vacated and remanded. Back down. Roberts delivers an opinion for a unanimous Supreme Court. 9-0. Well, yeah. So, no, the IDEA Act is not subject to this special standard. But, go and try. Yeah, this will be good. Go to the lower courts and try to convince them that they've been misinterpreting the ADA and the Rehabilitation Act all this time. Do you know how many ADA cases there are? Do you know how much ADA law there is? Yeah, that's it. The courts have been somehow screwing it up this entire time. Go try selling them on that bullshit. Good fucking luck. Also, fuck you. So yes, long story short, the parents can sue under all the acts. If they're covered more than once, so be it. Fuck you, school district. And that is the end of the case. 9-0. So that was fun and exciting. I enjoyed that opinion. And I enjoyed the Supreme Court's fuck you. I'm liking spicy Supreme Court. I'm liking these unanimous fuck you decisions. These make me happy. They can't collect twice. That's true. To the extent that they would be provided, monetary damages, they can't collect monetary damages more than once. So assuming arguendo, which is one hell of an assumption, but assuming arguendo that the total amount of damages is $100,000, then that's true. They cannot recover more than $100,000. Now they might be able to recover that money under more than one cause of action, right? But they can't recover more than their losses. So that's true. So you can only recover once monetarily. And I suppose you can only recover once injunctively either. Although the scope of those injunctions might be greater in some cases than others. But yes, you can only recover once, is true. But to the extent that one law gives you more coverage, you're not getting coverage more than once. So if one law said you're entitled to triple damages and the other law said you weren't, and you qualified for both, then you're entitled to triple damages. That's not recovering more than once, right? If both laws said you get triple damages, you don't get like triple. You don't do that, but yeah. So that's true. You can only recover once. That's true. But you can recover to the maximum extent that all the laws combined provide. So if you're entitled to more damages under one law versus the other, then you're entitled to more damages. But yes, whatever your maximum level of injury is the maximum entitlement. That is 100% correct. The IDEA Act is redundant? No, it's not redundant because it provides special protections unto itself. The IDEA Act is not redundant because it requires the schools to provide an individual educational plan. The ADA doesn't necessarily require that, right? I don't know what would be required to accommodate a disabled student. I don't know. I haven't really thought about it, but is an individual educational plan inherently what's required to accommodate a disabled student? Probably not. I don't know what other remedies there might be, but it's not necessarily the only thing that would be a reasonable accommodation. So I don't know in the abstract. Maybe there's a way to accommodate some disabled students or potentially all disabled students. Maybe there's a way to accommodate them with other than an individual educational plan. Maybe that could be done. But so the ADA doesn't necessarily provide you that protection. So it's not redundant because the ADA would only require you to do something. The IDEA Act requires you to do something more specific. So it is not redundant. And even if it were, it wouldn't matter either way. Great. Yeah, ADA is very broad past K through 12. Yeah, ADA covers basically all generic businesses, for lack of a better description. So it's a much more generic thing. And the remedies are more generic in their nature because it kind of has to deal with all cases. The IDEA Act is much more specialized. So no, it's not redundant. All right, let's read another case. This is fun. Are we having fun, stream? There's 1,200 of you watching. There were more of you watching, and now less of you are watching. There were closer to like 2,000 watching. Yeah, we are down like from 2,000. We've lost a lot of viewers since I started discussing Supreme Court. So I guess you guys are not interested in Supreme Court. Okay. So what would you guys be interested in me discussing? Are there other Karen Reed things you'd like me to discuss? Are there other interviews you'd like me to discuss? Maybe there's some motions I could discuss. Maybe I could discuss something else because you guys are not digging this. So let's see if there's something else we can talk about. Let's go to like free Karen Reed and see if there's some motions we can talk about. Let's see what we can do. Where is a listing of like all the motions and stuff that we can do? Verdict slip, we've already discussed that before. I mean, we could go over it again, but we could do the verdict slip again if that would be helpful. Let me pull that up. Oh, Lord. What did I just do? Okay. All right. Hold on. All right. Will this work? Yes. Okay, cool. All right. So here's the verdict slip for count 2. So the verdict slips for count 1 and count 3 are relatively simple because they're just a guilty and not guilty box for count 1 and count 3. So I assume you want to discuss the verdict slip for count 2 because that is the most complicated. I mean, the verdict slips for count 1 and count 3 are pretty simple unto themselves. We've sort of discussed this in some levels, but basically we've got 4 guilty options because we've got 4 lesser includeds, or I guess 3 lesser included. So number 2 is the top count, which is manslaughter while operating a motor vehicle under the influence of liquor, otherwise manslaughter while DUI. Right. So it's manslaughter while DUI, which is a specific charge in Massachusetts. So they have it's different states have different versions of manslaughter. You've heard about voluntary manslaughter and involuntary manslaughter, to be sure. Some states have multiple degrees of those. Some states have other things, but this state has a special statute for this. They have a special law called manslaughter while DUI. They passed a law specifically for that scenario. And so that's the top count. So it's manslaughter while DUI. So you have to prove that she's DUI and you have to prove the manslaughter. In this case, that she intentionally performed an action in a reckless fashion which caused the death of somebody is basically the short definition. So she intended to do something that was, so in this version, she doesn't need knowledge that John O'Keefe was there, for example, where she does for murder. So the difference between the manslaughter and the difference between manslaughter and the murder is in the murder, she has to know that there's a danger. And in the manslaughter, she only has to be reckless. So she doesn't have to know about a specific danger. She just has to be engaging in action that is reckless. So she doesn't necessarily need to know John O'Keefe is there. She just needs to know that, driving backwards 25 miles an hour at night, in the dark is a really, really dangerous thing to do, which it is. So, I mean, then of course the death occurred as a result of her actions. So the collision still needs to happen and it still needs to die. But in this scenario, it was just reckless. The scenario here another scenario that would be similar would be just like a child, running out into the middle of the street, because if you're driving backwards at 25 miles an hour at night, while drunk, that's pretty dangerous. And so maybe you don't know there's anyone nearby, but if a kid just randomly darts out into the street and you hit them, then that's manslaughter because you were engaging in reckless action, namely driving 25 miles an hour backwards in the dark at night. So as long as you believe that's reckless, which, kind of is, then you're there. And then the kid dies and, Bob's your uncle. So for the top count, that's what you need. She needs to be DUI and you need the intentional conduct. She drove backwards intentionally in a reckless fashion as opposed to knowing, and death occurred. So that's pretty easy unto itself. And then, as to her being under the influence, as to being DUI. Is she DUI because she was under the influence of liquor in a general sense, or is she 0.08 or greater? So presumably the easiest way is to just check the influence of liquor, because proving 0.08 specifically is a little tenuous, but proving influence of liquor a lot easier under this fact pattern. All right, then you have a lesser included of involuntary manslaughter. Well, since the top count is manslaughter while DUI, manslaughter by itself is lesser because it is under it, because it's less things. So here you don't need to prove she's drunk. Here you just need to prove that she intentionally engaged in the conduct in a reckless fashion that, you know, in which death occurred, basically. So you just need to prove that. You don't need to prove she's drunk. So that's pretty easy, I think, as it goes. Then the next count below is motor vehicle homicide, in which case you have DUI plus negligence. So here you don't need reckless conduct, you just need negligence. So that is why it's lesser, because negligence is lesser than recklessness. Negligence is just any failure. Negligence is duty, breach, causation, and damage, right? I have a duty, I breached the duty, the breach of my duty caused harm, and there was harm. That's negligence, right? So negligence is basically your run-of-the-mill standard auto accident. You know, I wasn't paying attention. I didn't, you know, I was, you know, just whatever. I was like looking at my phone, or I was distracted, or, you know, whatever. It's just your run-of-the-mill auto accident. You know, almost all auto accidents are negligence. It was because of some failure by you, the driver, the accident occurred. Usually, right? It's possible for it not to be. You know, it's possible that some freak thing happened that isn't your fault. You know, because duty doesn't require perfection. Duty just requires you to behave the way the reasonable person would. So it just requires you to operate your car like a reasonable person. So if you did that and an accident occurred, there's no negligence. But most auto accidents are negligence because the driver or the person caused the accident usually did something. So you just need standard negligence, but you also need DUI. And so that's lesser included, right? So now you just have a death. So you have a motor vehicle homicide. The death occurred as the result of a motor vehicle specifically while DUI, and she was engaged at least in simple negligence, which, you know, that's pretty easy. And then you also have just DUI by itself as the last count, you know, which just means that she was driving drunk, not that the collision happened, right? And so for each of these counts, you know, they are different crimes. And they're all lesser included because they're all included within the greater. They are all lesser because they have all the elements that upper one does. They're just missing something. So they're all lesser because they have all the elements that the top one does minus something, and they don't add in anything new. So they're all lesser included. And so that is the jury verdict form explained. And so the jury is supposed to check one of these 5 options, right? Just not guilty of anything or guilty of one of them, right? Because they're all lesser. So, you know, 4 includes 5. Well, I actually don't know if that's true or not, but let's press on. But like they're all lesser. So, you know, check one. So that's all easy. Yeah. So I don't know if there's a lot more for me to say about that. If you have specific questions about it, I'm happy to discuss it. The only other thing that is worthy of discussion is that they don't need to charge DUI like when it happens for the exact same reason they don't need to charge any other crime when it happens. You know, they have to bring charges within a certain period of time, you know, statute of limitations, and we could look up what that is. But they were always charging DUI, right? So because DUI was included in the top count, right? It's manslaughter while DUI. So they've always been charging DUI because that's true, because it's a lesser included. So they're not adding DUI. DUI was always there the whole time. It was implicit. So, but they don't need to charge DUI the same night it happens for the same reason they don't need to charge any other crime the night it happens. So And they don't necessarily need a breathalyzer or a blood draw to charge DUI if they can prove it some other way, right? So they don't necessarily need any particular evidence to charge DUI. They just need to be able to prove it beyond a reasonable doubt. And in this case, they've attempted to do that through blood taken by the hospital and also through counting drinks and also Karen Reid's statements. So that's how they've attempted to prove it. And, you know, whether or not that convinces you or not, sort of up to you, but it's legally sufficient, to be sure. There's legal sufficiency for DUI without breaking a sweat. So if you buy it or not, it's up to you, but it's easy enough. The maximum time for the DUI is 2.5 years under the statute. In terms of what she would get, we could look at the sentencing guidelines, which I suppose we can do. We can find the sentencing guidelines and see what they would say. I thought the defense add out the DUI. Yeah, that's my understanding. The defense added the DUI. That's my understanding. They asked for it. So let's see if we can find the, oh Lord. Okay, this is going to take a moment, isn't it? All right, hold on. All right, so let's navigate together. This is going to take a hot second to find it. Give me a second. Oh Lord. Okay, so this gives all the crimes. Okay, so this gives all the crimes. So I'm looking for, what do they call it again in this jurisdiction? They call it operating under the influence. Fine. All right. Let's see. Find. No. Mini mine list. This is okay. Oh Lord. Talk amongst yourselves. Let's see if, how about master crime list? Do I need to Google that? Is 2018 the last version of this? It looks like it might be. We'll go with 2018 and see if that gives us the answer. Okay, it's operating under influence of liquor. First offense, I suppose. So possible starting offense labels 2. Is that the right thing? 2? I'm going to go with 2, I guess. It looks like it. Operating under the influence of liquor. Yeah, I think 2 is where I'm looking for. Okay. All right. So criminal history score, locate a proper grid. Okay. Let's see. Discretionary zone, incarceration zone, blah, blah, blah. All right. So let's look at the grid. Okay. Sentencing guidelines grid. Okay. These are just examples. So 2. All right. So we're in 2. Okay. And we have no record. So intermediate sanction zone. What the fuck does that mean? What is an intermediate sanction zone? Kurt is not looking at anything legal. He absolutely is looking at something legal. What the fuck? Go up in the same document they explain it? Okay. No, they don't. There is no up. It's only one page. There is no explanation. Great. It's between the easy and hard. Yeah, that's great. On the site? Okay. Intermediate sanction zone. The sentencing guideline grid contains a zone where only intermediate sanctions are within the zone. To impose a sentence of incarceration upon a defendant whose crime and criminal record falls within the immediate sanction zone, a judge must depart from the guidelines. Well, what's an intermediate sanction? That doesn't help me. Where only intermediate sanctions are within the guidelines. Well, what's an intermediate sanction? That provides me no further information. An intermediate sanction is an intermediate sanction. Thanks, that's great. It means no incarceration? That's the definition of it? I don't think it is. What is an intermediate sanction? Intermediate sanctions are imposed as a condition of prohibition. That doesn't really help me much either. Is anyone going to define for me at any point what an intermediate sanction is? No, they're at no point in the sentencing guidelines going to tell me what an intermediate sanction is. That's great. Go to the Real Actual website. I'm on the Real Actual website, Jules. First of all, I'm doing my best, okay? I'm doing my best, okay? All right, I'll tell you what. You just tell me what to do. Just tell me exactly where to go and tell me where the information is. Where do you want me to go, J.E. Walsh? Just tell me. Just tell me. Okay, I'm on mass.gov. Where do you want me to go? Just give me the fucking answer. What do you want me to do? Chill out. Fuck you. We're waiting for J.E. Walsh. She's going to tell me the answer. Back out of this, okay? All right, now I'm on this page. What do you want me to do? We're all waiting on you. What do you want me to do? You put the answer in staff chat? Okay, let's check staff chat, see if it gives me the answer. Where the fuck am I? I'm on mass.gov/info-details/sentencing-guidelines-step 5-chapter-5 is where I am. Where do you want me to be? Please go here. I can't accept links in chat. There are no links accepted in chat. Look in Discord. I'm looking in Discord. I'm looking at staff chat. I don't know where you're getting this information from. I'd like a definition from Massachusetts would be great. You're giving me sites from other websites. I don't know what it means. To get to a computer? You need 20 to get to a computer? Okay, then you're of absolutely no help to me. All right, well, thanks anyway. All right, so we're going to go back to trying to find it myself because that's of absolutely no help to me, but thank you anyway. All right. Sending the link on Twitter. All right, fine. Waiting. I want the definition from Massachusetts. I want their actual definition. It should be available from their website somewhere. That's what I was Googling, but I'm just waiting now because apparently I wasn't doing it right. All right, laws, general laws, partial. Okay, let's take a look at that citation, see if that gets me anywhere. Let's see. Section 3. General laws, part 3, title 1, chapter 211. 211E, section 3. It says the commission can establish what they are, but it doesn't actually define them. It gives examples, but it actually doesn't define what they are. It just says the sentencing commission can define them. This doesn't provide it. 211F. Okay, what section of 211F? Section B of what? Waiting. Section 1 definitions. Okay. Intermediate sanctions program. Any program which has been determined to impose an appropriate sanction upon an offender whose imprisonment may or may not be necessary, whose imprisonment may not be necessary or appropriate, including but not limited to standard probation, intensive supervisory provision, community service, home confinement, weekend jail sentences, day reporting, residential programming, substance abuse, restitution, means-based fines, continuing education, including but not limited to changing lives through literature program, administered by a trial court in University of Massachusetts at Dartmouth, vocational training, special training, and psychological counseling. Well, at least that's a fairly suggestive list. So that gives us at least some ideas. So I'm done with this, and we can move on to other things. So the judge can impose things like that, I suppose, is what the sentencing guidelines say, if I'm reading them correctly. Because she has no criminal history score. She has no criminal history score, and therefore, and it's a first offense. So, and it's level 2 if I read it correctly. So she can impose those kinds of things, it seems. 180 days, where are you getting 180 days from? It wasn't on the list we just read. Where are you getting that information? Have I reviewed Sandra Birchmore? No, I've not. It wasn't in the list we just read. Where you just sent a link and screenshot. Okay. Where? On Twitter? You tagged me on it, I guess. Mentioned. Okay. Alcohol and drug suspensions for over 21 years of age. I don't know how any of this is relevant to what we're discussing. Under the Massachusetts law, they will suspend, revoke your permit or right to drive after receiving notification of conviction. So her license will be suspended for some period of time. It looks like first offense. So her license will be suspended for a year, and she has to complete some sort of alcohol program. Okay, noted. All right, so there's that. Southern Golden for $9.99 said, off topic, what's your email and how much would you charge to give a crash course on constitutional law? Well, my email is available on my contact page on YouTube, and also on my link tree. How much would I charge to give a crash course on constitutional law? Maybe an in-person course. I don't know. I suppose it would depend on the. Did they change the form? Oh, they had a suggestion where they changed the operation of it. Oh, that's fine. Yeah, I don't know what I would charge for a course. That depends. A overview of all constitutional law would take quite a long time. And to put together a course would take quite a long time. I don't even know what a reasonable amount to charge would be. I suppose I could just charge $300 an hour, and then that would be a reasonable rate because that would be a fair rate for an attorney. So $300 an hour, I guess, because that's what I'm asking for my standard rate. So I guess $300 an hour for as many hours as you wanted, and that's, I guess, what I would charge. So that seems like a reasonable rate. Okay. May you never need an attorney. $300 an hour is pretty cheap, incidentally, by the way. Yeah. So. So anyways, it looks like there is no possibility. It looks like sentencing is not recommended. And as to the 180-day thing, I still don't know where you got that information from. It wasn't in the link you just provided. And I'm not spending any more time just chasing links from J.E. Walsh. I'm not chasing links from you all day. I've given you enough of my time. So I'm moving on to other things. All right. It's cheaper than law school? Okay. All right. Well, I guess what do you want to learn? And we'll start with that. But yeah. All right. Well, if you want to learn constitutional law, then I guess send me some money and I'll send me an email. Send me an email and I'll send you back payment information. Um, and I'll charge you accordingly. All right. Anyways, let's discuss another Supreme Court case. No, let's not discuss Supreme Court cases because young guys don't like that. And I'm down to 1,000 people watching, so I'm continuing to lose viewership. So, yeah. What else should we discuss? I'm open to suggestions. What else should we talk about? Are there other things for us to talk about? I mean, I was going to look and see if there were other like motions from Karen Reed that we could discuss. So I was going to try to find if there were like other things going on there. You can't send me a message on Twitter because you're not verified. Well, that sounds like a real fucking problem. But you can send me a message on Discord. So you can contact me on Discord. And I still don't accept DMs, but you can leave me a note in general and that will be fine. Where'd I go to law school? Akron. Does Trump have the authority to deploy National Guard? I think so, yes, but we haven't really gotten into it. It requires a more complex legal analysis. Someone in chat says there's a verdict. Let's see if we can find any information relating to that. The things under documents in Discord? Okay. It doesn't look like it. I mean, yeah, there doesn't no one in the chat of like long crime or something are saying there's a verdict. So I don't think there's a verdict. I don't think that's true. If there was a verdict, there would be a lot of discussion relating to that. So I don't think so. I'm doing a good job. I'd like to think I was doing a good job, but apparently J.E. Walsh was unsatisfied with what I was doing. Sun's over your right shoulder if you look from the left. I don't know what the fuck that means. Castro put suggested new verdict shift in Discord chat. That's cool. Let me give you a second to pull that up. Let me go to documents. Can't paste it for some reason. You can't paste it because YouTube doesn't allow links. That's why. That's why send it on Discord, because you can send links there. We don't allow links on YouTube is why. You're dying? I'm sorry. Here? Okay. Yeah. Hold on a second, please. Yeah. So here was the defense's recommended jury slip. I'm not really sure this is any cleaner, to be honest, or any better. I don't know what difference it makes, to be honest, to have it this way versus the other way. But this was the defense's suggestion. I don't know that it makes any difference, but whatever. I don't know if this is any cleaner. To be honest, but whatever. YouTube won't let you because I don't allow links in YouTube is why. We don't allow links. That's why. It is disabled. But you can provide links in Discord. That's why. That's why we have Discord for talking and stuff. So you can send things. That's why it exists. That's why the Discord is there, is to have things so you can talk and shit. Thank you for the gift memberships. All right. Were there other documents for us to discuss? Let's take a look. Where's my document links? Okay. There are no documents otherwise relating to this case other than the proposed slip, so there's nothing there. Why weren't the parties allowed to state what grounds they had for objection? I don't know. I don't know why they weren't allowed to even state the basis of the objection. I don't know. Seems like a very strange way to run a courtroom to me. I don't get it. Yeah, it doesn't look cleaner. Yeah, I don't really think there's anything in it. I don't really buy that it's really any better. So I don't buy it. Yeah, people were leaving during Supreme Court analysis. They absolutely were. Yeah, we lost a huge swath of people when we moved on to the Supreme Court. So people don't like that. I don't know why, but they don't like it. I can't make them like things. They say the customer is never wrong in matters of taste. So if you guys don't like that particular flavor, I will try to give you something else you do like, because you guys don't like Supreme Court. I think it's interesting and amazing and fun, but I guess a lot of people don't think it's interesting and amazing and fun. So I'll try to give you something else that you like. Just play reruns of Turtle Boy. You know what we could do is we could just watch the interview with Ronnie. We never really watched it completely. We never watched it to its full. So we could watch that and become very frustrated. That's something we could do. It's just dry. Yeah, fair enough. I mean, that's, if you find it dry, I understand. Melanie Little has 32,000 people watching her, and I've got 1,000. So we're doing something wrong. So let's see if we can find those views somewhere else. Supreme Court reviews may be too esoteric, I guess. I mean, I guess it is. All right, let's watch this bullshit interview with Ronnie the juror, who is a piece of shit, and I hate him. Let's watch this bullshit interview.
Doing
good, thanks. How are you?
good. Thanks. Thank you for coming on. I appreciate this.
No worries.
Yes. So yeah, you were stuck behind a plow. I heard on your way in there. Wasn't Lucky Locker?
Yeah, of course.
It wasn't Lucky Locker, was it?
Yeah, I mean, the snow, right? We're trying to beat the system, right?
Well, let me start off with that, right? There's actually an interesting video that I just saw come out that somebody took driving by 34 Fairview Road, and I want to have you visited 34 Fairview Road, obviously, on like the first week of the trial, right?
That's correct.
What were your thoughts when you saw 34 Fairview Road and the car parked outside, in the lawn? What did you think of the whole scene there?
It was surreal. I think it was very interesting to be able to see the atmosphere. It would have been nicer to see it in a little bit more with some snow, just to see what would that look like. But we were trying to observe the area and the environment at the time.
Well, funny you should mention that. So this is people love to do this. This is what somebody just drove by like an hour or two ago, 34 Fairview Road. And this is the perspective that 7 or 8 of the witnesses would have seen. And then John's body, of course, was later found right about here. Okay. And let me just ask you something right now, right? So they want us, the prosecution contends and the prosecution witnesses contend. I believe it was Matthew McCabe, Jennifer McCabe, Julie Nagel, Sarah Levinson, Brian Higgins, and 2 other, Caitlin Albert and Tristan Morris. They all drove directly by this spot while it was snowing at like between 1 and 2 in the morning. Every single one of them says that they didn't see a body on the front lawn right there. If you had seen this visual during the trial, would that have made it harder to believe that they couldn't, if a body was there, that they wouldn't have seen it?
Yeah, I mean, it was very interesting because there were no pictures of what the body looked like at the time, right? So nobody took pictures of before they moved the body or moved the patient. We don't know what it really looked like, but looking at that, it's kind of hard to believe you can't see anything. But again, it's hard to say that you couldn't see it, and it's also hard to say that you could. I mean, it's all speculation in that respect, but it'd be hard, somebody who's that large, to not be able to see something there.
Right. So when we talked before, you said that you were one of two jurors who wanted to ask the Judge Cannoni, about whether or not you were, first of all, do you confirm that it was a 12-0 vote for acquittal on murder and leaving the scene of an accident?
That is correct. So that was what the entire group agreed upon. That being said, it was confusing because we didn't have very clear direction on if it was all or nothing. In other words, if all three convictions had to be 100%. So that's why the response that it was that we were continued to need to deliberate because it was not clear on that one charge. So the one charge that we were not very clear on and not everybody was in agreement with was essentially the manslaughter charge, involuntary manslaughter. So that was the one that we were not clear on. But the other two charges, which was essentially second-degree murder as well as leaving a scene of an accident, was very clear. We all 12 agreed that was not the case. Right. So,
right. And when did you guys start voting? So the first day you guys went and deliberated, it was closing arguments, right? And then you had like half a day there to deliberate. And then you came back, I don't know what day of the week it was, but you came back the next day, you had a full day of deliberations. When is the first time you guys took like a tally? And like when you said, okay, did you guys start with that? And did you say like, let's see where we stand right now? Or how'd that work?
I think we wanted to read essentially the first day. We kind of took it all in, and after that, then we started to do a vote. We clearly didn't have a timeline, or I can't recall exactly the exact timeline on when we first decided on some of those essentially convictions. However, it was very clear that each time we made a vote, we wanted to make sure that we read the charges. So very clearly read the charges in.
All right. So now I have a copy of the defense's motion relating to the jury slips. So let me pull that up real fast and discuss it for what value it has. Give me a second, please. It's very short, so not a lot here, but we'll discuss it for whatever value it has. All right. So here's the motion that was sent relating to the verdict slip that we saw with the change in the format. Defendant's motion to amend verdict slip. Now comes the defendant, Karen Reed, to request the court modify its jury verdict slip from its current form. Ms. Reed submits that the proposed amended verdict slip improves clarity for the jury in understanding its task in reporting the verdict. The current verdict slip, particularly slip for count 2, risks confusing the jury and causing errors. Respectfully, the present verdict slip is unclear and otherwise confusing. Lack of clarity and resultant risk of confusion error can be easily minimized by tailoring and clarifying the verdict slip to better aid the jury in memorializing its verdict. Indeed, there's no compelling reason not to. Specifically, Ms. Reed proposes the court uses the verdict slip attached as Exhibit A, which presents formatting changes, though no substantive changes to the verdict slip. The jury has started deliberation, does not preclude amendment. Indeed, the court amended jury slip in Miss Freed's first trial while deliberating. And then the judge wrote, after review, the motion is denied. The verdict slip is consistent with Massachusetts law and is viewed in conjunction with the jury instructions. A copy of the jury instructions was sent to the jury with the verdict slip on Friday, signed judge. So that's what she said. I don't think that the defense's preferred version is really much better than the other version. There are definitely verdict slips that could be a lot cleaner, where they actually spell things out a lot more clearly with much clearer instructions. So there's definitely clearer versions of verdict slips that have been done that spell things out more laboriously, but we're not doing that over here. We're doing simple. And I think that the verdict slip we have is fine compared to the alternative. I think it's fine. I don't think the alternative is really any better. So, fair enough. Back to the interview.
Understand the charges each time.
So to believe that Karen Reed was not guilty of murder, that means that none of you, even if they thought that she did it for some reason, not a single person on that jury thought that she did it on purpose, correct?
That is correct.
Okay, so the whole motivation with about the Aruba trip with the Sullivan girls, and she's all angry. So that didn't really play well with you guys. That wasn't convincing.
It wasn't convincing. No.
Okay.
And there wasn't enough evidence for one way versus the other, but clearly not enough evidence, or there was doubtful evidence. So
okay. So you guys were hung on that second charge, and I believe the count, correct me if I'm wrong, was 6-6, right, for a bit, and you were one of the 6 for not guilty on manslaughter initially, correct?
Correct.
And then came the Tui Rodriguez charge, and that's kind of like a, come on, guys, you gotta give it your best shot, get back in there. And then that's when things. What was the atmosphere like in there? Was there bully sessions going on? Was there people trying to urge people that, come on, we got to do this for the O'Keefe family. They deserve some sort of justice. We got to do something. What was it like in there?
It was deliberations. So clearly, one of the things that were happening is we were trying to examine all the evidence and looking into holes for the case, whether on one side versus the other. And ultimately, that's what led to some people swaying in one direction, and then some people remaining and standing their ground. Some people essentially remained and stood their ground the entire time. And
Court TV says jury's coming back. Okay. Well, I don't know why they'd be coming back necessarily. It's lunch, or yeah. Well, if they've just had lunch, it makes sense. It's surprising to me. It is surprising to me, but it seems like there's a lot of verdicts like just after lunch. For whatever reason, man, juries seem to really want to get that free lunch. It happens enough that it's kind of amusing. So if they like just finished lunch and that's why they're turning in the verdict form, that would be somewhat true to form, and it would be somewhat funny. It's like, I gotta have that free lunch, man. I'm only getting like $50 a day anyway, so I gotta get that free lunch. I'm definitely getting my free meal, man. So it's 1 p.m. Eastern time. So heaven knows when they got their free meal. But if they just finished their free meal, or they're in the process of having their free meal, they're like, yeah, we're done. That'd be funny. That'd be very funny. Yeah, man, that'd be really funny. Man, we'll come back. Right now, nothing's happening. We'll come back if it does, though. That'd be good.
I think that was. I think it's important to see that. In terms of the justice system and having this 12-panel jury. I think it would have been one way or the other if it was left to a very small group or only a few individuals. But given the circumstances that it was left to 12 individuals that have to ultimately come up with the same decision, I think is a very good system as it is.
So what
So-
got so it's a couple people changed their mind though. So there must have been some leaders in that room. Have you ever seen the movie 12 Angry Men?
Yes.
It's a classic. So obviously in that movie, Henry.
It is one of my favorite movies of all time. It might be my favorite movie of all time. And it might, if you had to ask me what is the best movie of all time, I think 12 Angry Men might be the best movie of all time. It is so fucking good. It is so fucking good. A lot of, because it's just simple. I actually thought about, can we actually play it on stream without getting copyright struck? If we could play it on stream without getting copyright struck, I'd play it and watch it with you because it's so fucking good. It's such a great movie. I love it so much. It is 98% of the movie happens in one room, the jury deliberation room, right? It's 12 people and all they do is talking. All they're doing is talk. Well, yeah, basically, there are no special effects, right? There are no special effects. It's one room. The way it's shot, the way it's done, the characters, it's so fucking good. It's so good. You know, like the cameras and the angles and the characters and everyone. It's so fucking good. Love the movie so much. Num, 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 num.
Fonda is very convincing. He has a strong personality, and he's able to sway 11 angry men to come to his side. So surely, the vote was 6-6, and then it went 9-3 for guilty. So I'm guessing there must have been some dominant personalities in that room. And who would you say that? Would you say the foreman was one of those, and an engineer? Is that correct?
I think a lot of people were strong in that room, in that they were opinionated, and based on their opinions and their level of expertise and what we were given in terms of evidence, that's how we ultimately arrived at that conclusion, or each individial arrived at that.
Okay, I was going to say, you guys didn't come to a conclusion because you hung.
Correct.
And so it was 9-3, and you kind of wavered a little bit, right? They convinced you one way, and then like what you told me last time was it was 9-3, and you were kind of on the fence, and then you kind of came back, and there was 8-4. Is that an accurate depiction of what happened? Would you say it ended in 8-4 for guilty to not guilty?
That's correct.
Okay. And you, correct me if I'm wrong, you told me that you and one other juror wanted to ask the judge, Judge Cannoni, whether or not you were allowed to acquit on two of the charges and hang on the third, and that the foreman said, no, we're not going to do that. We have to decide on, it's all or nothing.
So it was not a question of whether we can acquit. It was a question on, can we make decisions on each individual conviction independently of each other
individual charge,
versus,
yeah.
So that was the question. It wasn't necessarily.
Right. So acquittal, conviction. Yeah. So but you wanted to ask the judge, are we allowed to come to a decision on two of the charges and hang on the third? And the foreman said, that's not going to happen. No.
And it wasn't necessarily just the foreman, but there was a bunch of other opinionated individuals also kind of saying that, no, I think we have to look at it as a whole as opposed to independent. But clearly the person who was in charge at the time was the foreman. So his word or their word was more pronounced.
So those notes that he would write, were those group efforts, those notes, or they were well written. Obviously, a lot of people have talked about those notes, and the SJC in particular looked at those notes, and he used the word charges plural, and that was a big the SJC cited that a bunch of times. He said that we are deeply divided on the charges, he said. And did you guys come up with that note together, or did he write that himself, or did ChatGPT write it? How did that get written?
It was written by the foreman with in collaboration with all the other jurors. So we all looked at it. We all kind of accepted it as such. Again, it was one of the questions that we wanted to ask the judge was, for clarification on can we look at these charges individually? But ultimately, that kind of question was put down, and essentially we had no choice but to just, again, based on the group, right, or majority rule, to say that we were just going to ask one question, or it's an all or nothing scenario, as opposed to can be treated individually from each other or independently from each other.
A lot of people would say that if they were in that situation and they were not being allowed to talk to the judge, they would say, well, too bad, they would make a bigger stink about it. How did you feel about that? Do you feel like after this happened, do you feel badly for Karen Reed that, you know that she was acquitted, you were in that room, you guys all voted a bunch of times, and if you had just known, if it had been communicated to you better, if, you're not, the whole thing was just seemed like you're not professional jurors. That's the way one of the jurors put it, is like, I'm not a professional juror. It's my first time doing a murder trial. I don't know how this works, but I know we acquitted her, and this seems like a technicality. Do you think Karen Reed got the shaft?
Yeah, I think it's totally unfortunate because we just weren't well informed. And you're right, we're not professional jurors. We don't know how the law works. And it's kind of sad that, or unfortunate that we don't have that kind of view from an individual. So if we're in law, we would know how it's supposed to work. But from somebody who's new to becoming a juror or being a juror, we wouldn't know how the system really works. Mm-hmm. So it was very unfortunate circumstances.
Yeah. So just random question. I have so many questions, obviously, but one question is, you're obviously of Asian descent, and during the trial, there was one point where they were reading Matt McCabe's text messages out loud, and David Yannetti was cross-examining him, and he was reading them. And Matthew McCabe said something about like the Asian house. And I thought that was, I knew there was two Asian members of the jury. And I'm like, I wonder if they did that on purpose. Did that come across to you as at all offensive or anything like that? Him calling it the Asian house next door?
I think borderline kind of, I think it's borderline kind of offensive, but I don't think of it as offensive because I was born and raised here. So I think I looked at it as just somehow a descriptor, but I can see how some people would be offended by that kind of terminology.
Well, I think I think the defense was hoping you would be offended particularly by that. I think that's why they had him read it, is because he called it the Asian house. And I wasn't in the courtroom for that one because I wasn't allowed to be in there when Matt McCabe testified, but so I didn't get to see the reactions of the two Asian members of the jury.
Yeah.
So I wasn't sure if it landed or not, but you were there on obviously the closing day of closing arguments, and Brian Albert, Colin Albert, and Jennifer McCabe walked into court and sat with the O'Keefe family, and just the way they were positioned, they were staring directly at you. How did you feel about that?
It was a little intimidating and I say intimidating, it was just at the end. I think we're all at that point where we want this to have some closure. And I think it was slightly intimidating to see everybody there and all the players there, to some respect. I wouldn't say so much that I was fearful, but intimidated by everybody staring at me, right? So, or looking at me, and I say me, but it really is the group, 14, right? The jury. Yeah,
all 15 of you that were up there and sat through 3 months of this, and you didn't get paid. I mean, they didn't really pay you for this, like $50 a day or something you got?
Yeah, some small amount, yes.
So you gave up all this time, and God bless you, because it was hot sometimes in that courtroom, and it was a lot of the testimony was incredibly boring. I lived for this shit, and even I was bored by some of it. And I looked, and sometimes jurors were falling asleep because Adam Lally can just put you to sleep sometimes. How do you feel about the fact that you gave 3 months of your life to this, and ultimately the result was nothing.
I feel that we kind of failed the system in that we were charged with this responsibility and we came up with certain decisions, but at the end, it was not kind of looked at or taken into consideration in terms of some of the charges. And I think that was a failure of the system, and it is a disappointment. But that being said, I think it was a very good learning experience to be able to see the justice system. I wish that it had worked out for everybody and there was closure all across the board. But right now, there's no closure for the O'Keefe family and for the Reeds, right?
Yeah.
So there's nothing there.
So you are an EMT, which is such a unique job, particularly for this case. And at the scene, the EMTs were the kind of the first people to testify. And they think they interviewed like 8 or 9 of them. And 2 of them, no, I apologize. 3 of them testified that they heard Karen Reed say, I did it, I did it, I did it. If you came across a car accident or something like that with a dead body on the road and there was a woman screaming, I did it, I did it, I did it, would you tell the police what she said? Like then and there, and this woman's confessing to a crime?
I honestly would focus on taking care of the patient and not necessarily focusing on that individual. That being said, if that individual was my patient, then obviously I would need to disclose that information to law enforcement. But at that time, if my patient was Mr. O'Keefe, then I would focus on Mr. O'Keefe and his resuscitation first and foremost.
To be focusing on John O'Keefe's resuscitation. Yeah. So when they got there, the ambulance got there. They were there for about a couple minutes trying to resuscitate him, and then they immediately put him on a gurney, put him into the ambulance, and got him out of there. And you must have come across fatalities many times, I'm guessing. I mean, God bless you. I don't know how you guys do it, but I'm assuming You've seen too many dead bodies. When that happens, you've come across car accidents, I'm assuming, many times too?
Yes.
Okay. So what is the protocol? Like, what would the protocol in a situation like this be? Do you think that the police and the first responders handled this in a way that you would expect it to be handled? Like, not as far as not putting crime scene tape up or anything like that?
I don't think it was as coordinated as it should be. And I don't know if that's a fault of necessarily each individual or a problem with the system, in that maybe they didn't have the proper training or they should have asked more resources to actually make sure that it was done well. But I have to admit, it does not seem like it was done well in any way, shape, or form.
So, are you qualified to look at, like, a person's body after they're deceased and determine cause of death? Is that something you're familiar with as an EMT, or is that not something you're trained to do?
That's not my forte. I'm not necessarily, all I know is based on what is provided to me in terms of evidence, but I'm not in any way, shape, or form a educated person on pathology.
Well, luckily, there were 2 experts provided by the federal government from a company called ARCA that testified, 2 doctors, and they were the last 2 witnesses to go. And they both testified that, according to the physics, the science and the physics, the injuries to John O'Keefe are not consistent with being hit by a car, and the damage to the vehicle is not consistent with hitting a pedestrian. And so those guys are, doctors, PhDs, they do this for a living, etc. And in order to find Karen Reed guilty of manslaughter, you have to listen to the ARCA experts and say, I don't believe them. So how did 8 jurors reach the conclusion that those guys didn't know what they were talking about?
It was as a direct result of the Karen was there at that time, and John was there at the time, and it was believed that John died there, therefore, right, at that location, and therefore it seemed like, and everybody, all the witnesses were suggesting that he was never inside the house, and as a direct result, the assumption, or if you connected the dots based on the evidence that was provided to us, it seemed like there was some sort of collision with the car, and therefore there was damages to the vehicle. And with the damages to the vehicle, and that both individuals were there and present, that the cause must have been, or somehow some sort of involvement by Miss Reed. So that was how they all arrived at.
But how did they reconcile? Was the ARCA testimony brought up by the people that thought that she was not guilty? Did they? I'm sure somebody in that room must have said, but these experts are telling us that that's not possible. And what was the answer to that? Like, did people say that these guys are bullshit artists, that they're fake doctors? Like, what was the reason not to believe them?
I think the major rebuttal was, we don't know. And that was the other thing. It was very ambiguous on why these individuals were testifying. And so there was a question in the group on their essential integrity, in terms of, were they there as a direct result of somebody else trying to steer us in a different direction and confuse the jury. So it wasn't sure if it was insurance. It wasn't sure if it was, whether the Reeds were doing it, somebody else was doing it, or yourself was doing it to bring this group to try to testify so that it would sway the jury in one direction or the other. And that, I think that was one of the things that was, again, unfortunate, because I guess it cannot be said, or didn't want to be revealed to us on what were the circumstances of why those individuals were testifying, other than they were testifying for the defense.
Because now, obviously now that the trial's over, that they're not even defense experts, they're FBI. They were available to both sides, and only the defense called them. But it seems like the conversation in the room went, and they said, some people were suggesting maybe they were the insurance company, of course, because of course an insurance company would benefit from not having an automobile collision. Obviously, they wouldn't have to pay anything out. Or me, how did people thought I paid the ARCA guys? That's wild.
Like anybody, somebody was trying to, again, to try to sway the jury in one direction versus the other.
I'm not that powerful, I promise you. I can't afford those guys. But so that's basically the reason that they came up with. They said they heard all their testimony, and then they said, nah, those guys are just probably paid off by the insurance company. We're going to disregard everything that they said.
And one of the other reasons is because there was the other testimony of the individual from the dog bite expert, and all of the other things that the defense was trying to bring up, that again, wasn't sure if it was just to try to confuse or sway the jury in one direction versus the other, or create a jury which was created reasonable doubt, and therefore the vote had to be in one direction versus the other.
So it sounds like what you're saying is that some of the jurors in the room were saying that all of this defense third-party culprit thing, a dog biting John, this is all bullshit. This is all a smokescreen, and all these people, this dog bite expert they're bringing in, this is all a distraction from the fact that Karen Reed ran John over. Is that an accurate portrayal of what people were saying in that room?
That is correct.
Wow. Okay. So in order to believe that Karen Reed killed John O'Keefe, you have to believe that, and that John O'Keefe didn't go inside the house. You have to believe all of the McAlberts who testified. And so, am I correct in saying that they found the McAlberts to be convincing witnesses and truth tellers?
Correct. And I will say that that's to some respect, not only to say it's correct, but also to some respect, because there were some individuals who just looked at the facts. Again, the clear fact that Karen was operating a vehicle and drove the vehicle to that location, 34 Fairview.
Mm-hmm.
And then ultimately John O'Keefe lay at rest and died on essentially that address. And so everybody else is saying that he never entered the premises, therefore she must be at fault because he clearly did not just injure himself there. So
did anybody suggest that maybe the McAlberts are not being truthful, that maybe he did go inside? I assume somebody in the room, the not guilty voters, must have said that these people are lying, obviously. And what did people say to that? I mean, did some people believe at least that they weren't being honest?
I think the individuals who believe that she was not guilty was because of the mere fact that it was not adding up. So the injuries to John O'Keefe ultimately did not add up to the damage to the vehicle.
Mm-hmm.
And what ultimately injured him was, or led to his death, was a injury to his head, which was not very clear that that type of damage could have occurred on the vehicle, and there was no damages on the vehicle that would indicate that kind of situation. So for those who were skeptical, that's what they were looking at.
Yeah, the Commonwealth alleges that that his arm, I still can't believe they said this theory, that the arm was out and that the arm is what caused the taillight basically acted as a knife and just sliced his arm up and then caused him to spin and then land 30 feet on the grass. And the gash in the back of the head came from hitting the grass, which they said was so hard that it somehow caused a gash in the back of his head. People really believe that?
Yeah, this is a large reason why, like I've been predicting, like a 20% to convict. This is the thing that people tell. This is the thing where people say, "Oh, there's no chance to convict. There's 0%. What are you saying? There's no way." Like, this is the thing that these people are not factoring into the equation, right? There are jurors who think like this, or jurors who are just pro-police, or jurors that are whatever, right? So this guy is infuriating, but this guy might be on your jury, and depending on your luck, several of these guys may be on your jury, and depending on your luck, this guy might be, the loudest voice in the room and convincing people. And so this is a non-trivial factor that people are not paying attention to when they say things like, "Oh, there's no chance to convict." Why are you trolling us on civil? Why are you trolling by saying, "Oh, there's a 20% chance to convict"? Did you not see the evidence? Why are you saying that? This would be a larger reason why. This would be a large reason why I'm saying that. Right? It's like, this juror is not, it's like, this guy might be on your jury. Several of this guy might be on your jury. Yeah. This is how people act in the real world. This is sometimes what juries do in the real world. We give them all the instructions in the world about reasonable doubt and all the rest of it, and then they go and do this. Yeah. Well, welcome to reality, man. Welcome to reality. This is the reality of the situation, man.
Yeah, I don't think a lot of people in the room, some people who were experts in science, right, and physics, or have some knowledge of physics, necessarily believe that as the case, given the circumstances, that it was not very clear.
Mm-hmm.
But again, some individuals just believed at the just the circumstance that Karen and John were there at the same time, and John ultimately was killed.
And the text
Yeah, look at that face, right? Oh well. Oh well. Oh well. Oh well. Yeah, John O'Keefe was there. Karen Reed was there. Therefore, Karen Reed did it. Oh well. Too bad. Yeah. Yeah, I want to smack your smug ass face. Piece of shit.
stream data is what you mentioned to me a lot last time, and you said that was what the guilty people really stuck to was the text stream data. What was so convincing about the text stream data for them?
It was a combination of the speed, and suddenly there's an increase in speed and a decrease in speed, consistent with maybe somebody backing up. And so that, looking at that, was kind of convincing that she must have accelerated in a backwards motion. And then
even though that 24 miles an hour in reverse 62 feet thing, there was no time associated with that. It was measured in what's called key cycles, and they couldn't explain, like, at least they didn't say for sure, like, this happened at 12:32. For all we know, that event could have happened at another time or another place, because they didn't give us a time. But people were pretty convinced just based on that alone that, yeah, that's proof positive that it happened at that exact same time.
I think it was a combination of, again, the circumstance that both individuals were there. There's evidence of a broken tail light, the injury to John, and the injuries that John sustained. And then ultimately, that texting data was just another piece that indicated, yes, there must have been some movement. It was very interesting, though it wasn't very clear. And I think I said this last time, that it would have been nice to have somebody who is an expert in that, or somebody who has knowledge of that type of data from that company, right? From Lexus or whatever company, right? And to provide some information on if that can be accurate and what causes it to actually occur. So, for example, like I was saying, or I was thinking, like right now, as I'm driving home, right? My car could have slipped, and that could have triggered something, right, to suggest that maybe that will make a trigger that I'm driving kind of erratically. But it's not because of me; it's because of the ice and the snow on the roadway causing that to occur. Which we all know that during this time frame, that's the type of weather that was being experienced by Karen during, and all individuals, I should say, during this time frame.
So if the defense had an expert from Toyota or whatever that could explain, like, is there anything that could make it look like you went a certain velocity and you really didn't? Maybe your tires were spinning, maybe the RPMs were up. That would have been a good witness for them to call.
I think that would have been helpful. That was definitely would be a helpful piece.
Okay. Let's talk about reasonable doubt. Going back and listening to it all, you know, the defense gave you this story about what they think happened, how John O'Keefe went in the house, he was beaten up, and he was left outside to die on the lawn, and then Karen Reed was framed there after the fact. All right. And what I didn't hear much from the defense in their closing arguments was about what reasonable doubt was. Did you guys discuss what reasonable doubt was in the jury room? Was that made clear what that was? Because some of the things that you're saying right now is reasonable doubt. Even the arguments that Karen Reed, from the people that believe Karen Reed is guilty, they're making arguments for reasonable doubt. Did you guys understand what reasonable doubt was?
I believe we did, and that's where
I don't believe you did. I don't believe you did. Not based on what you've been saying. No, I don't think so, man. I don't think so. Not sure you understood that one. It's sad. We laugh so we don't cry.
where we kind of essentially got stuck is because I think that's why it ended up as a hung jury, is because we kept rehashing that second charge, in that some of us felt there was enough reasonable doubt and some of us did not. And not that we're trying to coerce anybody or try to convince anybody to vote one way versus the other.
But did they understand
but
what reasonable doubt was?
I think everybody had a clear picture of it.
I don't know, man.
That being said, I don't know if everybody wanted to vote in a particular way based on the reasonable doubt.
Now you've
Pause.
They didn't want to vote in a particular way based on the reasonable doubt. So if I parse that sentence correctly, everyone understood reasonable doubt, and some people believed there was reasonable doubt, but they didn't want to vote that way in accordance with the reasonable doubt. Is that what you're trying to tell me? Are you trying to tell me some people had reasonable doubt but didn't want to vote in accordance with that? Is that what you're trying to tell me? Great. That's great. That's fantastic. That's really great. That's good news. Fantastic. Yep. All right. Great.
Obviously were not sequestered, but you were like not supposed to go home and watch any of this, consume any of this. I don't know if other jurors were. I'm assuming if you weren't, and even if you were, you probably wouldn't tell me, at least not on the show. So assuming that everybody actually followed, that order.
Can I just take a second to say that this is the first time actually catching the YouTube thing on the screen behind me, the first time I've actually seen it, and where it says 150,000. Where it says it on the YouTube thing behind me. It says 150,000. Yeah, that looks good. I like that. It makes me happy. I'm sure it's said it before now. It's just the first time I've noticed. That pleases me. This is my smiley face.
They didn't read up about this case, et cetera, while this was going on. Do you think that, is it even possible for a kid? Like, how do you guys do that? Like, how do you go home every day and not turn the TV on and not have bias when it comes to this story during this trial?
So it was very interesting because we tried, or it was one of those things where you do what you're asked. And
if you did what you were asked, we would be having a much, much different discussion. I don't know what we can do. This is the frustrating thing. This is one of the frustrating things to me as a lawyer. And it's got to frustrate other things too. It's like, what can we do as a legal profession to get people to understand this? I don't know. Reasonable doubt has been the legal standard for I don't know how long. It has been a hot minute. I'm not sure when we invented the concept of beyond a reasonable doubt, but it's been a while, right? It's not exactly new when we invented beyond a reasonable doubt. So, I don't know what we need to do. You would think at this point it would be baked into everyone's understanding, but apparently not. And then the lawyers spend, and the collective, the collective courts have spent oodles and oodles of time trying to figure out how to explain this in detail. That's why we have the jury instructions and why they're so laborious, because we have to explain it so many different ways, because people keep finding new ways to make things. This is why we can't have simple things, because they keep trying to find ways we keep trying to have to patch the problem. And I don't know what we need to do. And Massachusetts has this whole beyond moral certainty thing on top, which normally is considered a fairly strong instruction. Like, that's considered really strong language. So Massachusetts has actually some of the strongest language in the country, at least the normal perception of it. It's like they have some of the strongest language on beyond a reasonable doubt. And still, they're not understanding it. I don't know what we need to do to convince people. I don't understand. I was watching a video from somebody, I can't tell you who. I was watching some video online from a lawyer. I don't think it was one of the LawTube contingent. I think it was someone else. and I think it was a video I was watching, and he was saying that when he has a jury, he likes to ask the jury, like during voir dire when they're initially being sworn in, right? Or they're being asked questions. He likes to ask them, if you had to vote right now, right? This is like, when the jury is being selected, right? So they have not heard one piece of evidence, right? It's like, if you had to vote right now as to whether to convict or not, what would your vote be? And he will often get the answer like, well, I don't know. I'd have to hear more. I'm not sure. And he's like, and he actually tells them that is the wrong answer, because it is the wrong answer. It's the wrong answer because we're starting from innocence. There's a presumption of innocence. So if you had to vote right now, having heard no evidence, right? If you had to vote right now, having heard no evidence, you would have to vote not guilty, right? It's, I want to hear more. I don't know. I'm not sure. God damn it. That's not the right answer. It's not the right answer. The right answer is, if you had to vote right now, you would vote not guilty, because that's where we're starting from. We're not starting from balanced. We're not starting from balanced. We're not starting with the scales balanced. That's the thing, right? The scales are not balanced at the start. By deliberation, they are not balanced. They are askew. They are askew at the start, right? It's like, I don't know, it could go either way. No, it can't. Why don't you understand this? Stacks gives $19.99 pounds to say congrats on 150,000. Thank you. It's like, what do we need to do? Just help me and help the entire legal profession, because apparently we can't figure it out. Despite all of our education, all of our collective degrees, all of our many years of practice, and all the people that have come before us, all the many, many professionals that have come before us, apparently we can't figure it out. What on God's earth do we need to do to get this through to people? I don't know. Anyone have any ideas? Because we apparently haven't figured it out, despite, I don't even know, 500 years at this point. It's got to have been. I don't know when we invented reasonable doubt as a concept. It's been a hot minute. Let's say 500 years ago. I don't know. We haven't figured it out in 500 years. Anyone got any ideas? I don't know what to do. Yeah, Q squared says, I'm unsure should be not guilty implicitly. Correct, right? If you don't know, there's only one conclusion, because we're not starting from even. We're not starting from even. That's not the starting point. God damn it.
I think it was a honest and trustable jury, in that we all followed the rules, which is not to watch TV, diet from that, diet from reading the news or any of the tickers, and not pay attention to those things. Or if something were to come up, we were required to report it as such, that we had some sort of interaction. But like I said, most of us.
No, I know you don't want to listen to this guy, and I understand you don't want to listen to this guy for any number of reasons, not the least of his voice. But I understand you don't want to listen to this, but you need to listen to this, because you need to understand. You don't want to listen to this, at least because of his voice. That is a non-trivial factor. The other reason you don't want to listen to this is because it's so stupid, it offends your intelligence. I understand completely, right? Your mind is rejecting this because of how stupid it is. But you need to press past that. You need to find the courage within. You need to find the resolve within to press past that. Because you need to understand, and you think you understand, but you don't really. That's the problem. It's like you understand on an intellectual level, or you understand on a very, what would you say? You understand on a superficial level that people think differently than you. If I asked you, do people think differently than you? You say, sure, of course they do. You understand superficially, but you don't really understand. And you need to listen to this guy, because you need to really understand. You need to really understand that people think differently than you. It is infuriating to you. It is mind-blowing to you. It is impossible. Your mind wants to reject the stupid. I totally understand it. I get it. But you need to understand on a deep level, not just a superficial level. You need to understand that this person was, in fact, on Karen Reed's jury. People like him are on juries. A person like him might be on this jury. A person like this may be on your jury. You need to understand this. I understand that I'm asking you to put your hand over the flame and hold it there. I get it. The candle is burning and your hand is over the flame and you really want to move it because it really, really hurts. Press through, my friend. Press through. You're going to get some serious burns on your hand. Your hand may catch on fire. Press through, my friend. You need to understand on levels that your mind is unwilling to eject. You understand only on the most superficial level. You understand only on the most cursory level. This is true. You need to understand this on deeper levels, and it will hurt you. You understand on a cursory level, fire is hot. You understand on a cursory level, fire hot. You've put your finger over the flames, and you've understood that fire is hot. And you think to yourself, I understand fire is hot. But you don't understand fire is hot. You don't understand it. You need to understand it deeper. It's going to hurt. It's going to be painful. You may never recover. You may never recover from the impact. Yet we press on. We press on in understanding the stupid, because when we talk about the reasonable man, here is a picture of the reasonable man. Ronnie is the reasonable man. Welcome to reality. Yep.
I should say all of us were pretty good about it. And we just, dieted from the news and the media.
All right. So I'm sure a million people have questions. So I'm going to read some questions that we have from Turtle Riders in the chat here, because I'm sure there's a bunch. Okay. Our first one, this is a $10 one from Jay. And again, if you guys are going to write them in, keep them brief. I will not read your freaking paragraph questions. So keep it brief. So how do you overlook paramedics' omission of possible, this is from Jay for $10, possible vehicle strike in the report narrative? The radio report to the hospital and the other report are both available to be examined, and would have been two opportunities for this medic to have reported document if it actually happened.
I'm starting from false assumptions. What false assumption am I starting from? I'm not sure. Yeah, someone in chat says I'm starting from a false assumption. Which false assumption exactly am I starting from here? I'm not sure what assumption I've made or what assumption is false. But maybe you can clarify what false assumption I've made, because I'm not sure what it is. What false assumption do you think I've made? Let me know in chat. This should be good. Oh, Lord.
So I think one of the things there is it would have been nice if that was all documented per se. Again, the jury is limited on what we are actually able to see in terms of the documentation. So we are only given a certain piece of the documentation, and majority of it is based on the testimony of the individual. So the individual can read the document, or they need to read the document and then kind of.
499 from Kate E. If they disregard the reasonable doubt standard, why isn't that considered jury nullification? It probably does, but what are we supposed to do about it? Right? And can the defense quote Blackstone's ratio in closing? Sure. Yeah, they absolutely can. They can explain reasonable doubt in any way they want. Sure. They can quote Blackstone or anything else that will help get the point across. We've tried multiple ways of doing it. I'm not sure any of them are working. But if you think quoting Blackstone will do the trick, you can quote Blackstone. That'll be fine. I'm not sure how much that will help you, but you can give it a shot. Yeah.
say it out loud to the jury, and that's what's provided to us.
Next question here. This is a random one. Lem sends for $50. Long time, first time. Could you please ask the juror if they ever followed Turtle Boy, Olivia Lambo, or Joe Flipperhead? Do you follow any of those accounts on Twitter? Did you follow Turtle Boy before any of this? You probably
No.
know who I was. That's okay.
Sorry, first time to learn about any of those, and in fact, first time I learned about Dr. Turtle Boy was when I got contacted. So,
well, thank you for respecting my pronouns. All right. So, do you have now that the trial's over? Have you consumed any of this, or you just went back to your life like whatever?
I think, as at least for me, and I believe the majority of the jury, we all wanted to just go back to our normal lives, and we haven't really followed much of it other than knowing full well, just occasionally, that it was a hung jury.
Greg asked for $5 Australian. This is the guy who chooses the grizzly bear of the human because he can believe he can rationalize with the bear. Yep. Guys, I mean, it's really as simple as this in the end. This is the simplest way I know to explain this. And it's also the most terrifying way I know to explain this. But like, you have met a lot of people in your life. You are a person and you've met a lot of people in your life. Okay. So I want you in your head to take a moment to produce the average person, right? This is the average person, right? He's the 50th percentile by definition. Okay. So I want you to imagine in your head the average person. How intelligent is this person? How careful is this person? How diligent is this person? How responsible is this person? How thoughtful is this person? How logical or emotional is this person? I want you to, in your mind, imagine this reasonable person, the amalgamation of all the people you have met, smushed into one person, right? Who is this reasonable person? How do they think? How do they reason? Are they diligent? Are they careful? Are they thoughtful? Are they logical? Are they emotional? Are you imagining this average person? Do you have this person in your mind? Have you pictured this reasonable person yet? Have you done it? This average reasonable person, have you done it? Okay. Now, having done that, remember, by definition, 50% of people are less than that. Half the people, by definition, are less intelligent, less careful, less diligent, less thoughtful, less logical, less analytical. 50% of them are less. Your jury is going to be composed of a swath of the population. Good luck. Frenchie's mom for 11 euros gives me a sticker that says good luck. I appreciate the sticker. Yep. Welcome to the world, man. Choo choo.
Jury, and that it's probably going to be retried, and we know that it's being retried, and we know the date. But I honestly have not gone and searched anything or researched much of anything in terms of the case because I lived it.
Do you
Pretty
think
much.
if the defense had been allowed to mention that there was a federal investigation into the investigation itself, and that the FBI paid for those experts to be there, would that have affected the outcome of the trial?
I believe that it would definitely have changed. Most likely would have changed the hung jury or made it more unanimous of a vote. So it would be,
not for nothing, Ronnie, but you can't have more unanimous. You can't have more unanimous. Tara for 999 says, thanks, Kurt, for the abject despair. We're all doomed. Yep. Now do you understand? Now do you understand why I say there's a 20% conviction chance? Now do you get it? If anything, you probably think 20% is too low at this point, having me just gone through that exercise. At this point, you're probably saying to yourself, geez, Kurt, 20% sounds like too low a number. I have lost all hope. Yeah, welcome to Black Pill land. Congratulations. Population U. Yep, good times.
Easier to kind of look at. And they would still ask us to continue deliberation because it would just be a few individuals left.
Next one here. This is from $30 from Dawn. Could the juror confirm if the jury slip was the updated version requested by Alan Jackson, or is it the one that they never updated? Did you guys get confused by that?
Yeah, so we got two different slips.
Diane says, I've been on 4 jury trials, never encountered anyone as idiotic. Stop with the arrogance. It has nothing to do with arrogance. It's not about arrogance. I'm not arrogant. I'm just trying to tell you that the jury is going to be selected from a group of ordinary average people in a wide swath. And some of those people will be less than average by definition. And some of those people might be like Ronnie. The fact that you've never encountered a person like Ronnie on your jury, first of all, really? Are you sure? Second of all, even if that's true, your sample size is relatively small, right? I mean, by definition, right? If you're trying to select 12 random people from the population, 12 is a fairly small number from the population, right? You're not so large that you're going to wind up on a bell curve, right? If you were trying to select 10,000 people from the population, then, you're probably going to be much more on the, in a bell curve kind of situation, right? But 12 people is too small a subset. So it's too small to average out, right? If we selected 10,000 random people and asked them, we'd expect those 10,000 people to be much more typical of the population as a whole, but if we're picking 12 people, there's no particular reason to believe they're going to be as a whole. So, you might wind up with 12 people that are above the curve because, it's not exactly unlikely. If you pick 12 people at random, what are the odds of winding up with, heads 12 times in a row? Well, it's 1 out of 4,000, right? If I did my math correctly in my head, to do 12 heads in a row is 1 out of 4,000. If I did my math correctly in my head, that's not exactly horrible odds. There's a lot more than 4,000 trials that happen every day. So you might wind up with 12 heads in a row, but you might wind up with 12 tails in a row by the same metric. So, or of course not, because those, but any given trial, baby, any given trial, sometimes, man. Yeah. 4 jurors isn't just 12 people. Yeah, but each jury is a random group of 12. So, it's just not a big enough sample size. It's just not a big enough sample size. 4 groups isn't 12 people. Yes, but it's just not a big enough sample size. And so, yeah, but it's not. And, maybe Ronnie is on the lower end of that curve. I don't know where Ronnie is on the lower, on that curve. So maybe Ronnie is on the more extreme end of the curve. So maybe encountering someone like Ronnie is unlikely, or him getting struck out is more likely. But, obviously Ronnie made it onto this jury, but, there's sort of that old saying, like, if you can't tell who like the stupid one is in the room, it might be you, right? If you can't tell who the foolish person in the room is, it might be you. So if you haven't found Ronnie in any of your 12 jurors, maybe you are Ronnie, or maybe just that was the way the fates were that day. Who can say? But Ronnie obviously made it onto this jury. Ronnie might make it onto your jury. Maybe you get lucky, but maybe not. There are more Ronnies out there than I think you're giving credit for.
The first slip that we got
Yeah.
Was
Yeah, Ronnie is also an EMT. You would think that Ronnie being an EMT might make him. You would expect that being an EMT, he might be above the curve, but apparently not, which says something about EMTs too. So not only do you have to deal with the probability that not only do you have to deal with the probability that Ronnie might be on your jury, which is scary enough, you might have to deal with the probability that Ronnie is the person who shows up in the ambulance to your crash scene. You can decide which of those fates is worse. Yeah. Okay.
updated and changed. I cannot recall the exact date or day that we were given the new slip, but we definitely were given a new slip that was updated charges and updated verbiage.
Okay. This is from
$2 from Greg says Ronnie is the proverb, stupid is as stupid does. A little bit, yeah. Yeah. Could be. Yeah.
Kim for $10 says, what questions were you asked of when you were chosen as a juror? Good question. During the voir dire, when you guys were called up and your little conference there with the judge and the attorneys, what were they asking you? What questions?
Each individual is different. I think the major question was for me is that would I be biased in any way, shape, or form because of my medical training? And so that wouldn't overlook the evidence and have an opinion and have a bias as a direct result of my medical training without looking at the evidence entirely and do I have a bias versus or against or for law enforcement?
Really? Who asked you that question? The Commonwealth or the defense? Do you remember?
I believe it was more of the defense.
Okay. The defense asked you if you had a bias towards law enforcement? Okay.
I believe it was the defense who asked.
And you said you were just indifferent, whatever. Because if you said, yeah, my dad's a cop or something like that, you'd be the first one on the cutting line. If you said something like
I don't know. Perhaps I tried to be honest, I tried to get out of it. I actually thought I was just going in just the first day. I didn't even know what the whole thing was.
He apparently was trying to get out of jury duty and failed. I normally don't ascribe to that saying that the jury is composed of people too stupid to get out of jury duty. I don't know that that is necessarily true. There are people out there who just believe in civic service. There are people out there who believe in, doing their duty, and people who believe in things like that. So I don't think it's necessarily true that your jury is comprised of 12 people too stupid to get out of jury duty. But apparently it's true for Ronnie. Ronnie apparently was trying to get out of jury duty and failed. My black pilling. How black is now a question I'm asking myself. Just how black is black? Can this black pill get any blacker? Apparently, the answer to that question is yes. Apparently, somehow the black pill can get blacker. My hope somehow continues to erode. Once again, this whole democracy republic thing that we've been doing, this whole government of the people, Ronnie is some of the people. Ronnie is some of the people. Ronnie is, in some sense, the government, because it's a government of the people, and Ronnie is a person. So Ronnie is, in some sense, like you or me. Ronnie is, in some sense, the government. This government of the people thing, I don't know, man. I don't know. I'm having some second thoughts on the whole democracy republic thing. I don't know, man. I'm not sure about that one. Yeah.
Until at the end when they were starting to select us, what was going on. But I thought it was just going to be a regular jury.
Were you there April 16th, the first day of juror selection?
No, I was there on the second day, on the 17th.
Okay, the second day. They picked 7 that day.
Q squared $5. Actually, a better view is about 65%. People that are average with slight difference, while 15% are dumber and 15% are smarter. Yeah, I mean, if you're talking like a standard deviation, right? Then I mean, yeah, we can look at what a standard deviation is like, because it's the middle. What is it, 68% for one deviation on both sides of the curve? Isn't that right? It's a 34%, and then times 2, so it's 68%. Isn't that right for a standard, for within one standard deviation? So like 32% is outside of a standard deviation. That's a lot, actually. Yeah. Yeah. So yeah, good times. Yeah. Yeah. A standard deviation is actually fairly significant. So yeah, standard. How many, where is he on that curve? Yeah. I mean, 2% of people are 2 standard deviations on either end of the curve. Right. So 1 out of 50 is on either end of the curve with 2 standard deviations. One out of 50 isn't exactly horrible odds. What are the odds that what are the odds that the bottom 1 out of 50 will be on your jury? I'm sure we could do the math. If we just did it randomly, what's the probability that the bottom 1 out of 50, how many people would you expect to be on your jury? Yeah, that's actually, someone could do the math on that. We could probably do the math on it if we pumped it into an equation. But how many jurors would you expect to be bottom 1 out of 50 if they were just completely randomly selected with 12 jurors? How many of them will be bottom 1 out of 50 on expectation? I'm sure we could do the math on that. We could ask ChatGPT or something. It's probably more than I want it to be. Yeah. Let's ask ChatGPT what the probability on that is. It can tell us the depressing news on this. Okay. All right. How do I ask this question? How many people that are in the bottom 2% of the population would I expect to find in a randomly selected group of 12? Let's see if it can figure out that one. I think that's the way to phrase that question. All right, if you're drawing 12 people at random and each person independently has a 2% chance of being at the bottom, the number of such individuals in your group follows a binomial distribution. Expected value is 0.24%. That means on average, you expect 0.24% of people in the bottom 2% in a random group of 12. So yeah, that's disturbingly high odds. I'm glad it's not higher than that, but that is higher than I want it to be. Yeah. So in your 4-person jury, the person who said they did jury service 4 times, right? Then you'd expect there to be at least one of those people on those juries. Well, that's not quite right, but it's close enough for the purposes of this discussion. That sucks.
That's interesting. And so you went into that and you must have seen crowds of people outside. Were you like, what the hell is this? What's going on here?
Yeah, I actually didn't realize what we were being selected for and what was the case until it was read to us by the judge. But essentially, I thought I was going to go in my typical jury duty, go in there and spend like maybe a few hours and then get out.
Or we don't necessarily have to make it that bad. We can make it a little less bad. Like, so bottom 2% is probably too bad. So how about bottom 5%? So yeah, because bottom 5% is like there's a 1 out of 20 chance of someone being in the bottom 5%. So how does that deal with our numbers? If we're talking about the bottom 5% of people, how many people would we expect to be in the bottom 5%? 0.6% or 0.6 people in the bottom 5%? Yeah. Okay. Yeah. Yeah, right.
Be able to have lunch and have the rest of my afternoon, as opposed to the other way around, where I was there for a little while for a full jury selection.
Next one is for Mackenzie, sends $5, and she kind of asks my question about the reconstruction experts, FBI, etc. And then she says at the end, like, how she says, because I don't understand how someone could take Officer Paul's reconstruction seriously and disregard the two defense experts.
That's a very good question.
Because he was the only one that was the expert that explained.
He sure was.
Commonwealth, how John O'Keefe got hit by a car. Did jurors actually take him seriously? Did they think his testimony went well?
Again, I don't think necessarily we were looking at one individual for their testimony. We kind of looked at the whole picture, bringing it back to the circumstance that somebody is dead, and those two individuals that came to that household or that address, one of those individuals is dead and the other individual's alive. Ultimately, and there's damage to the vehicle, then that individual must be responsible for that injury.
I'm sorry. I just need you to say that one more time. Just remember, this person might be on your jury someday. God help us all.
Ultimately, and there's damage to the vehicle, then household, and we kind of one individual for their testimony. We kind of looked at the whole picture, bringing it back to the circumstance that somebody is dead, and those two individuals that came to that household or that address, one of those individuals is dead and the other individual's alive. Ultimately, and there's damage to the vehicle, then that individual must be responsible for that injury.
Hold on. Excuse me 1 second. I need a sound effect to properly explain my feelings. Give me a second. My browser just crashed too. Firefox apparently is having trouble today. Firefox keeps crashing on me. I was going to play a nice little sound effect, and now everything has just completely crashed. Great. Hold on. For the sake of the joke, this is a lot of effort to go through for the sake of the joke. Now the joke is no longer funny because of timing, right? What makes jokes funny is timing. And because Firefox crashed, the joke is no longer funny. And everything is taking a minute to load. Let's see, where were we in this bullshit interview? Ah, Lord.
It's not common to create a copy and then invert it.
Yeah, it's just, why would they do that if it was an honest investigation? You know, but again,
Yeah.
the one.
No, I mean, that's
I don't know. Anyone know where we were in the timeline of this bullshit interview? Because my browser crashed and it's not playing nice with others.
great view, but again, we couldn't give credibility to that little piece because we don't know when he actually did it per se, or it wasn't.
If he says per se one more time, if Ronnie the juror says per se one more goddamn time,
It wasn't very clear.
The science says she didn't, so I will never believe she. Another juror says they could hear the noise outside.
Who were on the fence. So the ceiling fan was a very good distractor. So some of us would look in the store.
okay.
Too flashy. It would have been more beneficial to Karen Reed if you guys did the trip to 34 Fairview Road at the end of the trial instead of at the beginning.
I agree. It would have been more beneficial if it was even at the middle, if not the end, because at the beginning, it
Bedroom and the other side a couple times says, how could y'all trust the investigation given Proctor's character? I think we kind of been over that. Thank you, Carrie. Nicole sends $10, says, now that the trial's over, the rest of the jury's had time to read up this.
and be like, oh, there's something there, but maybe would not say, oh, there's actually something there. But I don't know if it was very clear that it was the shape or form of a body scenario it was on.
All right. Let's see. What did you think about Jen McCabe whispering on the 911 call? Did you say Kim
Trying to deliberate based on those inconsistencies.
and the dog? Do you remember that?
Okay, what I can do is I can search the transcript. That was cool. So, like, what was the last thing that we heard? It was something about what was the last thing he said? I'm having trouble putting two and two together. Yeah, I need to get the exact wording of it. Something about the two people being there and therefore, what did he say? What was the phrase he searched so I can find it? Oh, Lord have mercy. This is going to take a second trying to find this. Oh, distractor. Yeah, something about no. Was it distractor? Was it distractor? I got it. Can't remember. So stupid. My body can't. I can't remember. Two arrived and one left. Yeah, what did he say? Arrived only has 3 matches. No, it's not something like that. Arrived together? Yeah, something. No. Okay. Yep. All right. Yep. That's it. Thank you. Yep. 50 minutes. Okay. We're only 50 minutes into this interview. That's not possible. How are we only 50 minutes into this interview? We're only 50 minutes into this interview? How's that even possible? I hate my life.
We were looking at one individual for their testimony. We kind of looked at the whole picture, bringing it back to the circumstance that somebody is dead and those two individuals that came to that household or that address, one of those individuals is dead and the other individual is alive.
Yep.
Ultimately, and there's damage to the vehicle, then that individual must be responsible for that injury.
Yep. That was
So,
stupid.
Like, you know, her dropping him off there and whatever, like that's not proof of anything, right? That could,
How are we only 55 minutes into this interview? That's what I want to know right now. How are we only 55 minutes into this interview? That's the question I want to know. I thought we've been doing this interview for 3 hours. How are we only 55 minutes into this interview? What hell am I in? And apparently there's another, this interview goes on for another 2 hours. This interview goes on for another 2 hours. Hate me. I hate my life. That's what's going on.
I mean, that's bad. That's, I mean, God forbid, like, I hope nobody else ends up in a situation where they drop someone up the house and then they end up dead. And it's like, well, you dropped them off, so you obviously killed them. But you mentioned the taillight. That's the only real physical piece of evidence that they had against Karen Reed. However, was it brought up during deliberations that the Canton police searched the scene at 7 a.m. with a leaf blower and they videotaped it, and they didn't find a single piece of bright red taillight on the snow, yet they found 45 pieces over the next few weeks? Was there any discussion that perhaps...
Yep, it's me. Member for 3 months says, Kurt, this guy is so dim it feels like 3 hours. Even your brows are noped out of self-defense. Yeah. 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 We could speed it up to 1.25. Do people want to speed up the interview to 1.25? Is that better? So we get through this faster? Does anyone have any major objection to speeding it up by 1.25? That'll make his voice sound like a little weird, but are we down for 1.25? Are we down for that? We're okay with that? All right, cool. Let's speed it up to 1.25 and save a little bit of our sanity. I'm not sure how much difference it'll make, but a little bit. You'd be happy if I just want to watch videos? Right about now, I want to watch some videos of puppies playing. That's what I want in my life.
perhaps taillight might have been planted?
There were some individuals that were definitely stuck on that and believed that was reasonable doubt, but there were some individuals that believed that it made a, again, just circumstance or happenstance, that maybe there wasn't enough snow at the time, and therefore now ultimately now the ground is covered and therefore you couldn't see the pieces because it's covered, but prior to that maybe now you can see it. So,
well, it would be the opposite. Because when they first got there, when the Canton police got there at 7 o'clock, there was 3 inches of snow on the ground, tops, maybe 4, 3 to 4. And it's a lot of taillight, right? And they had their leaf blower out, and they have a video of him finding these transparent pieces of cocktail glass. Paul Gallagher finds them. So they were able to find transparent pieces of cocktail glass, but not all that red taillight. Was the general consensus that the Canton police are just completely incompetent? Wouldn't they have to be if they didn't find any taillight? Was that the consensus?
I don't think that was the consensus. I think the consensus was just, again, they looked at all of the overarching evidence, not just that one little piece. So individuals looked at everything and said, nope, that's not enough to say that that created reasonable doubt.
Right, next question here is from Melanie, sends $10, goes, did he see the footage of Alan Jackson in court arguing with the judge about how the confusing juror forms were? And what did he think of that? Did you guys know that battle was going on inside the courtroom?
I do not know of that in particular. I never saw the footage, but I understand that it was very confusing. And again, unfortunately, it's a fallacy in the system that it wasn't clarified for us that we could look at each individual charge independently of each other.
Okay. Natalie sends $5 and says, "What arguments or comments from guilty jurors led you to temporarily change from not guilty?"
So to not guilty, I
From
think
not guilty, from not guilty to guilty.
not guilty to guilty. I think ultimately, again, some of us broke down because it was very clear. They clearly displayed that both individuals were under the influence of alcohol at the time, and therefore should not have been operating a vehicle. So the operation of the vehicle, and that is that second charge, which is involuntary manslaughter, as a direct result
No.
of operating a vehicle under the influence of alcohol. So that is what a lot of people kind of swayed on, that yes, they shouldn't have been operating the vehicle, and it's not murder too, but could it be that she operated the vehicle negligently, and therefore
That's not good enough for manslaughter. It has to be recklessly. I hate my life.
led to involuntary manslaughter? So that's where there could be a sway.
So it was the fact that she was, admittedly had. So I would say, so the testimony from the police about she had 4 drinks here, that was very effective, obviously, because ultimately they said, well, she was drinking and driving, so she probably did it.
I think it was not only that, but the video footage.
I swear, listening to him, my intelligence is burning away. Yeah, I think it's my mind's only way to save itself. Like, my mind doesn't want to listen to this, and so its initial impulse is to run away. And since I won't let my mind run away, I feel like my own intelligence is being suppressed. I feel like my brain has turned off parts of itself and is refusing to work anymore. There's just now a void where my intelligence used to live. It's like it's an empty space. That black hole has just appeared inside my intelligence because my brain refuses to engage with this, and I can't make it.
Of the drinks that she was having was very strong in leading to that kind of opinion and thought process.
Okay. Even though the rest of them were also drunk. I mean, everyone was drinking and driving that night, including the police. And that didn't bother anyone else?
I think it bothered everybody, but ultimately we have to look at who's being charged here, and the individual who's being charged was Karen. So unfortunately, nobody else was being charged with it. It was just Karen. So therefore, Karen must have been, and both people were there during that same time frame. So
that's interesting.
Karen Reed is the one in the guilty chair. Karen Reed's the one in the guilty chair. It could be someone else, but she's the one in the guilty chair, so it's got to be her. That's how we're doing this right now. $5 Australian from Greg S. Is it any wonder that statistically thousands of innocent people are currently sitting in jail? Nope.
Interesting that you say that, because, and I've long argued this, that being in the defendant's chair is you're already losing. You're already down 20-0, something like that, because you're here, you've been charged.
Yeah,
you probably did it, or else you wouldn't be here right now.
Yep.
So you would argue that, like, the fact that she was charged at all and sitting in that defendant's chair and no one else was charged is pretty, that people were suggesting that was, pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody, right, should be considered innocent until proven guilty, but
theoretically anyone should be innocent until proven guilty, but
so theoretically anybody, right, should be considered innocent until proven guilty, but here they displayed clearly, the Commonwealth displayed that she was under the influence of alcohol, even though there was no breathalyzer per se at that exact time frame when the incident occurred. Right, it was after the fact. But based on the evidence of the receipts and the video showing that she was under the influence of alcohol and then operating the vehicle, that would be easy to kind of charge her with involuntary manslaughter, operating a vehicle under the influence.
So I have a question here from another juror. Is actually from the one of the jurors who was not chosen to deliberate, and I'm getting a message from them now. And they said, this is the quote: "Did the jury ever discuss to a moral certainty as part of the reasonable doubt discussion, or would having an attorney in the room?"
$4.99 from Spencer Slavia. Thank you very much for the super chat. The super chats help a little bit. Not really, but let's pretend they do. Thank you.
Have been helpful for that, because I believe one of the jurors who was randomly chosen not to be in the jury was an attorney. So would it have helped to have an attorney in the room describe what to a moral certainty was? Was that discussed at all?
I think having
Actually, that's not particularly helpful, because I don't think an attorney, and I couldn't swear to it, but even in maybe a Massachusetts attorney, but like you would have to have a Massachusetts attorney like who specializes in criminal law, I think, to be honest, because like to a moral certainty isn't really like a legal concept, or it's not normally one. So I mean, I wouldn't necessarily be really in a position to offer particular expertise, because it's not a common legal concept. So like I could give you some ideas about what I think to a moral certainty is, but I'm not sure that my expertise as a lawyer makes me particularly qualified, because it's not a common legal concept. So maybe if there might be some case law discussing it in Massachusetts, and maybe a Massachusetts criminal defense attorney might have some better idea of what it means based on some cases. But yeah, without specialized knowledge, I'm not sure an attorney would be particularly able to tell you what it means. Yeah, it's not something I studied in law school or was on the bar, that's for sure.
that level of expertise in the room would have been helpful for everything, including the fact that, number one, that all three charges could be looked at independently, and somebody who has that level of expertise to clearly indicate to us the moral certitude of reasonable doubt.
Okay, because they went on to say that when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs. So obviously, this discussion.
Yeah, I don't know how that isn't like clear, right? It's like moral certainty is the one we use in the most serious of our personal affairs. I'm not sure how that doesn't just answer the question. I'm not really sure that I'm able as an attorney or as a human being to really give you much additional clarity on that one. I feel like I can't make it any simpler. I don't know, man. Yeah, they say isn't like real genius that's able to make it simple. Like real genius is able to simplify. Maybe I'm just not smart enough to simplify this. I don't know. Saranus for $5 says the jury's mentality: instance proves nothing. A plea of not guilty is guilty of wasting their time. Yeah.
Didn't even take place at all. What a moral.
So I won't say that it didn't take place, because we read that statement multiple times to the group. I don't know if it hit home to the group more so if that individual was there to provide that level of expertise. Okay. So if somebody was there to provide that level of expertise, I think it would have been more realistic or tangible to the jury or the group rather than not, because although it was read multiple times, and I will say that we read it multiple times, and I was one of the individuals who was reading it multiple times, it clearly may not have made an impact or have been as impactful as if there was somebody with that kind of experience and that level of knowledge.
Yeah, coincidentally, she happened to be one of the two names chosen out of that box on the last day. And there was when I was watching the testimony of these people, there was three jurors in particular, all women, who were making visual representations with their facial reactions that they believed that Michael Proctor was an asshole and that the Commonwealth was full of shit and that Karen Read was clearly innocent. And coincidentally, all three of those people making faces were all chosen on the last day not to participate in deliberations. did you guys did you guys ever talk about this before you started to deliberate? And what was it like the moment that you went in that room? Like, what's the first thing people said? Like, okay, so let's get this over with, or what do you guys want to do first? What was that like?
We actually didn't. So in terms of just going into the room before deliberation, we really didn't talk much about the case when we were, other than a couple, comments here and there. And even when we were, when we were together, we were.
I like this comment, and Rowan, I like this comment, but I did have breakfast. Yeah, but I did have breakfast. Yeah, that's a problem. Yeah. Q squared for $5 says, I'm driving the rain, but seriously consider starting to drink every time this dude says per se. I feel you, Q squared. I feel you. Every time he says per se, I want to die a little bit inside too. Try to resist the temptation as long as you can. I know it's difficult. You want to numb the pain. I want to numb the pain too. But we just live here now. Maybe I should start a new goal. I should start a new super chat goal. Like if I get 20 donations of $5 or more, maybe we just stop listening to this. That's a good incentive. Yeah, let me start a super chat goal. Let me see what the number is. If we get a certain number, we stop listening to this. That's got to be good for some revenue. Yeah, let me see what the right numbers are on that one.
Not really deliberating or talking a lot about the case. But we did definitely talk about the case during the deliberation process. And we tried to figure out where to start. I think ultimately we came up with looking at all the evidence and looking at the video files, looking at the pieces of evidence that was provided to us. And we kind of looked at all of those over the course of the time frame that we did our deliberations.
This is from Kelly. If Chloe bit, you must acquit for $10. Says, I want to thank you, Ronnie, for coming on to stand up for what is right in the name of justice. What was the biggest thing that caused you to believe in her innocence or that there was reasonable doubt?
Ultimately, what made me sway back to reasonable doubt was, yes, she was there and he was there at the same time frame. However, the injury that ultimately causes death was inconsistent with the physics of the damage to the car. And the other piece that causes death was the hypothermia. So those two pieces, which was presented to us, was the basal skull fracture to the back of his head and the hypothermia was inconsistent with the damages to the vehicle. And so ultimately what I also thought about was that he was the one who kind of, and I'm not trying to put blame on him, but he ultimately was the one who was insistent to try to go back and go to this place. So 34 Fairview, he was the one who kind of programmed the GPS to that location. And she was the one who was asking to just go and have something to eat. Granted, it was a pizza place that was closed. She wasn't really looking to go drinking anymore. At least it seemed like it. He was and continued to party. So not trying to put blame on him, but it doesn't seem like she is at fault of whatever ultimately came about at 34 Fairview.
Because she just wanted to go home and eat food.
That's what it seems like it.
Right. Okay. All right. Next up, this is Nicole for $10. Says, hi, Ronnie. Thank you so much for your bravery coming on Turtle Boy tonight. In your opinion, do you think there's any possibility that one of the jurors who were firm on guilty could have ties to the McAlberts and thus already knew that they were going to try to vote guilty going into it?
It's possible. I mean, it's a small world, right? So who knows? I can't say that's speculation.
I'm just reading the question. I'm like, I don't really like that question because I don't know how you're supposed to answer that, but they gave it a shot anyway. All right, next one. This is B for $10. Says, this is a question I like. Would access to transcripts of trial help change the decision or help you guys deliberate?
Yes, I think it would be helpful to see all of the transcript. It also is what people sometimes don't understand is the jury wasn't allowed to look at whatever was objected versus sustained in terms of there was some overrules that were there. So those had to be scratched out. That's why we had notebooks. It would have been nice to know ahead of time how long it was going to go and we should have probably organized our notes a little bit better. So we did take notes extensively, but it would have been nice to have access to those transcripts to actually look through certain things as well. I don't know if it would have changed it ultimately, again, because of the unclear direction of the charges. So if we had better direction as well, I think we wouldn't be having this conversation right now. And I think the trial would have been done last year.
Right. Romy sends $50, says, "This is amazing. Thank you for speaking, Ronnie." People are very happy that you're willing to come on and talk, and you're not, I mean, good. I appreciate you coming on, because this is nothing wrong with this. And I hope more jurors do this and talk about what happened. I mean, are you worried about this? Were you nervous about coming on here at all? Were you apprehensive? Because when I asked you, you just said, sure.
At the time when you said it, it wasn't anything of a problem. And then as it got on, I was like, what could happen? But now talking, I think I feel relieved that I'm talking and letting people know the story. I think the story is important for people to understand, and also to still believe there is, hopefully at the end, right, a good justice system, and it works out. Because otherwise, if you look at it, she would have been imprisoned, and because of what happened, and clearly it may not have been the right choice. So I think, right, we will just have to let the next jury make the decision.
Let me ask you something. Did jurors not express any just general distaste for Karen Read? Because I've said this before, and I think Karen Read's biggest obstacle that she faces are the facial reactions that she makes in court. And I think some jurors, I know that one juror who was dismissed actually was dismissed because she made a comment to other jurors about Karen Read's facial reactions. Did that come up at all in deliberations, Karen Read's facial reactions in court?
I think not only her reactions, but other individuals' reactions. I think it was interesting because we all kind of focused on certain people or certain things inside the courtroom. And there was family members' reactions, other individuals' reactions. But in terms of her specifically, I personally did not kind of put any kind of qualifier or quality.
Well, we know you didn't, but like, were the guilty people, like, did it seem like they just didn't like her, the jib of her sail, the way she looked, because she's not a typical murder defendant. She comes in court, she smiles, she makes faces, she doesn't cry. Did that rub some people the wrong way?
I think it probably solidified it for some, based on some of her reactions to what was being said or what was going on in the courtroom.
Okay. Do you believe that Brian Albert butt answered his phone while having sex with his wife at 2:22 in the morning?
I find that very hard to believe, but anything's possible.
Yes, and just asking. That was me. Wow, I see a bunch of people bringing that up in the comments. But okay, next one. This is from Denise Tuttle for $10. Says, does this juror think she was framed, and has anything he's learned since the trial changed his mind?
So I think there's a lot of bias in the investigation, and therefore it's hard to go in that direction of, I think it created enough reasonable doubt in my mind that she was not guilty. Whether she was framed, that's a different scenario. But again, a jury would look at it and say that she's not guilty based on reasonable doubt. So,
well, if Karen Read is not guilty, then by definition, she had to have been framed because all that taillight got there, correct?
Correct.
Yeah.
Well, no, not necessarily. Not necessarily, right? Because again, like, it's the state's burden to prove the elements. So it is not necessary to believe the conspiracy, to believe the state failed to prove its case. You just don't believe. You can believe the accident occurred but didn't lead to the injuries. Those are not necessarily inconsistent positions. You could believe that the accident occurred and she hit John O'Keefe, but it didn't kill him, either directly or indirectly. And because the evidence just simply doesn't support a collision with the magnitude necessary to create a disabling injury. Somehow, some way, the accident occurred, and somehow, some way, those taillight pieces were created and were there to be found the whole time. So somehow, some way that happened because the taillight hit the glass or whatever, right? So somehow, some way that happened. But you don't necessarily need to believe it's a a conspiracy. You don't necessarily need to believe it's planted. You can believe the accident occurred and still not believe it led to death, because that's literally element 1 of the murder charge, and it's element 3, I think, of the manslaughter charge. Basically, it's like that the action led to the death. It's like, yeah, so you don't necessarily need to believe that to find not guilty. You can just believe that even if the accident occurred, it didn't lead to the death. So that's the easiest way to resolve it for me. So yeah.
So it's just interesting. So it seems like in this situation, you either had to believe the McAlberts were honest or you didn't. And did the Google search come up? Because this Google search was what ultimately got me hooked on this case. That 227 Google search that came back as deleted. And then the deleted phone calls from Jennifer McCabe to her sister at 6:07 and 6:08. And Brian Albert not coming out of the house, etc. Did you guys discuss the behavior of the McAlberts and how suspicious it was?
We extensively discussed why was the first person to go to the house, approach the house, was member of the family, you know what I mean? And then the other pieces of the Google search, we don't know. And again, there was not an expert in the group necessarily that could talk about it with enough knowledge on experience, and that if those Google searches can track to the exact timeline and time frame and backtrack. So right, we're not really sure about that, but we looked at it and said it's again maybe just distractors.
That's the consensus was, that the 227 Google search was a distraction.
Again, kind of distractor. I think some people were set at the very beginning that based on the evidence that they had seen so far, and kind of combing through some of the evidence, they kind of looked at it and said, you know what, both individuals were there at that particular address. One person was operating the vehicle under the influence, and another person is now deceased.
Wow. All right, next question here. This is from Not Man Shannon for $10 and says, if the defense took the time in closing to go over the jury instruction and relate each piece of evidence that establishes reasonable doubt to each jury charge, does Ronnie believe this would have helped the jury vote not guilty? I think we've kind of asked this already.
I believe that it would have probably been helpful to be able to have more of the data and clear instruction. So clear instruction, I think, would have ended up changing the scenario in terms of 2 of the charges, because we clearly said those 2 charges were essentially not guilty, right? So those 2 charges would be not guilty. The last charge, or the second charge, which is the involuntary manslaughter, I think if we had a level of expertise to ascertain reasonable doubt more tangibly to each individual in the jury, and a better explanation, then perhaps I believe that we would have been able to deliberate and go in one direction versus the other.
This is from Joan for $25 and says, knowing what you know now, what is your opinion regarding this case, and if you think he was hurt inside the house?
I think he wasn't injured by Karen and her vehicle. Where he was injured and who injured him, I don't know. And I think that's what law enforcement should be looking right at, is trying to figure out. Unfortunately, it's been such a long time ago, but that's what that's the mystery, right?
If you invited,
but it doesn't seem consistent.
If you invited someone over your house after the bar and then they ended up dead on your lawn 6 hours later, would you expect the police to search your house?
Well, unfortunately, if that were the circumstance, regardless of who it was, I would believe that law enforcement would comb my house and potentially go to each neighbor and interview each neighbor, and more testimony from neighbors and other individuals would have been presented. I don't know if that was just dismissed because they didn't think it was relevant testimony by the defense nor the prosecution, but I think it would have been important to have interviews of the neighborhood or individuals, including a search of my house, because it's even though it's my house, you know?
Yeah, no, it's funny you mentioned that, because across the street, and this was not even brought up at the trial, across the street, the deputy, or the lieutenant, I believe he's like a deputy chief now, named by the name of Tom Kelleher from the Canton Police Department, lived directly across the street from the McAlberts at, I believe, 31 Fairview. And he has a Ring camera, and I actually knocked on his door one time as part of my investigative journalism. He didn't answer. And I stood where the Ring camera was, and I kind of pointed my camera out of the street, and lo and behold, it captures directly where this incident would have occurred if Kara Reed ran him over. If the defense had presented Tom Kelleher as a witness, and he had said that, you know, the police never asked for his Ring camera video, would you find that suspicious as a juror?
Of course. I mean, it would be also suspicious if there was no recording, or there was supposed to be a recording and then suddenly it got lost.
And that's happened a couple times too, I believe.
Correct, in the course of the court.
Yeah, and didn't you guys? What did you guys think of the inverted video that was shown in court? Did you think that was on purpose? Did anybody think that was an accident?
It was definitely confusing because we all kind of thought it was on one side of the vehicle versus the other side. They were all on the right side versus the left side. And ultimately, when we realized it was inverted, it could be a honest mistake, but it's kind of hard to make an honest mistake when you have to work hard to invert a video, right? I think it's not common to create a copy and then invert it.
Yeah, it's just, why would they do that if it was an honest investigation? You know, but again,
Yeah.
the next up here, this is from Jasisa for $5, says, thank you for your service, Ronnie. Could you talk about the notebooks? What happened to them after the trial?
This is like the opposite of Supreme Court analysis. And it's interesting to me watching the number of people that are viewing this, because when we were doing Supreme Court analysis, we were down under 1,000 people. And now we've got 1,400 people. So we've got 50% more people listening to this than the Supreme Court discussion. That to me is very interesting, because the Supreme Court is elevating. It elevates because you are pushing law to its highest level, right? I mean, that's what the Supreme Court does. It's not necessarily every case, but the Supreme Court, you know, a lot more often than not, is pushing law at its highest, because that's when cases get to the Supreme Court. So it's taking things and elevating this. And this is the exact opposite of this. And apparently you collectively, the chat or the viewership, prefer this to the Supreme Court. You prefer the stupid to being elevated. I don't know, man. I don't know if I understand you guys completely. I'm not sure if I understand you. I guess I must be different or something, because this feels like torture to me. Some of you guys like this. I don't understand. But you know, you are my audience, so I guess more of this. I'll hold on as long as I can. Woof.
And did the state police have any access to them or anything like that?
499 from Nicole K. Kurt, what's your final percentage prediction for Kurt being found not guilty? I'm still giving 20% to convict. I refuse to give explicit odds for hung. So implicitly, I'm giving 80% not guilty / hung. What the break is between those things, I don't know. I'm too afraid to give it a percentage. It's like maybe if I don't speak it, it won't exist, right? Maybe if I don't name it, it won't be real. I don't know if that's a delusion or not. Some things don't exist unless you name them in some ways, because there's a lot of like conventions and stuff that don't really exist. So if you don't name them, they don't really exist. There's a lot of Tinkerbell effect of a lot of things. A lot of things only exist because we believe they do. So I'm not sure whether or not refusing to give it a name or a number is avoidance or not. But yeah, it's like I'm too afraid to give it a number, because I don't want it to be true. I can't do this a third time. My poor mind cannot take this. I can't keep doing it, man. I can't keep doing it. Thank you. 499 from Pixie Designs. Hey, I super stickered red to get removed. Okay, thank you. And Livin Lacat became an uncivilian. And Greg asked for $5 Australian, says, my car was broken into one night. The cop who took my statement went door to door looking for dash camera Ring video. Yeah, you know, like a normal investigation you might do, especially in this day and age. You might look to see if anyone has Ring cameras. You know, Or you might just knock on like the nearest doors and ask whether or not they saw anything, like a normal investigation. Yeah. Yeah. If this jury hangs, well, to be honest, whatever the odds of a hung jury are have got to be greater than they were last time, I would think, because the case last time was an absolute shambles. And apparently 8 members of that jury were ready to convict in the case of that shambles. So like the odds of a hung jury have got to be greater than the last time, I would imagine. I would think, whatever the distribution on that would be. So I don't know, 20% to hang, 40% to hang. I have to skew. I have to skew for Ronnie. Ronnie is causing me to skew my numbers. Ronnie alone is causing me to skew my numbers in places I don't really want to go. I don't know how to account for Ronnie in a reasonable way. I'm not sure how much to skew for Ronnie. But it's not nothing. So Ronnie is blackpilling me and causing all my numbers to be thrown off. Yes, the defense asked to revise the jury slip. They asked to revise it in what I think is a fairly like meaningless way, but they asked for a revision and it was denied. And yeah, we discussed it. I'm not sure it's really any cleaner or any better, but they asked for whatever value they wanted to, but it was denied. I'm not really sure it makes any difference either way, but $5 from Donnie Jomo. This trial is interesting to some because it's a micro review of our current government and judicial system. Fair. Big guy versus little guy and lack of education. Fair. Yeah, I appreciate that. This trial is at least an exemplar of what is possible within our current system. That is very true. Ronnie is out there. Ronnie is out there and waiting to be on your jury. God help us all. Every day, the sergeant at arms or whatever his title is officially, the court officer, whatever he is, the marshal, I guess we'll call him. Every day, the marshal says, "God save the Commonwealth." I don't know, man. I don't know. God has forsaken us.
Sorry, can you say that again? Yeah, you kind of cut out for.
Oh, sorry. Your notebooks that you guys had. What happened to them during the trial and after the trial? And
Burb has a very good comment. Burb, after 10 plus years in customer service, I don't have a lot of faith in reasonable people. Yeah, you know, if you are a customer service facing worker, your odds are probably even more skewed. If your job requires you to come into contact with customers a lot, are you a waiter or waitress? You know, do you have an IT support job or customer service job? Yeah, your black pill is probably even bigger than my black pill. You know all too well, although to be honest, that's a slightly self-selecting sample, but still, you are well aware of what's possible. You know, maybe only people that are on the lower end are likely to call. So you might be getting a skewed representation, but at least you're getting an exposure to what's possible on the lower end of the curve. So you might be even more black-pilled than me. Lord.
You know if the state police had any access to them?
So in terms of during the trial, after
I saw a great video on IT. I will share with you this video because it is emblematic of the problem, right? This was created to explain IT support, but it really explains just customer support in general and really kind of just explains people in general. So it explains many things beyond. Give me a second to find this thing because I want to share this with you so that we can all appreciate this together and hate our lives collectively. Give me a second to find it because I watched it very recently, so it's going to be in my history. One second, please. Talk amongst yourselves. This is worth it. That's what I'm going with. I'm going with it's worth it. Is there a way to filter by shorts explicitly? Come on. Too many videos. I watched too much content. Oh God, there's got to be a way to search for like in your search history to search by like shorts, right? If I just say shorts, will that work? Like I'm searching text. Kinda. Didn't work. God damn it. I hate it when you're trying to find something specific. Oh, I found it. Excellent. I found it. I found it. Yay. I found it. Okay. One moment, please. Continue talking amongst yourselves. All right, good. All right, great. All right. This will explain the problem. This will explain the problem. All your questions will be solved and you will understand everything. All right, here we go.
How do I get inside? Use the door. The what? The door. It's the thing you need to open to get inside. It's the only way to get inside. But I need to be inside now. I understand. Just go through the door. How can we fix this? I'm outside. I need to be inside. Yes, I understand. I need you to use the door to enter. This needs to happen immediately. Make it happen. I would really love to help with this, but it has to be you. You need to walk through the door to be inside. Why aren't you being helpful? I need to be inside. Do you see the door? Yes. Okay. The door is the only way to get inside. You need to walk up to the door, use the door handle, push open the door, then walk through the door, and you will then be inside. This is not acceptable. I'm still not inside. You have not done anything to help. How do I get inside? Use the door. The what? The door. It's the thing you need to open to get inside.
Yep. That's the problem.
Each day the court officers would collect our notebooks. So we were not able to take them home or write any more notes or look at them when we went home. When we came back the next day, again, it'd be available to us, but we would never have them available in the secluded area where we were. It was always only in the courtroom so we can write notes in the courtroom. At the end, during deliberation, we were provided all those notebooks. We do not know. All we know is it was kept in a secured area by the court officers, but we don't know if the state police or anybody had access to it other than the court officers.
Okay. This is Nicole for $10. Says, hi, Ronnie. There were several medical professionals on the jury.
Did I look at Polymarket today? I actually did not look at Polymarket today. Let's take a look at Polymarket today together and see if that makes us feel any better. Although I'm not sure it will, but we'll look at it for whatever value it has, which, whatever. All right. Right now, they're predicting 25% chance to convict. That sounds about right. And 78% chance to acquit, or 76% chance to acquit on all the charges, which leaves a -1% implied chance that they convict on a lesser count of count 2, count 3, or hang, because that's more than 100%. Yeah. So because it's the way the guilty is written. It's guilty of the murder or like vehicular homicide with DUI. I think is what the way it's written. So like yeah, it's 25% to be convicted that way. 76% chance to be acquitted across the board, which speaks for itself, which leaves a negative 1% implied chance of a lesser of count 2, count 3, or hanging. Yeah, that's great. Yeah, when you have more than 100%, you know something's wrong. Yeah, because it's percent. It's percent. What is cent? What is cent? 100. 100 is cent. Like a century is 100. Yeah, so it's per 100. That's why it's called percent. That's literally why it's called percent. It's per 100. Cent is 100. That's why it's called percent. You have more than 100%. Great. That's the. It says guilty of officer's death. No, yeah, you have to actually go into it. When you actually go read the actual rules. I know it says it in the title, but if you actually go read the rules, it says the market will resolve to yes. I'm sorry, I'm not showing this on screen. The market will resolve to yes if Karen Reed is found guilty of either second-degree murder or manslaughter by a vehicle while under the influence. Otherwise, the market will resolve to no. So it's not. It's more specific than that when you actually look at the actual rules. So the title itself is misleading because that's what it says in the rules. So yeah. Yeah.
See, the foreman was a physician's assistant. There was a nurse who was one of the not guilty voters. How did they justify John's injury with a motor vehicle accident? And, you know, as a nurse, so this person's a nurse, and they say, as soon as I saw the autopsy photos versus the vehicle, I immediately knew there was no way that he was hit by that vehicle. So I do know that one of the three solid that never wavered on not guilty, one of them was a nurse. Was she vocal about that? Because nurses are unanimous. Every nurse I've ever talked to is like, no way. Did the nurse offer her input a lot during the deliberations?
So
yeah, I mean, I'm having a lot of trouble with that one. Like how is this injury supposed to have occurred with these injuries? It's like it doesn't really make sense. Yeah. I also like etymology for that reason. When you go look up a lot of words, when you go look up the words and how they came to be, they're often just the smashing together of other words in other languages, which is kind of fun. Like it's actually very literal. When you go look up how the word came to be, it's just like, oh, these two things that were smashed together and then became a word by itself at some later point. I find that kind of funny. It's like, it's just literally like these two things together and then it just becomes a word unto itself. I find that humorous. I don't know. Maybe I'm humored easily. I don't know. Etymology is fun. That's what I'm going with.
The medical group was pretty vocal in terms of looking at the injuries based on our experience and seeing that it seemed inconsistent with the damages to the vehicle, and therefore that the vehicle strike was not ultimately what caused the death of Mr. O'Keefe. That being said, we couldn't figure out what caused those injuries. And I will say the medical group was trying to convince the entire group that the injuries are not consistent to the damages to the vehicle.
So the nurse was trying to convince people, like, look, I'm a nurse, guys. I see this all the time. That's not consistent with motor vehicle collision.
Correct. I think we were all kind of saying, no, that is not consistent based on our experience on the damage to the vehicle and the injuries that Mr. O'Keefe sustained.
If you were all saying that, If you were all saying that, how were you voting guilty? If you were all saying, no, this is not consistent, this doesn't make sense, how were you voting guilty? Make it make sense. Make it make sense. Please. Please make it make sense. If you all believed, right? If you didn't believe it, I guess, I'm not sure how you didn't believe it, but we could have that discussion, how you didn't believe it. But if you all believed the injuries were inconsistent, how on God's earth are you voting guilty? Make it make sense. Ron H for $9.99 says, just think Ronnie actually tossed these ideas around with the jury. So they're not necessarily his own thoughts. Even if they're not his own thoughts, apparently they reflect other people in the room. So even if you believe that Ronnie is not speaking for himself, which, you know, okay, fair enough. Even if you believe Ronnie's not speaking for himself and he's speaking for other people in the room then. So either way, whether or not it's Ronnie or someone else, either way, that person's in the room. How is that a thing? How is that a thing that's happening? I don't understand. P.S. Love your humor with the brain surgeon. With this brain surgeon? Yeah, okay. Well, brain surgeon, I have a question for you. I have a question, Ron H, as a brain surgeon. Do you think you could repair whatever damage is happening to my brain from this, from watching this? Do your skills as a brain surgeon allow you to fix whatever this is? Because if so, I may need to employ your services. Do we have the technology to fix the damage that's currently happening to my brain as we speak from this? Or is it just irreparable? We don't have the technology. I'm sorry. Which of those universes are we in? I fear it's universe number 2, but maybe you're aware as a brain surgeon, maybe you're aware of techniques that I'm not aware of. So maybe you can give me hope and say that this is fixable after all. We don't know how to fix it. We don't know how to fix it. We don't know. Yeah, that's what I'm afraid of.
All right. Next question here. We have, this is from JJ, sends $10. You said you guys came to the conclusion, or that some jurors came to the conclusion that she hit him because she was there, he was there, and there was some kind of collision. If the defense did a better job at explaining that he wasn't hit by a vehicle, would that have changed your thoughts? Or if they focused on John sustaining injuries inside the house instead of from a vehicle? I don't understand the second part of that question, but I guess my question that will go along with this is like that. Do you think that they focus too much?
Or maybe you can do brain surgery to like make me stop caring. Although that sounds like a bad idea. Maybe we go old school and do a lobotomy or something. I don't know. Maybe we sever off part of the brain or something. I don't know, man. I'm not sure the kind of surgeries that would prevent me from caring are any longer considered ethical within medical science. They used to be considered ethical. I'm not sure I'm not sure the first do no harm principles are going to really allow for that anymore. I don't know, man. I don't know. I'm having trouble. Yeah, I think I'm just screwed. I think I'm just screwed on that one. Yeah. Help me out.
Much on the conspiracy aspect of what happened and not enough just on, look at, dude, there's no way this guy was hit by a car because that's what the science says.
I think that would have been helpful because really creating the distractors, whatever distractors that.
The fact that he calls them distractors alone makes me want to punch him in the face. Is that a normal thing? And also, legally, is that justified, or does that give me legal excuse? I'd like the answer to be yes. Maybe another lawyer can help me out on that one, or something. Or maybe, yeah, maybe that helps me out with the temporary insanity. If he uses the word distractor one more time, or per se one more time, I don't know. Maybe I'll have to punch myself in the face to make me feel better. Do you think I could punch myself so hard that I give myself an injury? Probably. I probably shouldn't do that. That sounds like a really bad plan. Yeah.
Maybe like he went inside the house, he got injured inside the house. There was the dog that bit him. There was, injury in the weight room downstairs. All of these became kind of like theories and confusing or distractors to the jury. So ultimately, they just looked at the facts, and the facts were there's damage to the vehicle, right? So
this is a whole new reason for self-harm, right? I don't think the DSM contemplates this, but maybe someone with psychology or medical training can help me out on this. I know like self-harm can be a real issue, and there are many reasons for self-harm. I don't know whether or not this particular reason is known to science or not. This might be a new thing. Maybe there's an opportunity for expansion of psychology science, like self-harm caused by like whatever this is, right? This is a whole new reason for self-harm. And then actually whether or not that's a mental impairment is actually an interesting discussion at that point. Because you could actually make the argument at that point that I'm still rational, right? Because yeah, that's actually an interesting thing. Like if I do the self-harm because like I'm trying to save myself from this, right? That actually might be a rational thing, right? It's not actually a mental disease anymore. It's something else. Yeah. Well, that's a paper for Psychology Today. So you guys go work on that and get back to me. Let me know.
Simple look at it is two individuals were there. Somebody was operating the vehicle under the influence. There's damage to the vehicle. It's a broken tail light. There's injuries to John O'Keefe, and now he is dead. Then who's ultimately at fault? The operator of the vehicle.
You keep saying distractors, and that's what they were arguing. But their entire defense is third-party culprit. So are you saying that not the most effective defense for if you were
yeah, it would be like, yeah, it's kind of similar to chewing off your own arm to escape. Yeah, something like that, right? So it now becomes rational, right? It's like the guy who cut off his own leg to escape the boulder with the pocket knife, right? Yeah, so it's no longer irrational. It's now rational. It is now a rational decision. Yeah. So in that same sense, it's now rational for me to like punch myself in the face so hard to like make me stop caring or something. Yeah, exactly. That kind of idea. Yeah, we're on the right path. Yeah.
coaching their lawyers for the second trial, like, would you say that isn't that as effective as you guys think it is?
I don't think it's as effective. I think it would have been better to focus on the evidence that the state is trying to promote, and focus on those and show the holes on those, or create the reasonable doubt based on those pieces of information. So, for example, have an expert other than the individuals that were there who could actually talk knowledgeably about the physics of damage to a vehicle. I understand the ARCA group, but somebody else potentially, or clear indication that this is not a distractor. I think having those individuals testify at the end, after all the other distractors, which was the expert on animal bites, and then also the little pieces of distraction there that was created might have not helped the last person.
But the last two to go were the ARCA guys.
I think if the ARCA guys had gone before the distractors, I think it would have been better, because then it would have been more solid that, okay, the physics is not there to promote the damage to the vehicle, and then introduce other explanations that may have caused the injuries and caused his demise.
Okay. Next up, this is from.
Well, I'm losing market share again. We were having 1,500 people watch live, but now we're down to 1,100 again. So we're losing market share. So again, for that reason, I guess we should probably watch something else, just for sheer market share. Like, if people aren't interested in watching this, I'm certainly not going to torture myself any longer. So I guess we need to do something else, right? I can get these viewer numbers by talking Supreme Court, and then the pain will stop. We can talk something else. Okay, let's watch a different interview or something. Let's watch. There was some other stuff this morning that we can watch. Let's watch. Vinnie Politan was outside the courtroom a little bit earlier today. Let's watch that for a while and see if you guys like that better. So let's watch this video. First of all, Vinny, I'm not sure about those sunglasses. I don't know if they're really working for you or not, to be honest, but you know, I don't know if those sunglasses really are the best for your, you know, body, but you know, okay, whatever.
Now it's time to get in with the people, in the middle of the people. That's where we find, there he is, lead anchor, Vinnie Politan. All right, Vinnie, we've covered a lot of trials. This is different. There were people outside courthouses before, like a Scott Peterson, but they were there for the lynching. This has people on both sides, and it is unique. Give us your perspective of it and set the scene from your perspective.
All right, Ted. Great to see you, Ted. Sunny day here. I mean, it's absolutely beautiful. I don't know if the weather is adding to it, but there are so many people here. It is a literal sea of pink. I don't see people for the other side. This is one side. And you and I were there for the Scott Peterson trial, Ted. And I remember how many people were there, and I was like, oh, my goodness. It pales into comparison to what we see here today, the number of people that have come here. I'm going to walk you through the crowd, Ted, so get ready. Just be careful. Watch your step here with the camera. We're going to go down nice and slow. We're not going to go fast. But as we walk through the crowd, first let me show you down this way, because it starts on this side down here, okay? They're here all day. Everyone here, I believe, is expecting a quick verdict. They think it's happening today. Now, I don't know if it's happening today. They don't know if it's happening today. I don't even know if the jury knows if it's happening today, because we don't know what's happening in that room, but it can happen at any moment. But as you walk through here, the one sense you get is that they expect not guilty. They absolutely are locked in on not guilty. And you wonder, what will the reaction be, right? What is the reaction if it is not guilty? What would the reaction be if it is guilty? That's what I want to find out. So let's talk to some of the folks. Can I talk to some of the folks, Ted? You want to hear from the folks?
That's what
Sorry, I was muted.
yes, absolutely.
Ted wants to hear from the folks. Okay, here we go.
I was just saying that if it's guilty, a lot of people are going to be very sad and very irritated, is what I was saying. Oh, Lord.
The pink ladies, let me ask you. If it's not guilty, what happens here in the streets of Dedham?
We're not going to be happy.
If it's not guilty?
We come back and do it again.
No, if she's not guilty. Oh, if it's not guilty?
Okay, Ted, I'm so sorry. I am so sorry, Ted. Can we?
Great.
Do another take on that, Ted?
Yes,
okay.
take two.
Wait, I'll walk up again. Let's walk up again. Take two. Okay, so what do you think the reaction is going to be here in the streets of Dedham if the jury comes back not guilty?
Are you kidding me? It's going to be party in the streets. Yes.
But you
yes.
can't. Shh, but you can't scream now, right? You still have to be.
Oh, please. If Karen comes back and he comes back not guilty, this place is going to be joy. It's going to be wild. It's going to be tears. It's going to be happiness, relief. The pressure that we've all felt, and the anxiety and the frustration and the corruption and everything that we've been feeling for all this time is going to be worth it in the end if we finally are able to see Karen get the justice that she deserves.
Now, Ted, I don't know if you can notice, but the lipstick actually matches the shirt.
That's right. This is not my first rodeo.
All right, not first rodeo. Let me ask you a question. Who wants to speak here?
I will.
You'll speak. I want to ask you on the other side. If this jury comes back and says guilty, what do you think happens here in the streets of Dedham?
Sad, very sad time, because we all know she's not guilty. He wasn't hit by a car, and John O'Keefe was not hit by a car. It's a very simple. simple. But if they do come back guilty, we'll all be very saddened, and there'll be a lot of, I don't know, what else can I say?
No, that's interesting. I just want the truth. That's all we want is the truth, right?
Yeah,
all right.
we want the truth. And it's too bad that they don't find the truth and actually go after the people that actually did kill John O'Keefe. Because now you've got an innocent woman being framed, and people that did it are getting away with murder. And that's just not right.
Okay. Thank you so much. All right. We're going to walk further down here. You see some of the stars and stripes, Ted. You can see those as well. This is, Ted, I'm going to show you the VIP section. You ready, Ted?
Yes.
These folks, you got to get here early
They got
to get
shade.
the lawn chairs.
Yeah.
6 a.m. 6 a.m. they got here to get the spot under the tree. You got the shade.
They got a little table. They're doing a little picnic out there. Very cool. Doing a little picnic action. Some lawn chairs. I mean, you know, all right. That's cool, I guess.
You're ready. I just haven't seen any of the waiters or waitresses coming by yet to serve them lunch, but
I have a feeling they brought their own in those tumblers, but
yeah, they brought some of their own refreshments. That is true, Ted. Here's crackers right here. Okay. She does not want to be on camera, but this guy does. Ted.
Oh, I've seen that dude.
You ready, Ted, for the best dressed man? Best dressed man right here. There's my man. How's it going?
Going good.
Let me ask you, how long did it take you to decide what you were going to wear for the verdict watch today?
I just open up the closet and just pick what I feel. Yeah.
All right. Will you come every day? Because, you know, the verdict may not be today. It could be in any minute, any moment, but it may not be today. Will you be here tomorrow?
I'll be here as long as it takes.
As long as it takes. Absolutely. Yeah. Okay. All right. I mean, I'm so jealous, Ted. I'm so jealous that he's got that outfit and I don't have that outfit. Are you guys going to come every day?
Yeah, I would like to. As long as it takes.
As long as it takes?
As long as it takes.
Are you using vacation days today or?
I'm off today. Business, but.
Okay. No, I'm just wondering.
I don't know.
No, I'm just wondering because it takes time to be here. Right.
Yeah, 10 days.
Right.
Any
Like,
kind of day.
to me, that demonstrates.
Just quit your jobs.
Yeah, well, to me, it demonstrates the level of belief, right, and concern that you have that you would take your own personal time to come here. I mean, that's making a statement.
Yeah.
I believe. Okay. But you'll be here every day.
Be here every day.
We'll take attendance. Make sure you're here.
All right.
All right. So, Ted, the other thing that is really interesting, everyone's got a camera, right? Which is awesome. Can I speak with you?
Sure.
Let me ask you, why do you think so many show up? Like so many. I've never seen this. The closest we would get to this, Ted, is this probably close to Michael Jackson, maybe?
yes, absolutely. Yep.
Yeah, this is, and that was the world's most famous celebrity. This is Karen Reed. Nobody knew her before this. Why so many people?
I think people are just convicted in what they believe. Whether you feel for the family, which I do, but I don't believe she did it. And people are strong about that. They don't want it to happen to me or you or anybody just because someone's covering up for something, which could be or may not be. I don't know. But
the jury will tell us, right?
I guess so.
Well, hopefully the jury will tell us. Ted, the other thing, I've spoken to folks earlier today, and there are people coming in from different states. There was a family on vacation from Nebraska, made sure.
Yeah, if I could get that last second flight, what's the probability I could be there at 6 a.m? I guess if I get a flight out today, I could be there at 6 a.m, maybe. I get landed in Boston or something. I could wear my hats. I'm not sure how I'm going to bring a lawn chair, though, on my flight. Maybe I can stop at a Walmart and pick up one or something. I don't know. Yeah, maybe I should go camp out there with my hats. Camp out in front of the jury. I don't know, man.
To make this one of their stops coming through. So the interest, yes, is extremely high locally, but I think second time around what is different is how it has spread nationally. And that interest now has brought some folks to Dedham, which is it's a nice town, it's historic and everything, but it's not necessarily a vacation destination town.
It's not on your tourist list of things to do.
No, you might go to Cape Cod, you might go to the city.
I could say hi to Ronnie. Yeah, could someone look up for me real fast? What are the criminal penalties for simple assault in Massachusetts? Just so no particular reason.
But like to Dedham, but this is where the story is, this is where the action is. And this is where, again, everyone's wearing pink, just about. Should I find some? Yeah. Now, is that actually pink, or is that?
This is hot pink.
That's salmon.
No, this is fuchsia.
That is salmon.
This is fuchsia.
Okay.
You're awesome. You're doing great.
Thank you. What are your expectations about when you believe this moment will happen.
I believe by the end of the day they'll have a verdict and then they'll come back in the morning with it.
They're going to sleep on it.
I believe so. I'm praying it's today, but who knows? Okay. We're just hopeful for a not guilty, not guilty, not guilty for Karen. Not guilty.
All right, you just got a fourth not guilty over there. Ted, and like I said, Ted, most of the people I've spoken to expect it to happen today. They really feel that strongly about the case, and I think a lot of them were very...
Apparently, there's no court Thursday or Friday. There's no court Thursday or Friday. Does the jury know that? If the jury knows that, and I would think that they would, I would think they would know. If there is no court Thursday or Friday, assuming they are deliberating that long, I'd be somewhat surprised if they deliberate past Wednesday. Right? Friday was the very first day they got the case. You know, so there's that. But if they're not going to be, if there's no court Thursday or Friday, and you have to come, so Thursday, Friday, Saturday, Sunday, and you have to come back on Monday, that alone would yield some pretty fast, you know. So if the jury already knows that, which you would think they would, but the jury already knows that, that suggests, you know, incentive to bring this to an end. Yeah.
Very impressed with Alan Jackson's closing argument. Obviously, we've been watching him for years, Ted, and you watched him out in L.A. Many years before this. So I think that had a lot of impact on the opinions of people here because of the strength of Alan Jackson's closing argument. But I'm trying to remind you.
He delivered a doozy. I mean, that close was as...
Yeah, I guess Thursday is Juneteenth, right? Yeah, Thursday is Juneteenth, and then I guess they give them Friday for free. Okay. Yeah, because Congress created that federal holiday like last year or the year before or something like that. Yeah, so June the 19th is now a federal holiday. Yeah, okay, great.
Tight as you could get with the emotion in the right spots, the length. But Hank Brennan came back to, there doesn't seem to be, Vinny, correct me if I'm wrong, anybody.
What is Juneteenth? Juneteenth is the celebration of when Texas learned that slavery had ended, because apparently it was the last state to learn, you know, so because news travels as it does. So apparently June 19th was the date that Texas learned that slavery was over. So that's I guess that's when they figured it out. So yeah, we celebrate that for some reason. I'm not sure, but that's what we're doing now. So okay, fair enough.
Thinking that this is going to be a hung jury, which to me, if I'm going to lay down some money, that's where I'm going.
Right, and what I try to remind people is that...
No, not June 19th of last year. It was, the federal holiday was created like last year or the year before. But no, in 18 whatever. Presumably 1865, I assume. But presumably it was 1865. So presumably, yeah, and then like 2 years ago, Congress decided to make it a federal holiday. No, not less. No, Texas isn't that dumb. I mean, damn. Jesus.
As much as they see the evidence as being so clean cut, oh, let's turn around. You see what's happening here. Someone came down the street honking their horn, and now they get approached by police. Because this is, you notice how quiet everyone is, Ted? Like you've got hundreds and hundreds of people here that are remaining quiet. A car comes through, honking the horn. Police immediately emerge on them because not everyone understands what the buffer zone is and what it isn't. Usually you see a demonstration, you show your support, you honk the horn. Not here in Dedham, you can't do that. They don't want anything to influence the jury, which is in this old historic courthouse with very thin walls.
Is there any way, Vinny, that this jury doesn't know what's happening outside the courthouse?
I would say no. I would say no. I would say if you live in the area, how could you not know about the story, about the case? I think the jurors they got, may not have been in as deep as the folks here and many of the folks online, but you may have heard of it. But the thing that's interesting, Ted, is that we're looking at it now at the end of trial 2. which to me was so much bigger than trial number one, that there may be many more people that before this trial began, may have been in a place where they weren't as familiar. So I think that plays into it, because you pick the jury before the trial starts, and now that we've gone through number two, with it being so much bigger than number one, I would say if you had to do number three, it's going to be very difficult to find those 12 at that point, because of the way this has spread. But if you look around, take a look down the street, it goes even further down. I was up here in the beginning of the trial, and none of these people were here, Ted. These are all Johnny-come-latelys. I was here when this trial started back in, or not when it started, like 2 weeks in May. I came out, there were a dozen people over here, there were 6 people over here. But once it's time for the verdict and deliberations, it's obvious that everyone's going to use their time to show their support. I think the support early on was hampered by the weather, was hampered by the rulings in the buffer zone, completely changed the dynamic. But since it's been relaxed a little bit, the dynamic has come back. And the best part is, like I was saying, Ted, you have hundreds and hundreds of people here who are abiding by the rules, which is you're not chanting, you're not screaming, you're not yelling. And it's not easy to do. You get in a crowd, you get excited, you want to, make your point, but everyone understands the gravity of it. And I think that's where we are.
Yeah, absolutely. All right, Vin, you just be careful. You stay there and get to know some more people and hang out. And we are going to come back to you many times throughout the day. And of course, as soon as we hear that there's a verdict or a question, we'll rely on you as well.
Ted, can I show you something, Ted?
Yeah.
Ted, can I show you something?
Sure, of course.
You know we're in a verdict watch. We're in lockdown. Well, you know why I wear the purple tie, because I can't wear pink, I can't wear blue, I got to split the baby. But when it happens, Ted, here it is. The verdict tie is ready. The verdict tie is ready. So any moment, I'll be changing ties. We'll see. We'll see.
Okay.
Back to you, Ted, in the studio.
That's Vinny Politan, our roving reporter.
All right. Very cool. And then let's watch another one that had some video from earlier today. Let's see. So here's from LTL Media. They had some video today. So let's take a look at that.
Wyatt. We are out here, everybody. The crowd is filling in. Welcome in, everybody. Welcome in, welcome in. Smash the like button. I don't know how good the live feed's going to be, but I'll
the little jank
I'll have some video that I'll upload later.
It's a little jank.
And,
okay, it's a lot
I'm not gonna be
jank.
able to read the comments.
It's a lot jank. Currently being filmed with a potato. 1080p potato. What can you do?
How are you?
Yeah, it's not like this. I have to I don't know. Like, this is the first time doing it. Oh my goodness.
What's that? That's good.
He's having bandwidth problems. It's probably because of the density of cell phones in the area, right? Because when you get more and more cell phones, sometimes you have problems with connecting. I'm sure you guys have experienced that before when you've been like where a lot of people are and like you can't get a signal to save your life because the network is overwhelmed. It's like, yeah. So it could, yeah, it's probably a bandwidth issue. The network is a bit overwhelmed. So we got Potato Cam. Okay, Potato Cam. Tell us more.
making compliments on it. Should have down. Brian LTO.
Hello.
Yeah.
Not guilty, right? Not guilty.
Not guilty. All the way. Not guilty.
Morning. Say hi to everybody around the world.
There's a lot of pink.
I haven't.
I'm not sure really pink's my color though.
Yeah. Yeah,
I
absolutely.
don't really look good in red either, to be honest.
Thank you.
Red's not really my color
Unfortunately,
either.
I can't see the comments, everybody. The way that StreamYard lays this out in a mobile, it sucks. StreamYard, fix your app. But I know that people are commenting, but I'm sorry, I can't see them.
Salmon. A pink tie. Burgundy. I could probably pull off burgundy. Burgundy tie I could pull off.
Brandy, this is Karen's sister. Hi, Karen's sister. I love you. God bless you. Hi, Liz. Nice to meet you. Today's the day, right?
Yeah, burgundy tie is probably the way to go.
He's like, I'll try.
How you doing? How are you?
Petro's over there.
I know, I walked by him.
I'm trying to sign bomb him when he's live, and he's getting all mad at me.
I might go over there after.
I'm like this.
You know, this is a FCC violation, FCC violation.
And he keeps looking back because he knows what I'm going to do. And, you know, he's waiting until 8 o'clock because I can't have the sign anymore.
Oh, okay, yeah.
This
is an FCC violation.
So, what time is it right now?
5 minutes out of 8.
I got 5 minutes.
5 of 8.
Turn into a pumpkin. I have to get rid of the sign. What were you just saying about the sign?
Look at this crowd. Amazing. Look at the crowd. It's amazing. And it's filling in. All across the street.
You know, in 5 minutes, I can't have the sign.
I'm sorry. I wish I could see the comments. I can't see the comments.
Until I'm freaking lead sign. Oh, hi. I think today's the day. We have a lot of people here.
One more person, Brian from LTL Media.
How are you? I'm good. I'm good. I'm good. And I think today's the day. I feel it. Not guilty. Not guilty. Not guilty. Not guilty. And if anybody's wondering, I'm talking to Karen's sister. I'm not going to put her on camera.
All right,
But thank you. I don't know how good the signal is down here.
All right, 7:55, so it's like 5 more minutes, and then the Karen Reed stuff has to be covered up. And yeah, we do this symbol. I know some of you that have been around, I'm gonna write it. No, you aren't.
So in 5 minutes, all the Karen Reed signs have to go away because that's part of the buffer zone requirements. Again, I don't know how good the stream is, but I'll video this all up later. I'll upload the video. I'm sorry. I wish I could see the comments, but I can't. It is wildly filling in down here, especially in the last 5 minutes. Tons of people all across the street near the Deeds building.
And you.
What's it say? Karen Reed is my hero. FBI hard ARCA, Gen Lied. I love that. That's great. That's really good. That's really good.
Yes. So who did you have use Okay. Thank you. Thank you very much.
Hey, Brian, how are you? Say hi to everybody.
Hey, how you doing?
This guy has literally photographed every moment of the hearings, the trial, the retrial. This man has been down here in the heat, the cold, and just phenomenal job, Brian.
And the other
you
day
have beautiful photographs.
The other day, he actually brought the pink lens. Finally, after 3
Oh,
years of me asking.
Oh, he had the pink lens. The pink lens. Yeah, that's great. Good stuff, Brian. It's a hell of a photographer. He's really good. Really, really good. Oh, we got Rita. Let's go say hi to Rita. Rita! All right, Rita, what do we got? What's going on today?
Today is
Let us know.
Monday, June 15th, and today we are praying for justice. We are praying for an end to this nightmare. And we're praying that this jury does the right thing, looks at the evidence, looks at the science, looks at the medical, looks at the engineering, and sees that there was no
collision. No accident.
There was no collision.
There's no collision.
Yes.
Tiananmen Square. Yeah. How the cops come down here, dude.
Wonderful. Yeah, they wanted us, like some of us, to be over here just to be with. They didn't want to have to come out and tell the crowd like you can't do this, you can't do that, and take it personally.
Kind of
so they have
yourself.
some of us, and you've been down here. We police ourselves mainly. It's just a matter of informing everyone down because everyone's just as passionate about it, you know, and everybody's been good. And like I said, folks, this is not an anti-police.
Yeah, of course.
movement.
No,
so
no.
don't come down here and just automatically just get in their face.
Right.
There's a lot of wonderful good cops down here, and they're just doing their job, and we're just trying to make it flow good and get Karen safely inside and outside.
Of course,
court,
of course. Welcome in, everybody. Make sure to smash the like button.
7:59. If you have any free Karen Reed stuff on, you have to have it covered up. Cover your signs. Make sure you don't no hats on or anything. Okay. 7:59. Just cover it up.
Oh, I have some.
And make sure it's not showing at all. Okay.
Again, I don't know how good the stream's going to be, but I'll upload this video later because I'm capturing the video as well, and we'll get it up on the channel for everybody. Because I'm sure the internet connection's terrible down here. And I apologize. I wish I could read the comments. I can't. The way this app is set up, it's really hard to read the comments on the phone. So I appreciate everybody supporting. If you haven't subscribed yet, make sure to smash the subscribe button. Oh, sorry, sir.
Wow.
I'm Amanda.
Oh, nice to meet you.
Nice to meet you. I saw you post some pictures from the Eagle Event Center.
Oh, yeah.
I'm one of the owners.
Oh, okay,
so
awesome.
I'm good friends with Mimi.
Yeah, it's beautiful in there.
It
How old is that building?
1929.
Yeah, it's really nice.
I stopped whispering around this time, so it's like a trained animal. Like they're coming.
Yeah.
As I wear a shirt, the full system inside.
Can we get a selfie?
Oh, of course.
Well, you probably better.
Let's see what I can do.
Since you hold up all day, every day.
Let's see. I think we got it.
I think so too.
Awesome.
Might as well get one too.
All right.
Come on. Bring it in, Mom. Do it. Bring it in.
Yeah, absolutely.
Let's get one of you.
Sure. I used to sell these watches for 16 years. I worked for that company. Yep.
How come I can you push the button? Get in, ladies. I can't push it.
Your picture's going to have my finger on it.
It's not bad.
They come out good?
Yeah. No, it did.
I think I'm out good.
It's going up on Trump.
There you go. Yes, of course. Do you want me to push the button?
Yeah, that'd be even better.
Come here. I'm deaf. It's all easy to shift that way because they're like a little kid. You gotta stop staying down here.
I think more of the fact, just what I said last year. I understood that. Oh, like last year was a conversation between them of, should we have just had a DUI charge? Maybe that would have stopped them from being hung on the manslaughter charge. So I think that's where that stems from, because last year they were in the same situation. They didn't want to hung a jury, and ultimately they ended up being hung on was she drinking and driving and was she killing. So I think that's where that stems from. Personally, I didn't know about it until the other day until I got at it, so they weren't making it. It could have been like a last minute decision, but it wasn't something that was, I think had a lot of momentum behind it. It was like a last minute type of thing. I think Karen ultimately was like, maybe this was said, this one on the jury. So.
But how does that work? Isn't it typically entirely up to the prosecution?
That's what I thought. Yeah. I mean, I don't know how you can just add a charge. But I mean, hey, I think for the Commonwealth.
Kind of like Alan Jackson said, I can't charge you with perjury.
Right. I think it had to have been a discussion with Hank Brennan to add that. If not, I don't think because they ultimately didn't want any less included. They wanted it.
Yep. Guys, I'm gonna shift everyone back a little bit.
You gotta stay down this way.
One, two.
You got this. You got this. Oh, yes, you got this.
Right. Hi, Neil.
Restaurants, you guys don't end up in the street, you don't get hit, you don't make a bad day of anything. So I appreciate you guys cooperating.
Thank you.
Thank you. Thank you. Next time you go, you're not coming back.
Remember, we still have Hank Brennan to come in. The O'Keefe family. Stanky and Lally. Nobody's on the ground.
Jess Machado.
It's just Machado.
Muted. Sorry. I'm sorry. My fault. Yeah, sorry, my fault. Anyways, there was a video suggested to watch from this channel, Yellow Cottage Tales. The video is entitled Karen Reed Deliberations plus Alan Jackson Show How to Turn Half-Truths into Narrative. So this is, I suppose, from the anti-Karen Reed contingent. Alan Jackson's masterclass in how to turn half-truths into narrative. Now this video is 4 hours and 26 minutes long. So, you know, that's a lot of video, and I don't really want to watch 4 hours and 26 minutes. So if there's like, you know, 5 or 10 minutes worth of this I should watch, you know, to see if I like to watch more, then that's fair. But, you know, watching 4.5 hours, you know, is not fair. So is there a particular timestamp that you'd like me to start watching at, or to something to give it a fair shot? Let me know. So sorry? You don't have to be sorry? No, there's not? Oh, okay. There's not 5 minutes or 10 minutes worth? That's just, okay, fine. Well, in that case, I'm not going to watch it because it's just way too long. That's not fair. So what else could I be reacting to? What else would be good to react to, or other discussion would be good? Let's see. See if there's anything in chat. J.E. Walsh is in my Discord. No, he's not. Where's my, yeah, goodbye. You're blocked. That was fun. Let's see. All right. Let's see what else is going on. Boston Raw from Survivor. Did we listen to the other juror that Turtle Boy interviewed? Yes, we did. We watched her entire interview earlier today. JD Lawyer Explains put out a 1 hour recap of the trial. We could watch that, I suppose. Look back at the testimony in the Karen Reed trial.
As we wait for the jury, I thought it might be nice to perhaps take a retrospective look at some of the sentinel moments in this trial. And with that in mind, that's what I'm going to do. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. In this trial, there were numerous examples of witnesses who were caught lying. There were alleged experts who turned out not to be such great experts. There were just some moments in this trial that made my mouth drop, you know, what? And I don't normally have that experience with trials. Normally the evidence comes in pretty much the way you expect it to. The cross-examination goes pretty much the way you expect it to, but not in this case. And in fact, notably different than probably 90% of cases out there. This was a battle royal between a great lawyer and a good lawyer. And by good, I mean technically good, not necessarily morally good. So in no particular order, I'm going to go through some of the witnesses that the state put on, some that the defense put on, and just kind of remind you of all of the things that have gone on, some of the things that I've talked about in this trial, and perhaps you'll find it interesting as a retrospective of this trial. This is going to be a much longer video than most are. But again, if you haven't watched the whole trial, you haven't seen all my videos on this trial, it's a good way to familiarize yourself with at least some of the more relevant facts in this case. So the first thing I want to look at is Mr. Alessi's cross-examination of Ms. Hyde, who was one of the state's cell phone experts.
Okay, so focus on what it is you think Jessica Hyde should be prohibited from testifying about.
Oh, Your Honor, I am not seeking to prohibit her from any testimony under this rule. What I want to do is to have it admitted in evidence, have it published, and question her on what she presented to the court in the Maryland case, what was presented, her report, because it was deemed not reliable.
What's notable about this is the way in which the judge limits the cross-examination. That's the first part.
In March, and you recall on your direct examination, Attorney Brennan asked you questions going to your experience and qualifications. Do you recall those questions?
Yes, I do.
You were involved in a case, is actually a murder trial in the state of Maryland in a case called State v. Herrera as recently as March of 2025, correct?
Correction, it's an attempted murder.
Attempted murder. And in that particular case, you had attempted to offer various opinions to the court, correct?
I object. You have to move along from this case, from what you're talking about. You have to move around.
Do.
And is it correct that in that case, you submitted arguments on behalf of the prosecution in that case?
I submitted an amicus brief, which is not on behalf of anybody. It's as a friend of the court.
Right, but the friends of the court, you took a position in that, quote, friends of the court brief, correct?
Took a position on the evidence.
Right, and the position you took on the evidence was that the frequent location history data is reliable and should be used. Is that correct? I'll repeat, using a variety of different artifacts, we can see active interaction with the mobile device up until 12:20:50 a.m. ET. Do you see that statement?
Yes.
And then if you skip down, I'm going to skip a couple sentences to the paragraph under the chart, and this is the key part.
Okay.
It says, from that point, and I'm understanding that point to be the 12:20:50 a.m., correct? You need to say yes or no, I'm sorry.
Yes.
There is no indication of interaction with the device. Did I read that correctly?
That is correct.
So I am going to, and you believe that statement is correct?
Until 6 something a.m.
No, I'm sorry. I'm just asking if that statement is correct. Not if you have other information, but is that statement correct? I object.
Can you answer that? Ms. Hyde, can you answer that, yes or no?
Did I read that correctly?
You read it correctly.
Thank you. If we could, Your Honor, have a document that is put up already in evidence and publish Exhibit 39. And it will be, thank you. And if we could go to slide 82, please. And Ms. Hyde, if I could draw your attention to the entry that is, it says 3209 under app lock, but we know that the 00 is a 12. So it's 12:32:09 a.m. on January 29, 2022. And I'm going to read what it says in red, and this is a timeline of Mr. Whiffen. You know Mr. Whiffen?
I do know Mr. Whiffen.
And so he put in red, not us, he said device locked with lock button for the last time. Do you see that?
I do.
And you know that to lock a phone, you actually have to hit the side button with regard to an iPhone to make it lock. Do you know that?
Yes, sir.
Okay. And that is an interaction with a phone, is it not?
I concur.
So that means that that interaction with the phone occurred at 12:32:09, correct?
I did not review that specific artifact. I cannot attest to Mr. Whiffen's exam, only to my own.
So do you have any reason to believe that what is in evidence in this case that Mr. Whiffen has produced, and that do you have any basis to contest the fact that the device was locked with a lock button for the last time on the phone of John O'Keefe at 12:32:09 as you sit here?
I cannot contest it because I do not recall looking at that specific artifact.
Don't you think it would have been appropriate to be accurate as a digital forensic analyzer on the topic of the last of an indication of interaction with the device? Don't you think it would have been appropriate to look at that 12:32:09 in any of the tools you said you used on direct?
I did not correlate that artifact in my timeline.
I understand you didn't, and my question is,
you make a statement. Well, let me back up. Do you understand that in this case, as in many cases, that matters of seconds in activity can be determinative of a case? Do you understand that from your experience?
Absolutely.
So it's important, therefore, to get activity right for any data forensic examiner when they're issuing reports about activity, particularly of a decedent. Is that important?
Absolutely.
So isn't it correct that the statement that you make on page 7 of your report, that from that point, 12/20/50, there is no indication of interaction with the device, is incorrect?
I cannot make that without going back and reviewing and validating the artifact you just produced from Mr. Whiffen. I would need to validate that in order to respond to that.
But as you sit here, you have no basis to contest what Mr. Whiffen has stated, that there was a lock button.
For those of you who asked, I sent a note to Defense Diaries. I sent a DM to them seeing if they want company on Twitter. So that's the only means I really have to get in touch with them. I also sent a text to Melanie Little, but heaven knows whether or not she's even checking her phone. So I won't expect to hear back from her, but I'm happy to jump on stream with somebody else and we can make it work. So we'll see if Defense Diaries or someone else wants to respond. If someone wanted to join my stream, we could do that too. It would be a little bastardized, but we can make it work too. So we'll see how that goes. Andrea had verdict watch, no invite. I didn't get any invite from Andrea. No, I didn't see anything from her. So no. $5 from Space Emerald Doll. I'm a computer science major. So am I. And normally when I see a woman in STEM, I'm so proud, but not right now. Fair.
On the side of the phone of Mr. O'Keefe, a full 12 minutes after you say there was no interaction with the device. Is that correct?
I don't. I would have to review that portion.
And then the second part goes down to what a sloppy job she did in evaluating this phone. Like almost all the experts hired by the Commonwealth, they just couldn't get somebody to do their job or do it the right way. But when the prosecution wanted to be over the top and go ugly on the witnesses, particularly Dr. Wolf, who in a voir dire, which occurs outside the presence of a jury, he was mean and nasty. And the reason he was mean and nasty here and not so much in the trial is because he didn't want to create a bad impression for the jurors. But what you see here is Mr. Brennan's real personality. Let's watch.
Well, when you spoke on March 20, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. No. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolf, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknowns, so there was a lot of uncertainty.
So what you saw there with that "you're not answering my question" thing is actually the man was answering the question. If he had asked it differently, if he had used a leading question, he could have gotten the answer that he wanted to. But what he wanted to create was this idea that the experts being obstreperous. And it might have worked with the jury.
Viewer count is way down, 826. We're losing viewership again. We're way down. All right. This video isn't working for you guys. No problem. We'll find something else that works for you. So does anyone else have any other suggestions of content that we could review that would be what people want to watch? The numbers reveal everything. Check other feeds? No, I'm gonna just stick here for a while. I mean, there's no point. Microdots doesn't do streaming collabs. Nick's body cam footage, to the best of my knowledge, that doesn't exist. So I can't review it. Trooper Paul, or maybe do a poll. We could do Trooper Paul, maybe. Rensselaer's Cross. Review DUI guys review, maybe. From what I've seen from other streams, people seem to really like you pontificating. The numbers disagree. The numbers do not agree with you. They do not seem to like me pontificating. I could show microdots videos. Yeah, I could do that. Okay, we can do that. Let's see what microdots has in terms of videos. What looks good. Let's take a look at this video. This looks interesting.
Each one of these little hash marks, a different color, represents 10 feet. The red lines show the extent of motion. Remember what I said, initially pulled forward, then backed up, past its initial spot, and then went backwards further distance. So what this shows is where we simulated this in a program called HVE. So that's the vehicle, the Lexus pulling forward. It's still going approximately 23 miles an hour when that ends.
According to Commonwealth expert Judd Welcher, Karen Reed's Lexus was idling in position a short distance ahead of John O'Keefe, somewhere just beyond the flagpole. We'll refer to this as position 0. He claims she drove forward 34 feet and stopped at position 1. Position 1 is even
Baldoni dismissed? Really? That's interesting.
farther from the supposed point of impact than previously believed, and that matters. More distance means more time for John to react. They'd have you believe he was just standing still, willingly making himself a perfect target, so Karen could attempt a 1 in a million shot and actually make it. Fairview Road is typically quiet, with little traffic and minimal ambient noise. In those conditions, the sound of an approaching vehicle speeding towards you wouldn't just be audible, it would be alarming.
Thank you, Bluefish, for the super chat. That's appreciated.
Welcher asserts that Karen pressed her foot down on the gas pedal, applying 75% of its full range, and accelerated toward John, reaching a speed of nearly 24 miles per hour, traveling a distance of well over 87 feet, turning the street into a slippery racing strip, striking his bent arm, causing the mismatched wounds, and projecting his body through the air, or in some other way, to its ultimate resting place just below the flagpole. The Commonwealth mostly glazed over this aspect of the collision, likely because it's the most unbelievable part of their theory. They provided no scientific evidence explaining how a taillight could produce the specific pattern of abrasions on John's right arm, how he sustained no broken bones or significant bruising, or how he managed to lock his phone after being incapacitated under this scenario. Another problem is that Ryan Nagel drove by just moments before and didn't see John inside or outside the SUV.
I was making sure my sister got in the house okay.
Specifically testifying that Karen was alone.
But you did look inside that SUV.
As I passed by, yes.
And you saw one person.
That's all I saw at the time, yes.
Female with long hair, is that
correct?
Right?
After the SUV travels 87 feet, the trigger event.
All right, apparently they're back in court or something. Oh, I don't need to do this. I can just do it this way.
We're ever going to see again.
Vinny, I got to ask you, if they do believe, as you said, she's innocent, the flip side of that is they have to believe that there was a cover-up.
No, they don't.
Clearly. That
no, they
there
don't.
was something corrupt.
They don't need to believe those
police
things.
Department.
They don't need to believe
What is it about
that.
this community that you've been able to discern, if at all?
Even Court TV doesn't get it right. Like, even Court TV does not get it right. They don't need to believe there's a cover-up to disbelieve the state. They don't need to believe that. It is not required. They can just simply believe that the evidence doesn't prove it. You don't need to believe it's a cover-up. Those are not concordant.
Allows for a belief like that amongst this many people in what I believe is a relatively small community.
Yeah, the skepticism level is huge, is high. And there have been things that have happened here. There have been other instances. I mean, there's this specific case. This movement was started by Turtle Boy, Aiden Carney. He's been here today. A lot of these folks have watched him through the years in their coverage of this, so they know every detail. Then you speak to people from Canton. People from the town where this happened, they don't trust their local elected officials. They don't trust some of their police. And that's how widespread the skepticism goes. Then you look at another case like Sandra Birchmore, and you look at a case like that where there was allegations that have turned into an actual federal indictment against police. And in all instances, people are just so skeptical, and they want to see the proof way beyond a reasonable doubt, and they're not going to take people at their word. And when I say people, I mean people representing the government, people representing the Commonwealth. They do not take them at their word. They want to see the proof, and they don't believe they've seen it, that Karen Read committed this crime.
Vinny, do you have any sense of what's happened to those against Karen Read, believing she did it, believing she should be convicted? The first time around, and you pointed this out earlier when you were speaking to some of the people there, the first time around, it was not all supporters at all. You had both sides. So this, to me, just looks very different.
There was no one here supporting John O'Keefe and his family and the prosecution. Now, a lot of the Karen Read supporters say they're looking for justice for John O'Keefe as well. They just don't believe justice is the conviction of Karen Read. They believe justice for John O'Keefe is the conviction of someone that was inside 34 Fairview Road that night. So when you have a different perspective of what the truth is, of what justice is, you can have a situation like this where people are not going after the victim in the case. They just believe there's two victims in this case because they believe Karen Read is a victim as well, a victim of a wrongful prosecution. Now, when the O'Keefe family walked in, they were the ones wearing blue. The folks supporting Karen Read overwhelmingly are wearing various shades of pink, probably about 70% of them. That's how they show their support. But you look around and you look for anyone, anywhere, who has a different viewpoint of this case. They're just not showing up at the courthouse. You know, they may very well be online. They may very well be out there. They may be watching, but they're not showing up here at the courthouse.
Vinny, no red tie today. I think you might have jinxed the verdict. I don't know if we have one or not. Any reason you went without the red tie on a verdict watch?
Oh, of course he does. Vinny Politan,
Don't wear the red tie for a verdict watch, Michael. Michael, a verdict watch is not a red tie affair. So purple, you can't wear blue. Blue is one side of this case. Pink is the other side. You split the baby, you got purple. That's fine. Red is for the verdict only. So once we get word that there's a verdict, then
did you bring a blue
tie?
tie? Did you bring a blue tie?
Shirt. I always have it with me, Michael, during verdict watch.
I knew this. I knew this, and I'm sorry I didn't remember you only put it on for the actual verdict. It's like Tiger Woods, right? He only wears the red shirt on the final day.
But it makes sense because we could.
No, the judge cannot swap in jurors merely because it's hung. They can't do that. Yeah, you can't swap in jurors merely because it's hung. That wouldn't be fair, right? It wouldn't be fair. Suppose it's 11-1 to convict, right? Because you don't know what the hang means. You don't know what it means. Suppose it's 11-1 to convict and there's one holdout. It wouldn't be very fair to sub that one juror with someone else, would it? That wouldn't be really fair, right? So, and if it's 11-1 the other way, it's no more fair. So you can't swap them out merely because there's a difference of opinion. That's not a valid ground. So yeah, that doesn't work. So you can only basically swap them out for misconduct, not because they have a strong opinion. You can't even swap them out if they refuse to talk. Right? If you have a juror who's like, no, I'm guilty, or no, I'm not guilty, and I refuse to discuss it, you can't even swap them out for that reason. You can't force them to talk. You can't force them. It's like, I'm just solid and I'm done. You can't stop that. So, you know, yeah, it is what it is. Can she overrule the jury? Only one way. She can only overrule the jury for a not guilty, to a not guilty, more specifically. Yeah, she could put in a not guilty verdict. She can do that. That's it. That's the only thing she could do. So she can dismiss the jury. She could direct a verdict and not guilty. Those are the extent of her options. Yeah. It's one of those two things. Yeah. Can a jury be declared hung this fast? In principle, sure. In this case, probably not. But there's no minimum time necessary for a hung jury. There's no line of demarcation. Right? So in principle, you could have a hung jury declared in 5 minutes. Although that would be one hell of a weird situation, but at least in principle, yeah, there's no hard and fast rules. It's all based on situation, so yeah. Can we not talk politics? We principally talk law, not politics. We are a legal education channel. If they said they can't decide, would the judge not just say you go back and deliberate further? Sure, she would give him a dynamite charge usually. They don't have to. Judges don't have to give a dynamite charge. Sometimes they don't, if they think the jury is deadlocked for other reasons or they think it's pointless. So there's, again, no hard and fast rules here. All right, it's all based on the situation. Yeah. Was a dynamite charge also called a deadlock instruction? Please try really, really hard. Jurors, have you considered trying harder? Yeah. That's a dynamite charge. Also called an Allen charge, it's called something Turi Rodriguez, I think, in this jurisdiction. Whatever, yeah. Please try harder. They did 2 dynamites in the last one. Well, not really. They did a soft version. Then they did the formal version. So depends how you count. But all she said was, "I'm sending you back." She didn't give the charge. So no. She didn't really give no. She just said, "I'm sending you back for further deliberation." That's all. And then the second time she gave the "please try harder" instruction. So yeah. What about nullification? What's your question? A nullification would be if a jury in their heart thinks one thing, but a verdict is the other way. So what about nullification? I don't understand.
We could have them deliberating for days. We don't know yet. We were talking, Vinny, about the fact that last time they deliberated 5 days before that mistrial, and today's day 2. What do you think if you were to read the tea leaves about if there's no verdict today, if they come back tomorrow, do you think the momentum is still going to be there building with all of these individuals outside of that courthouse?
Absolutely. I think the only thing that might change is the weather could scare a few away. If we get some rain, there's some slight rain in the forecast, and that's a real issue. I mean, it's the most beautiful day ever in Dedham, Massachusetts in the 60s.
Nullify the law. So in that situation, the jury thinks guilty but votes not guilty. So yeah, so they nullify the law they really think in their hearts not guilty, but they vote not guilty anyway, or they think guilty, but they vote not guilty anyway. Yeah, what about it? I mean, a jury could do that, but that doesn't really feel like the situation here. Why would the jury do that in this situation? That doesn't make any sense. If the jury, why would they think guilty but vote not guilty anyway? Why would they do that? That doesn't really make sense. So, yeah, I don't get it.
Breeze and a warm sun. School just let out. There are school children here with their parents, with their moms. What's interesting about the crowd is that you have some younger people. A lot of the younger people I've bumped into are streaming about this case. They're on social media. They're on TikTok. Then you've got a lot of folks who are, I want to call it like regular middle age kind of, right? Somewhere between, 35 to 60.
And strictly speaking, the way that the instructions are written in the state, them believing guilty but voting not guilty is following the instructions, which is interesting, because the judge said if you find that the state has not proven the case, you must find not guilty. But if you find the state has proven the case, you should find guilty. Right? So if they voted not guilty, they haven't actually broken the instructions, because it's the difference between must and should, right? So the judge isn't going to tell them that they can. They're not going to tell them explicitly, but it would be within this, it would be following the instructions. It's like you said, if I believe the state proven the case, I should find them guilty. I decided not to. So I followed the instruction. Yeah.
safety in that area, right? And those are the folks predominantly who were here. And you've got families as well, though. Some of them are moms of young children. The young children are here. School was out yesterday. So you've got a cross-section of people showing up in terms of...
I guess you can't tell them they must.
But I
think in some jurisdictions they say must. I think in some jurisdictions they say must. So it's interesting to me in this jurisdiction they say should.
We're getting word from the courtroom. I'll let you know, let our viewers know, that Judge Cannoni said that she will give this jury until 4:20 to deliberate, and then she will send them home, which is in about 10 minutes or so. That's Eastern time. It's currently about 4:10 Eastern time, so let them go to 4:20 before sending them home for the day. So wanted to let you know, wanted to let our viewers know. And I wanted to ask you this. You've commented a couple of times on your show about the age of the jury, them being relatively young, specifically as opposed to the previous trial. What effect do you think that'll have in terms of how long this will take? Again, we remember the other one took about 26 hours. Over 5 days. This doesn't have the same feel to me. I don't know. What are your thoughts on that?
I think there's a couple things at play here, right? I think younger jurors generally are more skeptical. I think they're more skeptical of people in power. And in this case, obviously, it would be the Commonwealth, it would be the prosecution, it would be the government. So I think there's that in play. I think younger people, things move a little quicker. I think that's a brilliant observation by you, Michael. I'm looking at this week. There's no court on Thursday. We always talk about the Friday factor. Well, this week there may be a Wednesday factor where things might speed up a little bit on Wednesday if we get there, right? This could still happen today. But if we get to Wednesday, I am approaching Wednesday like I usually approach a Friday during a verdict watch. Because they are off on Thursday. It is a holiday.
Vinny understands.
And
Vinny understands the Friday factor very well. Friday factor is real.
For the jury, if they're close,
the Friday factor is real.
To wrap it up in one way or another and send a note to the judge and let the judge know where they stand. We're not there yet, though. We got a long road to go to Wednesday afternoon. We still have to close out this day with either a verdict or sending everyone home. But as you said, we'll know within minutes what's happening today.
What is the Friday factor? Juries like to reach verdicts on Friday so they don't have to come back on Monday. Yeah, it is a well understood phenomena. It's like, yeah, there's a difference between deciding on a Thursday and coming back on a Friday. And not deciding on a Friday and I have to come back Monday. It's like I get 2 days off and then I have to come back again. I don't want to do that, right? So Friday factor is real. It's like, yeah, it's like, it's the weekend. I don't want to come back on Monday. Yeah, so a lot of Fridays, a lot of verdicts on Fridays. Yeah, there's a greater than expected amount of verdicts on Fridays. And so, yeah, this time Wednesday for the same reason. It's like, yeah.
Come back tomorrow. Who knows? Who knows if we've had cases, and you'll both probably remember them, where a jury kind of agrees and they want to sleep on it. That's why first thing in the morning, I'm always aware of what's going on, because you could have a very quick turnaround in the morning. We slept on it. How do we feel? And then a morning verdict is delivered. And I think we had that, I recall, in one of the Scott Peterson verdicts, where the jury reached the verdict, slept on it, and delivered it in the morning. But generally speaking, afternoon, I'm feeling like Wednesday. If we're not there tomorrow, I'm on super high alert on Wednesday.
Yeah. All right. Well, we've got about 8 more minutes before the judge says they go home for the day, come back tomorrow if there's no verdict. Vinny Politan, we're going to let you head out because of your excellent reporting. Thank you, of course, for being on with us. I know you're there all hours.
Listen, I'll be here. If something happens in the next 8 minutes, you come right back to me, because you'll see what's happening with these folks here if we get word, because word will spread very quickly if, in fact, a verdict is reached.
And we will see you put on your red tie on air. So we will be coming right back to you if that's the case. Vinny Politan, our lead anchor, thank you so much. We are going to take a break here. Of course, we'll get you back. That fan's inside the courtroom so you can see.
Vinny fan is spinning like crazy.
Right back after a quick.
Spinny fan is very
away line But you never know what's gonna stick to a juror and what they're gonna wonder about, because I think human nature wants us all to look at trying to figure something out, but also trying to look for something that, like, hey, what about this? You know, this, and I think that's one of those issues that could potentially be a problem for Karen Reed, and could be something that someone who wants to convict Karen Reed could look at and say, 28 minutes is a long time. Something else is going on here. I don't like it. It doesn't smell right. So we'll see what the jury does with it, but you are 1,000% correct. The way it was handled in the second trial, much different, much more under the radar. And I don't know, the jury's not allowed to take notes. Are they going to remember that?
And that was my point, the way it went under the radar. I'm not sure they will remember it. There are people with the theory that she did go by the house, which is one of the reasons why when she returned with Jen,
she knew where the body was.
She knew where the body was. That was the testimony.
That's what some people are saying. And of course, all three of us know you never know what a jury's going to do, what's going to stand out to them. I love your analogy of throwing spaghetti at a wall, because you just don't know what's going to stick. But Vinny, I must ask you, you were referring to biggest trials in the nation that you've covered. You've been there. I'd love to hear your impressions of this particular defendant, Karen Reed, because we know she has spoken to media. She's spoken to Matt Johnson, leaving that courthouse a number of times. She has said that she feels good, that she feels strong. We know the attorneys have a gag order, but she has shared some information on different days about what they're going to do, or who's going to be called, or how the testimony went. What's your impression
Things
of
are
this
happening.
particular criminal defendant?
Yep. Hold on. Do this orally.
You may be seated.
All right, jurors, we appreciate how hard you've worked today. It's been a long day. I'm going to send you home. So I do have to give you those cautions. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful with your social media use. And I think what's a good idea to do is when you leave here, just leave the case here. Literally, figuratively, just clear your heads. It's a beautiful day. Get some fresh air, and we'll see you tomorrow morning. Okay? Thank you.
All right, so the call me.
Well, guys, we are done for the day. 9 hours, no questions, no verdict. No questions, no verdict. We are done for the day. How did you guys like DVR being off, where you couldn't rewind the stream? I think it kind of was good because it made everyone.
So we'll see everybody tomorrow morning, okay?
Thank you.
All right, thank you.
All right.
I'm interested in what you guys thought, because it kind of made sure that everyone was, listening to and hearing the same thing at the same time, prevented anyone from, being like, behind or anything, because there's no way to be behind. So I'm curious what you thought. I thought it kind of was nice. You didn't like it? Personally, you hate it? Did you not like it? Horrible? Did not like? Did not notice? Did not like? Do a quick poll on it. Don't like either. Don't like it. Didn't notice? Okay, well, the consensus seems to be against. So I guess for tomorrow we'll leave the DVR on for tomorrow. Because it seems the consensus is against me. So that's fine. We'll leave it. I'll tell you what, I'll even turn it on right now for whatever value it is. Even though we're about to end the stream. I'll turn it back on. All right, there you go. It's back on for whatever difference it makes. Now you can rewind. Lol. It's annoying. All right, fair enough. Too late for today? Well, it's the thought that counts. It's the thought that counts. All right, fair enough. People didn't like it. Fair enough. I aim to please, so we will do DVR tomorrow. Ah, Lord. You guys are so demanding. Nah. I want DVR. Nah, I want the ability to rewatch what I missed. You guys are fine. All right, stream is set up for tomorrow. DVR is enabled for tomorrow. I'm not even sure if I remember to turn off ads today or not. Turn off ads for tomorrow. Redirect for today. Set up for today. Great. So we can end the stream. So is there anything left before we end the stream for the day? What time tomorrow? 8:30, same time I set it up for today. We might start a little early, depending, but give myself that extra half hour of sleep. So. Oh yes, 150,000. Right. We should do a merch giveaway tomorrow for 150,000. We should do a big merch giveaway for tomorrow. Well, I'll tell you what. How about we save it for the verdict? That way we can celebrate both. That seems like a good thing to do. So we'll do a merch giveaway for the 150,000 celebration when a verdict comes in. That seems like a reasonable thing to do. And then we can hopefully celebrate both, or we can commiserate. At least, she may have been found guilty, but at least you can make yourself feel better with some merch. So either way it works. Or I suppose for a hung jury, if they announce a hung jury, I suppose we can commiserate that there will be a trial 3, although the odds of yours truly covering trial 3 are not looking really high. I don't think I can do trial 3, guys. I don't think I have it in me to do trial 3. Will Bev be on trial 3? Presumably. Presumably she'll be on trial 3. Trial 3 happens just to recaps? Yeah, maybe. Although recaps are problematic because you kind of have to watch the thing in order to do a recap of it. So it doesn't really work to just do recaps because you have to watch it to do a recap. So unless I just do commentary on someone else's recap. Would Proctor have qualified immunity if sued? I don't know the answer to that question. That's a very specific question that I can't answer intelligently. I don't know. I don't know the answer to the question because qualified immunity can get very, very specific and very, very tricky. So I don't know. I don't know the answer. We might get trial 3 before GTA 6. Yep, that's great. Whenever GTA 6 comes out, I will be playing that on stream. I'm kind of looking forward to that. I might just do 8-hour gaming streams at that point because I'm kind of looking forward to GTA 6 like many people. So this might turn into a bit of a gaming channel for a while when GTA 6 comes out. Because it looks like it looks like a great game. So I'm here for it. I'm here for it. Have I played Red Dead Redemption 2? No, I played 1 but not 2. I've heard good things about 2. I probably should. What's considered a quick return for a verdict of trial this size? I'm not sure there's an intelligent answer to that question either. You know, I'm not sure what quick comprises of. Red Dead Redemption 2 is gorgeous. Fair. Fair. We could play some Red Dead Redemption 2 on stream while we're doing Verdict Watch. It's not the worst idea. I was thinking about, you know, playing Doom or something, but we could play Red Dead Redemption 2. How much is Red Dead Redemption 2 going for these days? Let's find out. $45? What do you mean Red Dead Redemption 2? What do you mean Red Dead Redemption 2 is in my library? Red Dead Redemption 2 is in my library? Apparently Red Dead Redemption 2 is in my library. Oh. I don't have to buy it. At some point I bought it already. Oh. Oh, okay. Well, that makes that easy. Apparently at some point in the past I bought it. Oh. All right. Oh, okay. So that's easy. All right. Well, I guess maybe we'll play that tomorrow. I'll go ahead and install it right now while we're waiting. Yeah, mysterious game appears. Yeah, mysterious game appears in your library. When did I buy that? I do story mode? Of course I'll do story mode. I've never played it before. I've got to play story mode. Never played it. What else would you do? What games do I have? Let's see what I've got in my library. That looks good. Well, we always play Crime Scene Cleaner again. That was pretty fun. We've got some Jackbox games for party games. Those are fun. Baba Is You logic games, although that breaks your brain after a while. Shapes 2, I could finish that. Stellaris, not really interested. We could do Chained Together or something. Binding of Isaac. Oxygen not included. Witcher 3, we could play Witcher 3 again. That was a great game. I really like that. We could play it again. Per Aspera. Apparently there's a major update. So we could try playing that game again. Let's see what else we got. Of course, there's always Dwarf Fortress or RimWorld. Command and Conquer Remastered, Witcher 2 and Witcher 1, which I've never played. So we could play Witcher 2 or Witcher 1. Maybe there's some sort of graphics update mod I could install or something, so it'd be less like ranky, but we could do that. That might be fun to play Witcher or Witcher 2. Maybe we should play Witcher or Witcher 2. I don't know. Hell Architect. Let's see what else we got. No Umbrellas Are Out Loud. I haven't played that since it came out. There hasn't been any updates on that game though, really, since it came out. So I don't know if I want to play that or not. It was kind of a fun game, but I don't know if I want to play it. It was a weird game. Planet Base, I beat the shit out of already. Surviving Mars, 60 seconds remastered. Mass Effects, we could play Mass Effect 1, 2, or 3. We've got Mass Effect we could play. That would take a long time. Bully, old game we could play. Civ 6, City Skylines, Doom Eternal. I got Doom and Doom Eternal, I think. Phoenix Wright, we are not playing that because I'd rather kill myself. Fallout New Vegas, Far Cry 4, Far Cry 5. Let's see what else we got. Fallout and Fallout 3. I think I've got Fallout Tactics and Fallout 2 and Fallout 4 I've got. So I've got basically all the Fallout games we could play. Roller Coaster Tycoon, Mortal Kombat 10. What else we got? That looks good. Hitman Absolution we could replay. That's fun. Or Hitman 2, or Hitman Codename 47. We could play. Blade Symphony. What else we got? Hitman Blood Money, Portal and Portal 2. In honor of Aperture, we could play Portal or Portal 2. That could be fun. Let's see what else is good. Batman Arkham Asylum. Never really played that, but I've got Game of the Year edition, so we could play that for the first time. Let's see. Game of Thrones. I've never played that. I don't know if it's any good. Batman Arkham Asylum or Arkham City and Game of the Year edition. Those are all the games basically I have. Far Cry 5 was good. The ending was very, very unsatisfying to Far Cry 5. Very unsatisfying. Far Cry 4 is a better game. It was a much more satisfying ending, at least. Take a poll. I can only put 4 options in a poll, so that would be difficult. Do I use Epic Stream EAA? Do I mean Epic Loader, you mean? I have Epic Loader. Yeah, I think I've got some games on there, but I don't usually use it. Yeah, I don't have Far Cry 6. I heard it was kind of shit. So I never bought Far Cry 6. Pick 4 games I want to play and see what games you like. That's fair. All right, let's try that. Let's run a poll. All right. Which game should I play on stream? All right. So let's do, let's see. Red Dead Redemption 2 can be one of them. What else looks good on that list? Witcher, maybe Witcher 1 or 2. I'll do as kind of a combination. Presumably Witcher 1, because that makes sense to play that first. And then I have to see if there's like any sort of graphics patch or something that we could install so it like isn't so jank, but we could do Witcher 1. That could be fun. Let's see. What else looks good? We could play Portal. It's been a while since I played Portal or Portal 2. Portal 2 takes a long time to play. Much longer game than Portal 1, but we could maybe do that. Maybe I should put that on the list. Batman. Does anyone else have any strong favorites that they want for this game, for this poll? Portal or Portal 2? Put Portal 2 on there. Mod should count twice. Not sure about that. We could play Mafia 2. That's cool. Old game. So fun. Batman Arkham City or Batman Arkham Asylum? The new Mafia game is coming out soon. That sounds cool. Yeah, let's just run these 3 options and see which one of these you want. Let's just run it with these 3 options and see which one you guys of these 3. Witcher 2 is the best of the series? Well, I've never played Witcher 1, so it kind of makes sense to like go back and sort of play Witcher 1. Witcher 3 was a hella fun game. I really enjoyed Witcher 3. So like it was one of my favorite games. It was really good. I really liked it a lot. At least it's Witcher Enhanced Edition. So presumably that's with like not shit graphics. Red Dead Redemption seems to be winning the poll though. I'm thinking you guys are thinking Red Dead Redemption 2 for tomorrow. All right. I'm amending the title of tomorrow. All right, cool. We're going to have a gaming stream tomorrow and Verdict Watch. That'll be fun. I'll enjoy that. 330 viewers? Yikes. Yeah, Witcher 3, but Witcher 2 told you to love the series. Do you think I should just skip Witcher? Do you think I should skip Witcher 1 and just go to Witcher 2? Do you think that makes sense? I mean, what makes sense to you? You can tell me. Do you think it makes sense to skip Witcher 1 and just go straight to Witcher 2? Witcher 1 is a different game. I'd start with 2. Okay, fair enough. All right, maybe Witcher 2 then we can play if we beat Red Dead Redemption, depending on how long the game takes. Am I sure I don't want to watch the Ronnie interview again? I don't know. We could definitely watch it some more. Maybe it gets less stupid. You never know. Maybe Ronnie is just slow in the first half. Maybe in the second half he really comes through for everybody. We owe him an apology. Maybe that's what happened. No more. Yeah. He was annoying. Yeah. All right, I think Red Dead Redemption 2 it is. Let's get the game just loaded and started to make sure that we get the. Let's just do a rest of this. It's still downloading. Damn, it's only 30% downloaded. How long does this game take to download? I'm downloading at half a gig a second. How long does this game take to download? Shit. I'm downloading at 500 megabits. How long does this take to download? God damn. And also, why am I only downloading at 500 megabits? But still, it's a huge game. Apparently it is. Shit. Am I going to explain what Red Dead is about? Nope. It's about living in the Old West and shooting bad guys. I enjoyed Red Dead Redemption 1. Red Dead Redemption was a cool game. It's slower while I'm streaming. It shouldn't be that much slower. I have plenty of bandwidth. And besides, it's the difference between uploading and downloading. So I should have plenty of bandwidth, but, you know, whatever. Right now I'm streaming at 5,000 kilobits, which is actually 5,000 kilobits per second. So actually I'm up, my upstream is only 5,500 kilobits, which is not that much. I mean, in terms of bandwidth, 5,500 kilobits is it's 5 megabits, to be honest. So that's, 5 megabits is a fair amount. 5.5 megabits is, I guess, fair amount. So I'm upstreaming at 5.5 megabits and downstreaming at 470 megabits. But I've got fiber. I've got 100 gigabits. So I should, yeah. Am I multi-streaming today? I am. It's been much better today than last week. Well, what the difference is I'm streaming in OBS instead of browser. That's the difference. I still am multi-streaming, but I'm streaming in OBS. And OBS is a lot better quality than the interface. Right? So yeah. So plus by streaming from OBS, I can stream at 1080. Whereas if you stream inside the browser, you can only stream at 720. Plus, so you get a lot more bandwidth. Red Dead Redemption's 110 gigabits. If it's 110 gigabits, then yeah, how much crazy it makes a difference. Yeah, isn't it? Yeah, because you can stream natively. It's a lot better. Yeah. And plus I'm streaming a lot more data. I don't know how much data I'm streaming with the browser extension, but it's I know how much data I'm streaming with. With this, I'm streaming 5.5 megabits. That's a fair amount of data. It's actually probably more data than I need, to be honest. But why not? All right, guys. Well, I guess I'm going to go ahead and sign off for now, and I will see you bright and early tomorrow. That sounds fun. And we'll play some games. I will see you tomorrow. Oh, is there someone I can redirect you to? Because that's always a nice thing to do. I'm not sure if it makes any difference at this point because I don't have that. Well, actually, I have to redirect to myself for the stream for tomorrow. So never mind. I'll redirect to myself. Like the stream for tomorrow, and I'll see you guys tomorrow. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.